Civil rights and protected classes, the bills before the Joint Committee on Judiciary. We're officially called to order. I am Chair Edwards, and I am joined today by my co-chair, Representative Michael Day. This hearing is the 14th official convening of the Joint Committee on the Judiciary for the 194th legislative session. Joining us today from the committee, and they'll likely join us remotely, those Senators Pat Jalen, Senator Liz Miranda, and Senator Patrick O'Connor. Senator Vilas is currently on orders serving our country. At this point, I'm going to turn the mic over to Representative Day, who will introduce the House members.
Thank you, Madam Chair. Good morning, everyone. To my right, your left, down the end is Representative Mendez. To my far left, Representative Higgins. To her right, Representative Moakley. To his right, Representative Kilcoyne. And to my left is Committee Counsel Robert D'Alessandro. Thank you.
So committee staff will be present in the hall for anyone who did not previously sign up but wishes to testify. And I want to thank everyone who did sign up and testify by 5 p.m. on November 23rd. The committee looks forward to hearing your expertise and personal experiences as we consider bills before us on immigration, civil rights, and protected classes. Here's just some few housekeeping notes before we begin. The time will be projected on the screen above us, and an alarm will notify you when your time is up. The committee will have the opportunity to ask each presenter questions at the conclusion of their testimony. We have about 140 people signed up to testify, and that's signed up to testify, not including folks who have decided that they want to testify or could be coming from the other hearing that I know Safe Communities is on today, who may come in and testify as well. So I will be very strict with the 2 minutes. I will be very strict. And please note, you can submit the rest of your testimony in writing to the committee. To ensure everyone has a fair opportunity to be heard, I will remind participants of our time limits, which will be strictly enforced. Individuals will have 2 minutes for their testimony, which with a maximum of 5 minutes for panels for the group. Please be mindful of these limits so that we may hear from as many voices as possible. Those who have signed up to speak on multiple bills will still have no more than 2 minutes. So once your name is called, speak on all of the bills that you are considering or in favor or opposing. You have, before I'm going to call anyone up again to speak on something, I will prefer that you go once and speak on all of your bills. Testifiers who require an interpreter. We understand that there are some people here who do not speak English as a first language who may need additional assistance. You too will have 2 full minutes to speak in your language or in the language that is most comfortable for you. You have 2 minutes. Again, please do not read your testimony, just speak. Your interpreter will then have an additional 1 minute to summarize what you said for the record. So this is not taking from your 2 minutes. Everybody still has 2 minutes to speak, but some people do not speak English as a first language. So they will have an interpreter who will summarize what they said. Okay? The chair has reserved the right to call public officials out of turn. Additionally, I want to note that public officials who intend to testify on a panel will not be taken out of turn. As such, to my colleagues who are elected officials who would like to speak out of turn, we will call you up as an individual. You will not bring people with you to testify and come out of line on a different bill. Okay? So it's just going to be the individual elected official. Those, again, who did not RSVP to testify may be given a chance to speak at the end of the hearing after all the scheduled testimony is complete. After my list is done, I will make a general call out. Is there anybody else here who would like to testify? But you still may sign up so that my staff and I have your name on a list so I can just go through that list as well. Please note that the committee will continue to accept written testimony which may be submitted by mail to the Joint Committee on the Judiciary at 24 Beacon Street, room 136, Boston, Massachusetts 02133, or to Christiana Golden, CHRISTIANNA.GOLDEN at masenate.gov for Senate bills, or Talia Quinn, that's TALIA.QUINN at mahouse.gov for House bills. All written testimony received by the committee will be made publicly available. Provided, however, the chairs may limit and redact testimony that includes sensitive personal information or information that may jeopardize the health, wellness, or safety of the testifiers or others. Today's testimony may touch on subject matter that is deeply personal and for many painful. I want to acknowledge the courage that it takes to speak publicly about difficult experiences, and I ask that everyone in this room, whether you're offering testimony, listening, or asking questions, to please approach today's discussion with respect, compassion, and care. With that being said, we do not allow signs. We do not allow signs while you're testifying, in the room. Also, no clapping, please, no booing, if that does happen, because I do realize that some of these issues could cause a lot of tension. If you do that, I'll give you a warning, and then I'll promptly ask you to leave. Included in the noise making are snaps. Please do not do that either. Again, while many of, I know it's a goal to express support, to encourage people who may be for the first time testifying publicly, and to encourage your person or your group or this individual to feel safe, to feel supported. I understand it may be coming from a good space. It may not be received that way by somebody else. So I simply ask, for the record, speak your truth, and everyone be respectful. With that, I again thank you for your patience and your presence and your commitment to justice, and I look forward to a productive, respectful hearing. Right? Anything else that you want to introduce? Yeah.
Also like to recognize and welcome Representative Ramos, who's joined us.
Okay. We shall begin. We're going to begin with Attorney General Andrea Joy Campbell.
Rep Day, Senator. I was listening.
I know you were following the rules, but they're not
Okay.
panels.
They work in the building. Good to see you.
You may begin.
Good morning, everyone, and thank you, Chair Edwards, Chair Day, and of course the members of the entire committee and your staff. We know you don't do this by yourself. And because this is the week of Thanksgiving and gratitude, I want to thank this entire committee on behalf of my entire office for the work we've done in collaboration together. I am extremely grateful to each of you. This morning, in particular, I'm here to testify with respect to my support and strong support of S1126 and H1920, an act relative to combating hate in the Commonwealth, which I filed with Senator Gomez and Representative Tram Nguyen. I am also joined by Liz Matos, who's the chief of our Civil Rights Division, who is to my left, and John Burke, who is the managing attorney of our Civil Rights Division, who is to my right. From the targeting of our immigrant, Jewish, and Muslim residents to the harassment of transgender and LGBTQ+ communities, episodes of hate have been on the rise, including an escalation of hate and bias incidents in our schools, on our streets, and at our workplaces. As your Attorney General and the Chief Law Enforcement Officer of the Commonwealth, I'm here to tell you that Massachusetts, of course, will not tolerate any type of hate or bias in our communities. Every incident undermines our residents' dignity, respect, and humanity, and of course, not just for those involved, every single resident of the Commonwealth. And it is imperative that we take action to strengthen our laws and improve the tools available to combat hate and protect our residents. closing loopholes in our civil rights laws, and strengthening our enforcement tools, particularly at a time when the federal government is all but abandoning civil rights enforcement, will allow us to maximize our effectiveness in addressing these incidents of hate and bias and step into the void left by the federal government. Thank you again for the time today to testify and, of course, the opportunity. I would now like to turn it over to Liz, who will provide an additional detail with respect to the bill and the work of our Civil Rights Division, just for a couple of minutes. Thank you.
Thank you, Attorney General. My name is Elizabeth Matos, and I'm Chief of our Civil Rights Division. The Civil Rights Division responds to violations of state and federal laws prohibiting discrimination in various contexts, public education, employment, housing, financial services, public accommodations, for example. Additionally, we enforce the Massachusetts Civil Rights Act to address acts of bias. Our mandate is very broad, and recent acts at the federal level have escalated the urgency of our work. Despite the breadth of civil rights laws that we enforce, our investigative tools are actually quite limited. And under current law, subpoenas must be tied to a criminal violation or a consumer act or practice that is unfair and deceptive. This means that the Civil Rights Division does not have the authority to subpoena documents and acquire information to investigate most hate and bias incidents, including incidents involving organized hate groups. This legislation would address this gap and prioritize civil rights enforcement by providing civil investigative demand authority or subpoena power. Sorry?
I just want to make sure that it wasn't us.
Oh.
We're good? Okay. Go ahead.
No, it's okay.
We're good.
I can back up. So the legislation would address this gap and prioritize civil rights enforcement by providing civil investigative demand authority or subpoena power to the division. This is actually a tool that the federal government has in various civil rights enforcement contexts, but that we lack. Such limitations on our investigatory abilities do a disservice to the Commonwealth, of course. Providing the division with similar enforcement authority as other civil rights areas like consumer protection will enable us to more comprehensively and effectively combat acts of hate. It would also allow us to investigate additional incidents of hate and bias and would ensure that our state laws are more robust and protect and enforce civil rights at a time that is very sorely needed. This legislation would also address a number of other loopholes in the Massachusetts Civil Rights Act and expand the scope of injunctive relief. It would also add protected classes to the state's hate crimes law, which are right now missing. Lastly, the bill would require mandatory reporting of hate crime data from local law enforcement and ensure that the data is more thorough and up to date so that we can better predict and prevent future incidents. I appreciate the opportunity to testify today and to be happy to answer any questions you may have.
Thank you all. We're happy to answer any questions you may have. Appreciate all of you.
Thank you. Are there any questions?
Sure.
Go ahead.
Thank you, Attorney General.
Thank you.
And your team as well. Counsel, just a question. You've got the power on criminal investigations, right? This would extend it to a civil investigation without criminal?
Right.
Thank you.
That's it.
Okay.
Thank
You all very much. Happy holidays to you and your families. Thank you.
Thank you.
Oh, yeah.
Representative Hong? On an act ensuring access to equitable representation in immigration proceedings.
There's a lot of people today.
I'm gonna wait for the door to close. You can all hear how loud it is when the door is open, so I would hope that we move in and out as soon as possible and then close the door. Thank you.
Sounds good. Thank you. Good morning, Madam Chair, Mr. Chair, Vice Chair, and District Member of the Joint Committee on Judiciary. I'm here today in strong support of H. 1954, an act ensuring access to equitable representation in immigration process. Before I begin, I would like to extend sincere thanks to Senator Gomez and Representative Roger of Cambridge, Moran of Lauren, for filing this important legislation, for their leadership and standing up for immigrant refugee family across the Commonwealth. Access to legal representation can be a difference between safety and separation, stability and uncertainty in community like mine, where many family, including family, refugee, and hardworking low-income household, navigating in a conflict immigration system is more than just a legal challenge. It is directly affect housing stability, family unity, employment, education, and full participation in civic life. I have witnessed firsthand how a lack of proper legal counsel can leave individual and family vulnerable, marginalized, and unable to advocate effectively for themselves. This bill is especially important to my work and the work of the committee because it reinforced the fundamental principle that justice should not depend on one income or immigration status. By ensuring access to counsel for eligible immigrant facing removable process, H. 1954, strengthen due process, promote fairness in our legal system, and uphold the value of dignity and equality in the Massachusetts stand for. For our immigrant community, this legislation offers hope, protection, and opportunity to live without constant fear of being separated from loved one. It supports healthier families, stronger neighborhood, and more resilient community throughout the Commonwealth. I respectfully urge the committee to give this bill a fair report. I also want to show my support to H. 4684, an act to ensure law enforcement identification and public trust. Thank you for your time and your leadership for this committee. Thank you very much.
Thank you. Thank you, Representative. Any questions? Seeing none, thank you. Online, we have Representative Sally Karen.
Good morning.
Good morning.
Thank you very much, Madam Chair, for taking me out of turn. Thank you to the members of the Committee on the Judiciary. I am greatly encouraged when I see the makeup of a committee dedicated to these very crucial issues, so I thank you. I'm here very briefly on a perhaps not as weighty bill as some you will hear about today, but nonetheless valuable and important. And I'm referring to House 1927, filed by my terrific colleague from Watertown and Cambridge. And this is legislation to exonerate the women of Boston who were accused, tried, I use that term very loosely, and convicted and put to death in the witchcraft episode, a dark and tragic episode in our history. I represent Danvers. Danvers was Salem Village. So to grow up in Danvers is to hear from the time of third grade about what happened to Rebecca Nurse. And you'll hear today from a delightful guy in my town, Dan Gagnon, who's written a book about Rebecca Nurse. And what's different is that he focuses as well on the exoneration of Rebecca Nurse. The saying, it's never too late to do what is right, applies to a situation exactly like this. I'm very grateful to the group working to elevate the experiences beyond Salem Village. We all hear about Salem Village. This now extends to Boston, including these 5 women. I thank the committee for hearing it. I thank Steve Owens for filing it. And I thank everyone who works to keep this history alive and so that we are mindful that we don't want to repeat it. Thank you very much.
Thank you, Representative. Any questions? We have here Representative Jim Hawkins.
Thank Thank you, Chair Edwards, and thank you, Chair Day, for taking me out of order. And yes, I can have the bill number in front of me. It's H4684, and it has to do with ICE agents wearing masks. It's become quite simple since I filed it what the discussion is around this. Simply everybody in this Commonwealth that's detaining people should be held to the same standards. ICE agents should be held to the same standards as our police and other law enforcement agents and officers in this community. There are exceptions in the bill for dangerous situations. Exceptions would include a face mask if it's like a domestic violence type situation where there's a threat of physical violence. It would include a face mask if it's a meth lab type situation where there's a danger of breathing in dangerous chemicals. All of these things are accepted. And even if for a police officer who's out doing a duty in sub-zero weather wearing a face mask to stay warm. But the fact remains that the ICE agents are not primarily detaining in dangerous situations. By their own records, the vast majority of the people who are detained have no criminal record. So this is not necessary. The question that might have come up is on constitutionality of this, where we're a state agency and they're federal agents. But this law that this was based on was just passed in California. So clearly there's some precedent to doing this between states and the federal government. And we, in fact, have a history of doing things that aren't in agreement with the federal government, including selling marijuana and a lot of the bills that have passed before us for reproductive rights, Fair Share Act, things like that, were at one point considered unconstitutional. So I don't feel that that's relevant here to this. Thank you.
Any questions? Seeing none, thank you
That
very
was
much.
easy. Thank you.
Yeah. Anybody else online? Very nice. Okay. All right, seeing there were some other folks, but I don't see anybody here, any other elected. So we're going to go on to start our public testimony on bills. S1175, an act prohibiting injurious operations or offering services or products that discriminate against or injure protected classes. We have Cece Doucette. Cecilia here. We will come back to her. We're moving on to S1056 H1589, an act to amend the definition of a hate crime. We have a panel with Mikey Jones. Okay. Come back to that. S1248. No, okay.
You said Mickey Jones, correct?
Yes.
No, record for House Bill 1980.
Okay. Well, we'll call that. Okay. We'll call that. S1248, an act codifying organizational standing to protect and promote civil rights. We have the first panel, which is Maureen St. Cyr and Christina da Fonseca. Are they virtual? Are they online?
Yes, we are.
Okay, great.
Good morning. Thank you for the opportunity to testify here today before you in support of S1248. My name is Maureen St. Cyr. I am the Executive Director of the Massachusetts Fair Housing Center. We are one of the 4 organizations in Massachusetts that investigate claims of housing discrimination, provide legal assistance, and provide community education and outreach about residents' rights under state and federal laws prohibiting housing discrimination. Notably, we also investigate discriminatory housing practices and bring housing discrimination complaints in our own name to end those practices when our investigations show evidence that there's ongoing or systemic discrimination. This enables us to open up housing to ensure that residents in our communities do not face unlawful barriers when they are seeking to obtain the housing of their choice. More than 40 years ago, this practice of organizational complaints and organizational standing was affirmed by the U.S. Supreme Court in Havens Realty versus Coleman, which held that fair housing nonprofits have standing to bring lawsuits in their own name when they face injury to their mission and resources as a result of unlawful housing discrimination. Since that decision in 1982, courts and administrative agencies in Massachusetts have also recognized the legitimacy of this practice, including Massachusetts Federal District Court and the NCAD, which is tasked with interpreting Chapter 151B, our state anti-discrimination statute. But like other principles of civil rights, organizational standing is under attack on the federal level. We've seen challenges to organizational standing in the U.S. Supreme Court and in federal courts in other states, and in the housing court here in Massachusetts under 151B. This bill would codify and confirm what our longstanding practice of organizational standing has been, and reaffirm this longstanding civil rights law to protect the ability of nonprofit organizations like Mass Fair Housing to bring complaints in our own name to enforce state anti-discrimination law. Thank you for your time and consideration, and I ask that you positively report out this bill.
Thank you. Christina Dafonseca, did you?
Yes.
Okay.
My name is Christina Dafonseca. I'm Executive Director of South Coast Fair Housing, serving Bristol and Plymouth counties and Cape Cod and the Islands. I also am testifying in support of Senate Bill 1248. I and others founded South Coast Fair Housing 13 years ago to address systemic and persistent housing discrimination across southeastern Massachusetts. While our work includes educating the public about fair housing and providing direct legal assistance to those experiencing housing discrimination, it is the pursuit of fair housing claims in the name of our organization that is what helps take the burden of combating housing discrimination off of individuals and families. Our work helps to eliminate discriminatory barriers to housing. For example, if we find discrimination against families with children because of lead paint, we will seek lead abatement so that lead paint is no longer a motivating factor for discrimination at that property. Because of this work, specifically because of our organizational standing to pursue discrimination claims, we've helped make apartments in southeastern Massachusetts lead safe, and those homes are now not only open to families with children, but they're also safer for them. Families facing discrimination due to lead paint discrimination or other forms of housing discrimination would be far less likely to have legal redress available if organizations like ours cannot pursue these claims. These claims would be left to be litigated by the individual, forcing them to take on the legal and time costs themselves, which is difficult for many, particularly those experiencing housing instability. So I ask that you positively report out Senate Bill 1248 and help protect this core part of our fair housing work. Thank you for your time.
Thank you so much for your testimony. Any questions? Seeing none? Okay. S1246, an act to add sex and gender as protected classes for crime prosecutions. We have up first a panel. Wendy Murphy and Allison Shea.
Before you start the clock, I was a panel. My co-panelist couldn't make it this morning. Do I have 2.5 or 2? Because I can talk quickly.
2 minutes.
Okay. I'm here to support a bill to add women to the Massachusetts Hate Crime Statute 265, Section 39. Massachusetts is the only state in New England that does not protect women in its hate crime law. Not surprisingly, then, according to the SJC in its Bellard decision 2024, domestic abuse is the most prevalent crime in nearly every district court and community across Massachusetts. This makes sense because studies show that when a class of people is excluded from a hate crime law, that class suffers higher rates of violence and abuse. In the last 10 weeks of 2023, 8 women were killed by men, making Massachusetts the deadliest state in the nation for women during that time period. But not one person on Beacon Hill spoke out because our law does not recognize the targeting of women as a hate crime. If I beat the hell out of you because you're Irish or gay, it's a hate crime, but if I do exactly the same thing to you because you are female, it is not. This is outrageous, then the message is clear. Violence against women is less bad compared to violence against other people. Notably, the federal hate crime law does protect women, which means the national government, led by Donald Trump, does a better job protecting women from violence than does Massachusetts, a state led by Maura Healey. Is that not reason enough to fix the law? Without this Senate bill, we have an absurdity in the law because Chapter 22C requires police to count hate crimes against women, but police chiefs tell me they don't comply with 22C because why would they measure something they can't prosecute? My answer is because that's the law. But they've been told to disregard 22C until women are added to Section 39. That's a lawsuit waiting to happen because the Massachusetts Constitution forbids discrimination against women, including by this body, and it's subject to strict scrutiny review, yet here we are talking about a law that does exactly that. If you don't fix it, I will. I brought with me today a copy of a lawsuit I will file if you don't fix it. Women have waited long enough for equal treatment and equal protection of all laws in the Commonwealth. Thank you.
Thank you. Any questions? Okay.
Thank you.
H1820, an act providing increased protections from harassment and discrimination on the basis of height. We have virtually, is there Brandy Solove online? Brandy, when you're ready. Brandy, about a couple more seconds. Oh, there we go.
Hi, sorry everyone, having an issue unmuting. I'm a California attorney, Brandy Solove. I'm honored to be here today to provide expert testimony. I am the legal director of the Independent Living Resource Center in San Francisco. Because so many people face weight discrimination, I also run a pro bono project called Fat Legal Advocacy Rights and Education Project, also known as FLARE. Discrimination based on weight happens in all aspects of a person's life. Kids are bullied in schools. They may not be able to find school uniforms that fit them. They literally don't fit in. As teenagers, they may be denied a spot on the cheer or dance team. In college, they may not fit into school desks. They may have a hard time socializing because public venues like theaters and stadiums also may not have chairs that fit them. Fat adults have more limited job opportunities because we don't look the part. Even thin people face weight discrimination face weight discrimination, like a very muscular graduate hoping to become a police officer, but he was over the weight limit because of his bodybuilding. Fat people also face housing discrimination, possibly being denied because of their weight, or even charged higher prices. They face hostility by landlords who have stereotypes. The worst and most common cases of fat people who face discrimination because of are people that have a combination of face discrimination based on a combination of weight and their race. Black and brown people are disproportionately impacted by weight discrimination. This also unfairly impacts many other groups like transgendered people who are denied medical care like gender affirming surgeries due to weight bias. Laws that protect fat people don't cost that much money. And they make it very clear on what people's rights and responsibilities are. Some fat people are protected under disability law, but it is not clear who and when. Adding height and weight protections make it obvious that this discrimination is not allowed. Now is the time to make a difference. Thank you.
Thank you very much. Is there any questions? Thank you. Okay. I just want to announce that Senator O'Connor on the committee has joined us virtually. And as I announced earlier, we will be calling electeds out of order. So District Attorney Marion Ryan and Representative Souza.
Thank you so much to the chairs and members of the community. Thanks for taking us out of order. My name is Priscilla Souza, and I'm honored today to appear with District Attorney Marion Ryan to support H. 1995, an act regularizing sentencing for hate crimes. I come before you because I believe the Commonwealth has a responsibility to ensure that hate-motivated misconduct is addressed fairly, transparently, and consistently through our criminal justice system. As the bill's co-filing sponsor with DA Ryan, we are seeking to refine and strengthen our laws so that they reflect both the seriousness of bias-motivated harm, now more than ever, and the needs of our communities, again, now more than ever. Currently, Massachusetts law provides two primary statutes addressing bias motivated for civil rights motivated crimes. However, as the summary of the bill reveals, there is inconsistency. Persons receiving a continuance without a finding, a QOF, under Section 35 are not uniformly subject to the same post-determination program requirement as those convicted. H. 1995 seeks to correct that by amending Section 37 and 39 of Chapter 265 so that individuals convicted of a granted continuance without a finding will be required, unless good cause is shown in written findings, to complete diversity awareness training approved by the trial court. In doing so, the bill advances two core objectives: regularizing sentence, ensuring that identical or equivalent treatment is given to offenders of those actions whose actions involve bias, regardless of whether the resolution was a conviction or a QOF. Two, promoting accountability and education. By requiring a diversity awareness program, the bill emphasizes that bias-motivated conduct is not simply a quote-unquote normal crime, but one that impacts safety, dignity, and the sense of belonging of targeted communities. And I cannot stress this enough, now more than ever. From the perspective of victims and the broader community, messages matter. And I'll submit the rest in writing.
Thank you. Good morning, Madam Chair, Mr. Chair. I'm happy to be here with Representative Souza on House Bill 1995. It really does two things. It permits us to resolve these cases without necessarily giving someone a criminal record, particularly for young offenders. But at the same time, it does require that they engage in the education program. I think that what really changes people in terms of these hate-motivated crimes is education. And having to share time and speak with people who are different, to be educated about the impact of what they have done, is what we really see and hear from offenders is what changes their behavior. Right now, we cannot require them to do this education program unless they get a guilty finding. So this would give us that flexibility, and it would also give the judge flexibility. If a judge really feels it's not warranted, they can opt out of that. The second bill I'm here on today is Senate Bill 1056 and House Bill 1589. These both address what I'm sure were oversights in the original hate crime bill. The first is that right now, in order to be a victim, if your property is in some way damaged as a hate crime, you must be the owner of that property. So clearly, if you are a tenant and your property is damaged, you don't qualify to be a victim. For us in Middlesex County, we have 21 colleges and universities. Students obviously don't own their dorm room or other property. They cannot be a victim in those cases. And the second piece of that legislation would require that when there is restitution ordered to someone, that restitution must be used to ameliorate the harm. Right now, there's no control on that. So even if the landlord agrees to be the victim, the landlord is the victim, the defendant is convicted, restitution is ordered, there's no requirement that the landlord use that money to ameliorate whatever happened. This is particularly true, for instance, with public buildings. So we've had a number of incidents where really hateful things might be written on a public building that faces someone's home, Restitution's ordered. The town cannot be ordered to use that money to paint over or repair the damage to the building. So I think these both address real oversights, but also make the bill much more effective. I'd be happy to take any questions.
Any questions? Seeing none, thank you so much.
Thank you, and thank you for taking us out of order.
Thank you. Moving on to public testimony. H1886, an act relative to privileged communications. Carrie Burke.
Good morning, co-chairs, and thank you, committee, for having us here today. My name is Carrie Burke. I'm the Director of Social Services Advocacy for the Public Defender Division at CPCS, and I'm here to support House Bill 1886. CPCS is committed to providing holistic representation, work that aims not only for strong legal outcomes, but also positive life outcomes for our clients. Our social service advocates are central to this mission. As part of the defense team, we identify the life circumstances, barriers, and unmet needs that may have contributed to systems involvement, connect clients with supports to move forward, and provide written advocacy that helps judges and prosecutors understand our clients as whole people with complex histories and future goals. Our interdisciplinary model works only because social service professionals, like attorneys, operate under attorney-client privilege. Outside of this setting, we would be mandated reporters, but within the defense team, we must be trusted with the client's full story. Without that trust, our relationship and the attorney-client privilege breaks down. Breaching privilege through reporting would undermine the defense, and we could even result in disciplinary action against counsel. Although we recognize that our work is protected by privilege, the mandated reporter statute does not clearly reflect this. That silence creates confusion and places staff and contractors in the untenable position of choosing between upholding constitutional privilege and risking professional or criminal penalties. Other jurisdictions, including New Mexico, Colorado, Louisiana, and Washington, D.C., have resolved this gap by explicitly accepting defense-based social workers from mandated reporting laws. Massachusetts should do the same. Clarifying that statute would eliminate unnecessary fear and uncertainty and allow us to continue providing holistic representation with confidence that we are protecting our clients' constitutional right to privileged communication and the integrity of their legal defense. I respectfully ask you to report House Bill 1886 favorably out of committee, and thank you very much.
Thank you so much. Were there any questions? Seeing none, thank you. H1889 S1064, an act to eliminate disparate impact. First panel, Brianne Frank, Craig Diaz, and John Walkie. This will be a, it's, do you have 3 people in your panel?
See Brianne, so I guess it's just the 2 of us.
All right, we'll
and
give
then
you
there's another panel coming up that'll take on
Perfect.
more of this.
All right, we'll give you each 2 minutes then.
Okay. Good morning, Chair Edwards, Chair Day, and members of the committee. Thank you for this opportunity to address you. My name is John Walkie. I'm the Director of Climate Justice at Green Roots, here to speak in support of S1064 H1889, Act to Eliminate Disparate Impacts. Over the past 20 years, I've been an environmental activist in Greater Boston area, in particular neighborhood of East Boston. And for folks in this community, especially the environmental justice community, we spend a lot of time talking about systemic racism, systemic discrimination. And what we're really addressing are looking at the impacts of our policies, these systems, to address how we get to these outcomes. From an EJ perspective, it usually means looking at the outcomes of permitting processes and trying to suss out why certain communities, certain groups of people are always getting the less desirable end of the stick, whether it be trash transfer stations, polluting power plants, or other infrastructure that provides critical benefits for a region, but very targeted burdens to specific communities. And in East Boston specifically, in the past few years, as you know, Chair, we've twice pursued Title VI complaints with our federal agencies, and the process has been less than effective. even under receptive administrations. Both of those instances involve a lack of language access policies or poorly implemented policies that effectively shut out members of the East Boston community from public processes that greatly affected their quality of life. For some time, we've been trying to come up with something better at the state level, and now at this critical point in time, the need for this is greater than ever. The current administration in Washington, as people here know better than I, is dismantling so much of what so many have worked over generations to get in place. Civil rights, clean water and air protections, and basic rule of law are in question to a degree we've never seen in our lifetimes. And relative to the community members with whom I directly work with, the immigrant community, obviously the situation is really bad. So I'm not here to get into the details of the bill, as I'm not a lawyer, but just to call on all of you to step up at this moment in time to form a front here in Massachusetts against what's happening in Washington. The Commonwealth has been a leader on civil rights for 250 years. We can continue playing that role by favorably reporting out this bill this session.
Thank you. So normally for a panel, we have about 5 minutes. And so if you want to put 3 minutes up on the clock, and then between the two of you that's left, and we go ahead and do that.
Hello, my name is Brianne Frank, and I am a volunteer lawyer with Alternatives for Community and Environment. I have been helping to represent Situate Concerned Citizens and the Diaz family in a federal disparate impact claim. This action has been rendered essentially defunct by the Trump administration. Craig Diaz is here today to share his experience with the disparate treatment of 2 landfills in his town in support of this bill. I cede the rest of my time to Craig.
Thank you for having me. Very nervous, but in 1927, my uncle had purchased a piece of property in Situate, and he was trying to pass it on for generational wealth to us. In 1934, this town of Situate decided to put a town dump right beside our land. We happened to be the only Cape Verdean neighborhood, and this was a convenient place to put a dump. In 1976, they promised us that they were going to clean the dump, and they were going to cap it, and they were going to take the necessary steps to do the right thing by the community. In 1986, they had some other problems that took place. And 5 years ago, we decided to reach out to the town to put parks and sidewalks in our community, because we were the only part of the community, this wealthy community, that didn't have this. And we put our issues on Facebook, and we got a lot of good feedback. People wanted to do this. But one lady wrote us back and said, no, you don't want to do this, because in 1986, the property that you're looking at was contaminated, and you need to look into this. So we started looking into it, and come to find out, yes, it was contaminated. And we've been trying for 5 years to get it cleaned up. My children and my grandchildren can't use our property. The way the rest of the community can. And it's frustrating, because down the street is another dump. They made sure it's near $1 million golf course that is cleaned properly and done right. But when it comes to us, we've been waiting 5 years to get anything done. We've been in meetings for 3 days with DEP. We've been through so much. We're asking just to be treated fairly. You know, you talk about EJ and you talk about disparate treatment, and well, my thing is, we're part of the environment. The environmental impact to us is the same as the other people on the other part of town. We're only asking to be treated not differently, but be treated fair and clean up the waste that they put on our property.
Thank you.
Thank you so much.
Thank you
I'm
very
sorry
much.
for being so nervous.
Not at all. You did an excellent job. Are there any questions? Thank you very much, the panelists. Next panel on the same bill, Andrea Park, Adam Reynolds, and Iris Coloma Gaines.
Good morning. I'd like to thank Chair Edwards and Chair Day and the members of the Joint Committee on the Judiciary for allowing me the opportunity to testify today. My name is Iris Coloma-Gaines. I'm the statewide language access attorney at the Massachusetts Law Reform Institute, and our organization co-leads the coalition advocating for H. 1889, S.1174. I come before you today to testify in support of this important bill. The goal of the bill is to ensure that people are protected from government practices, policies, or actions that are neutral on their face, but when they are carried out have a discriminatory or disparate impact on people based on their protected characteristics. Existing state law provides fairly robust protection against discrimination in housing, employment, and public accommodations. However, Massachusetts does not have a private right of action for cases involving issues involving the environment, education, tax assessment, and disaster recovery, just to name a few. This bill would update Massachusetts law to allow victims of civil rights abuses to bring claims in state court, which are currently not allowed under federal law, to challenge government programs or activities that have a harmful or discriminatory effect. The bill would also prohibit discrimination on the basis of protected characteristics, which are already protected under Massachusetts law. In fact, this bill would provide a definition for the term protected characteristic, which is not currently defined under the Commonwealth law as a law or class or characteristic, as a class or characteristic is already protected from discrimination under federal or Commonwealth law. While federal anti-discrimination laws are under attack, it's imperative Massachusetts broaden its laws to prohibit all forms of discrimination, including government policies, practices, and programs which have a discriminatory effect, despite there being a lack of intent. Please report this bill out of committee favorably. Thank you.
Good afternoon, Chair Edwards, Chair Day, and members of the committee. My name is Adam Reynolds, and I'm a legal fellow with the Conservation Law Foundation, a nonprofit working to improve the environment and address environmental injustice in New England. I'm here today to express CLF's support for S.1064 and H. 1889. And as part of CLF's support for this legislation, I'd like to address a couple of examples of cases where a private right of action to address disparate impact discrimination would help protect both the people of Massachusetts and address environmental injustice. In 2016, the MBTA canceled late-night service on certain bus and subway lines that disproportionately served low-income communities and communities of color. Despite the existence of less discriminatory alternatives, CLF and our partners could not go to court and had to pursue administrative appeals to address these inequitable impacts. A private right of action would have allowed the people affected by the service changes to improve public transit and protect equal access. In another example, residents of Brockton, East and West Bridgewater were forced to spend decades fighting against a proposed power plant that disproportionately impacted low-income communities, communities of color, and communities with existing health disparities by exposing them to far more pollution than wealthier, whiter, and healthier communities. Without a private right of action, litigants' only option was to pursue disparate impact claims before the same agencies alleged to have caused the disparate impacts. Without a private right of action, people seeking to remedy the discriminatory impacts of government policy must either forego litigation or be pushed into administrative appeals that either, one, depend on a favorable federal landscape, or two, ask agencies to self-police their own policies. In the environmental context, EPA has often waited decades to consider disparate impact claims, and we've heard what that can do earlier. This problem has only worsened with the new federal administration. With this bill, Massachusetts would join a growing number of states that are working to ensure their citizens are protected from federal rollbacks and are empowered to protect their legal rights. We ask that you please give this bill favorable report this session, and thank you for your time.
Hi. Good morning, chairs. My name is Andrea Park. I'm also at Massachusetts Law Reform Institute. I just have a little bit to say, which is that I have litigated fair housing and discrimination cases in the Mass Commission Against Discrimination and in state and federal courts in Massachusetts. And I just wanted to emphasize that this doesn't interfere with any existing rights that we have. We have, as Iris said, a pretty robust set of laws and a structure for individuals who have claimed discrimination, and I think that the MCAD is a really important body to help assert those rights, particularly for unrepresented litigants, and we have been in communication with them about this bill. But we do have a gap, as you've heard. It's not intended to really open floodgates of litigation, but it's really to go after bad actors who are able to get away with things because there isn't an enforcement agency that's available. And I think as we see the federal landscape sort of, continue to be eviscerated, we do need to provide some access, and there are other states that we are looking to see what kind of framework they have set up. So we do hope you'll report this bill, and we're looking forward to continuing to work with you on it.
Thank you. Are there any questions? Yeah, go ahead.
Thank you, Madam Chair. If I could just pick up on that last point, we're always dealing with intended consequences and unintended consequences when we act statutorily. So So you said it's not intended to open the floodgates, but only to get at the bad actors. What are the guardrails you have in here to ensure that that actually is what the reality becomes?
I think there's a couple of answers to that. One is, I think that there are, just the reality of bringing cases that implicate disparate impact, there's a huge barrier to entry for those, right? There's, often takes an organization to be able to gather up a lot of evidence that really is going to show that there is even a cause of action to be brought there. So I think that it isn't the kind of thing that anyone can just kind of go and be like, hey, you did this, and I don't feel like this is right. Like, there is a lot of data that is required in order to bring a claim like this, which is part of what's so complicated and I think has really impeded the federal government's certain agencies' ability to investigate those. And I think another thing is that most of the time what the claims are being sought are really injunctive relief. So in the examples that you heard about earlier, and the people, I love the framing of people are in the environment too, right? These are not people who are going and seeking money damages because they think that they were wronged in some way. It's not a typical lawsuit in that regard. It really is seeking injunctive relief to right the wrongs and really correct harms that are happening to particular communities. So I think there are guardrails in that sense.
If I may, just a quick follow-up on that. You've got punitive damages allowed in here, right? And a plaintiff's bar is very wily in finding, plaintiffs that they represent on a contingency basis. How do you address that?
I think that those, again, there's a high burden of proof to be able to prove that those are necessary. And these are aspects of the bill that I think we're willing to work with the committee and the chairs on, as far as, as we continue to do research in other states. Where are punitive damages appropriate? How are they assessed? Who has them and who doesn't? I think I just want to make sure that we understand that, we're trying to create a sort of a different framework here. There are punitive damages currently available under 151B for current discrimination. Claims that individuals can bring, and those are very important to bringing actors to the table. So, but I think that that's something that we can discuss.
Well, just to follow up on the chair's kind of cautionary conversations, because so much of the plaintiff's bar's cases, they're settled, right? And so that would be an incentive for someone to go out of their way. We file the suit, it's worth it to the state to pay some go-away money, which could be a significant amount, right? Of which 1/3 goes to the attorneys and so on and so forth. So I think that's where some of the cautionary concerns are coming from. I'm acknowledging, however, that a lot of this conversation is prompted by what the courts have done to disparate impact over the years, and basically narrowed it in such a form that what it means to show discrimination almost is you need the recording, you need all these different aspects, when so much of what is oppressive about discrimination is the ultimate impact on a group of people without them even knowing it, right? That can be generationally felt. So I believe it exists, disparate impact, and I think that the goal of this is to try and figure out a way to get at it. My not even concern, but it is because we have allowed, or this would allow for all classes who are protected. We have parents who are protected, people with various disabilities who are protected, veterans are now a protected class. So what that could open up is any group of people who's a protected class saying this law impacts us adversely. Disparate impact, right, is a concern. So I really like the conversation being kind of not narrowed, but really focused on the environmental impact, because I think you can measure that. The health impacts, the history and so on and so forth, the science that's behind it. We believe in science here, all of these different things. So I'm looking forward to a longer conversation about how we meet the concerns of opening up the floodgates, but also understanding the horrible oppressive nature of discrimination is its disparate impact. So I look forward to that bridge, and I understand that this is a great attempt at that.
Can I just respond really quickly? I think that you're right too, and we're having a conversation kind of ongoing over the past since this bill's origins happened after the Sandoval decision from the Supreme Court about that, which is obviously a live debate in the federal context as well now too, which is what is the disparate impact? Who gets to claim that? Are we talking about historical wrongs, or are we just talking about people who feel unjustly treated? So I think that is a very active discussion. I think that we're happy to have that with you. I think it's good to know that we still believe in science, but there is also, I think it can be broader than environment, but I do think we can start small and cabinet in ways that will not open floodgates.
Appreciate that. Look forward to working with you. Any other questions? Seeing none, thank you.
Thank you.
H1973, an act protecting personal security. We have a panel with Finn Gardner and Kelsey Grunsta. In person. I'm just going to say it one more time.
Just want to recognize and welcome Ranking Member Berthium, Representative Berthium has joined us as well.
All right, just going to announce it one more time, then we're moving on. H1973, an act protecting personal security. The panel is Finn Gardner and Kelsey Grinsta. Maybe they're online. Finn and Kelsey. No? Okay. H4199, an act protecting victims of childhood sexual abuse and holding perpetrators accountable. An individual, Catherine Robb, in person. Catherine Robb? Maybe virtually? No? Okay. H4684, an act ensuring law enforcement identification and public trust. Individual, Lee Stephanie Roscoe, who is virtual. If Lee's not there, we also have virtually Nora Dooley. No? Okay. H4115, an act relative to preventing immigration reporting and ensuring the right to legal counsel. We have Grace Ross. I don't see Grace. Okay, I'll have her. H2009, an act supporting and honoring immigration and customs enforcement lawful detainments, the SHIELD Act. Individual in person, we have Alex Matthews. Okay. We also have Ryan Sullivan, who is virtual.
Hi, Chair, members of the committee, thank you for the opportunity to testify today. I'm Ryan Sullivan. I'm speaking on behalf of the Legislative Committee of the Massachusetts Association of Criminal Defense Lawyers, NACDL. I'm also a practicing criminal defense attorney, appearing in courthouses across the Commonwealth every day. I'm rising in strong opposition to H2009, 1805, 1588, and also H4684 and the Senate companions. These bills would further empower ICE to conduct arrests in and around our courthouses. Coupled with 4684, they would permit ICE agents to conduct arrests while masked and unidentified. This practice is wholly incompatible with the transparency and accountability on which public trust in the justice system depends. These bills would expand ICE's authority to detain individuals who come to courthouses for legitimate and often urgent reasons. People seeking restraining orders, victims of domestic violence, witnesses to violent crime, individuals who are appearing to assert their innocence, as one of our clients was taken away in the middle of his jury trial with subjects. When community members believe that they may be seized by masked, unbadged federal agents placed into unmarked SUVs that don't have any law enforcement insignia and transported out of state for simply entering a courthouse, they lose confidence that the court is a safe and neutral space. We are already seeing the chilling effect this fear creates. Victims decline to seek protection, witnesses disappear or avoid police, entire communities avoid the courthouse altogether, even when they desperately need its services. When courthouses become a place of fear instead of justice, the harm spreads far beyond immigrant communities. It undermines the integrity and functioning of the entire system. Massachusetts has long recognized that our courts must remain open, accessible, and safe for all people. These bills move us in the opposite direction. They legitimize secrecy, erode accountability, and invite abuses by the federal agents operating without identification and without scrutiny. Thank you.
Thank you. Any questions? Seeing none, thank you very much. I'm just gonna, one more time, Alex Matthews, online, in person. Okay. H1696, an act to cure us of the liabilities that ultimately restricted equity. I have Asia Jackson. Okay. And Antonia Edwards.
Good morning. Just want to say thank you for the distinguished panel and honorable chair, Ms. Lydia. My name is Antonia Edwards, and I stand for you as a lineal descendant of American freedmen, third generation removed from formerly emancipated people whose freedom was solidified and codified by the 13th, 14th Amendment. Forced labor built this nation. My lineage extends back to both my maternal and paternal lines, each directly tied to the legacy of U.S. chattel slavery. Reconstruction, Jim Crow, the long struggle of civil rights, human rights. My family migrated here from down south, South Carolina in 1940 through the Great Migration to escape racial terror. At that time, when they came here, they faced racial terror here as well too. So from 1910 to 1970 through the Great Migration, there were two waves. There were 65,000 to 90,000 American freedmen who came here from the South to escape racial terror. Both on the census data and also the Boston Foundation in 2023 and the Pew Research Report, there's approximately 140,000 to 160 American freedmen in Massachusetts today. That's 30 to 35% of your black population. So if you can't see us, you can't serve us. Due to a flatness of blackness and a diversity, our heritage is being erased. And so we're asking that any commission, any reparations that deals with the legacy of slavery, that were actively being spoken of. And our ancestors are recognized for the badges and incidents and the stain of slavery that we carry. We have the enslavement, we have terror, racial terror, we have political disenfranchisement, we have housing segregation, we have separate and unequal education, we have environmental racism, and infrastructure neglect, pathology of freedmen families, we have suppression of culture, creativity, intellectual life, stolen labor, blocked economic opportunities, criminalization, unjust legal system, mental, physical, and medical neglect, and we have a persistent racial gap. We're asking that you take this opportunity to recognize the fact that Massachusetts, and I'll be short, Massachusetts created slavery, but it also helped end it. But it never repaired the damages done to the American freedmen or the descendants that built the labor for the Commonwealth of Massachusetts. So we ask today to take this opportunity to right the wrongs of history and justice required. So you can't serve us if you don't see us. So we're asking unanimously to vote in favor that there's any reparations commissions, any reparations agencies that are put together, that you recognize our ancestors from the American Freedmen Act of 1865, the American Freedmen Bureau 1865 as well too. To not do so will be egregious. Thank you.
Thank you very much for your testimony. Any questions? Seeing none, thank you.
No, thank you. Thank you for the opportunity.
Okay, moving on to H1922, S1119, an act relative to fair investment. There's one, I see one panel, 5 testifiers. I think they're all virtual. Catherine Gray, Greta Swami, Mandy Pat, Madhosikra Alisi, apologies for the pronunciation, and Akash Murthy. Are they all online?
Yes, ma'am.
Okay. So you have 5 minutes for this panel, virtual panel. You may begin.
Thank you. I will start. Thank you, Chair Edwards, Chair Day, and members of the Committee on Judiciary. My name is Dr. Deepa Swami, and I'm speaking on behalf of the Coalition for Capital Equity, representing hundreds, if not thousands, of founders, funders, and professionals across the state in strong support of S.1175, H1922. We have a big problem. Massachusetts and federal law provides no basic civil rights protections to entrepreneurs, innovators, and artists seeking private investments like venture capital. This leaves founders, especially minorities and women of color, uniquely exposed to harassment, coercion, and discrimination in one of the most unequal power dynamics in business. The absence of legal standards has created a systemic market failure. Women and minority founders form over 50% of new businesses, and yet they receive only 0.6% of venture capital in Massachusetts, making it one of the least friendly states for women entrepreneurs. In a state where 99.5% of businesses are small businesses, this distortion directly suppresses the state's innovation, competition, and growth. S.1175, H1922 closes this gap in a balanced, targeted, business-friendly manner. It uses a compliance-based framework modeled on California's SB54 VC law and federal fair lending law, creating clear expectations without over-regulating. Not only will this bill provide much-needed access to private capital, it will grow the Massachusetts economy, potentially doubling it. Additionally, with a simple compliance fee from the AGO's office, this can ensure the state $1 billion in revenue as well. On behalf of the coalition and as an entrepreneur and a founder, I respectfully urge a favorable report, and I cede the time to my finalists. Thank you.
Any of the other panelists want to, Catherine Gray or Mandy or Akash? Should chime in now. Are there any other people on?
I think we have a few people in person.
If they're in person, you should come forward.
Good morning, and thank you, Honorable Committee, for this opportunity. My name is Urvashi Batra, co-founder and CEO of PriorWise, an AI company. I'm here in support of Bill S.1175 and H1922 in support of the Fair Investment Act. I spent more than 2 decades in enterprise tech, often as the only woman of very few in a room dominated by male leaders. I learned early that I had to shrink myself just to fit in. I was constantly modulating how I spoke, how assertive I could be, how much space I was allowed to take before being judged differently than my male peers. When I became a founder, those dynamics unfortunately did not disappear. Despite strong credentials, I see male founders receive immediate credibility, while women like me are met with hesitation or doubt. This isn't about individual bad actors. It's about systematic patterns that replicate themselves when there is no transparency, no accountability, and no structured mechanisms to check for bias. That's why Bill S.1175 and H1922 is so important. Today, beyond building my company, I also mentor students, many of them young women who are eager to start their own company in this Boston innovative community. These are extraordinary young women with vision, talent, and ambition. We cannot ask the next generation to dream big while leaving barriers completely untouched. Massachusetts wants to lead in innovation, but it's difficult for entire groups of talented founders who are consistently overlooked because of invisible barriers. This bill brings those barriers into light and promotes fairness, encourages best practices, and strengthens the innovation ecosystem everywhere. Thank you.
Good morning, thank you. My name is Joanna Rosenberg. Thank you for having me here. I'm the founder of Simply Here, a company inspired by my family's experience when our mother, who had ALS, lost her ability to speak. Living through that showed me how hard it is for patients and caregivers to stay connected when communication breaks down. I started this company with a mission to create a simple, scalable solution that helps patients communicate more easily with their caregivers, not only with ALS, but also across conditions like stroke, dementia, and other neurological challenges that affect millions of Americans. I've been self-funding this work, building product, hiring trusted developers, gathering feedback, searching for the right channels to reach caregivers who urgently need this support. My journey reflects a broader issue. Venture capital access isn't just about money, it's about gaining entry to networks, expertise, and industry connections that help a startup grow. For many women and other underrepresented members of the population, those networks remain out of reach, regardless of the quality or importance of the problem they're solving. I understand that investment carries risk, but that risk can be managed through tiered or milestone-based funding. What's unacceptable is limiting opportunity to only one type of founder. When underrepresented founders are excluded, entire communities and critical innovations are left behind. The Fair Investment Act isn't about guaranteeing investment, it's about guaranteeing fair access. It ensures that founders like me can compete on equal footing and bring solutions to the families who need them most. I urge you to support Bill S.1175 and H.1922 and expand access to growth and innovation in Massachusetts. Thank you.
Thank you very much. Any questions? Seeing none? Thank you. Just want to note that we've been joined by Senator Liz Miranda. Okay. I don't have any additional, anybody else here whose name I called didn't come and testify on this particular bill? All right. Moving on. Okay. Up first, we have S1116, H1683, an act to strengthen justice and support for sex trade survivors. We have on our first panel, Alyssa Scruggs and Sophia Rousseau.
Good morning, Chairman Day, Chairman Edwards, and members of the Judiciary Committee. Thank you for giving me the opportunity to testify before you again regarding the incredible hardships still faced by survivors of human trafficking in the Commonwealth and the concrete steps we can take toward meaningful solutions for survivors. My name is Alyssa Scruggs, and I'm a partner at the law firm Kirkland & Ellis, and one of the authors of H.1176, H.1917, an act to ensure fair access to compensation for, known as the Sex Trade Survivor Act. This is a testimony. I apologize, I have the wrong papers in front of me. We wrote this bill because the vacatur bill that exists right now was an extremely important step towards providing justice to survivors of human trafficking, but it was just that, a first step. Vacatur, as it stands, requires that folks appear in court multiple times and repeatedly rehash their trauma in public settings, which can be not only traumatic, but is also time-consuming and onerous, and essentially requires the assistance of an attorney. As a result, vacatur, while, again, an incredibly important step, and we're so grateful that Massachusetts has it, it was really just a first step, and we need to take the next step now to move towards providing justice to survivors. One big element of this bill that takes that step is expanding the vacatur provision, expanding the types of evidence that can be used to achieve the rebuttable presumption of being a human trafficking victim. The bill also removes some of the existing archaic language from the Massachusetts Code, like common night walking and common street walking. And importantly, it also convenes an interagency commission that would be the most diverse and multifaceted commission to ever look at this issue in the Commonwealth. I'm going to allow my colleague Sophia to provide more information about why this bill matters so much on the ground, but I thank you for your time today, and I welcome any questions you might have.
Thank you, Alyssa, and thank you to the chairpersons and the members of the committee. My name is Sophia Russo, and I'm an attorney with a decade of experience working with human trafficking. I have prosecuted human trafficking offenses at both the district level and the state level, and I currently work for Safe Exit Initiative, working with those with lived and living experience as they try to navigate the legal system, facing barriers as the result of their involvement in the sex trade. I will be speaking to the elements of this proposed bill that expand access to vacatur and post-conviction relief, specifically relating to human trafficking survivors. I'd like to acknowledge that those with lived experience don't always identify as victims of human trafficking, and the scope of this entire bill works to expand protections and supports for those with lived and living experience who would not identify as a trafficking survivor. In my experience and practice, criminal convictions signify accountability, can help restore justice to those who have been wronged, serving as a lasting record of the person's offense and the harm caused. However, it does beg the question for, in the case of human trafficking, the entwining of the criminality and human trafficking is a necessary part of even proving a trafficking conviction. So there's an interesting area that needs to be addressed, and this bill seeks to do that. One of the key provisions of this bill is expanded relief through vacatur and the added provision of expungement, which serves to acknowledge the harms of human trafficking and rectify the legally sanctioned inability of survivors to move forward with a clean slate. Having a criminal record is one of the greatest barriers to exiting the sex trade. The current statute allows for vacatur for 4 times that are commonly associated, and we're seeking to decriminalize common night walking, street walking in this particular bill. However, these type of charges on someone's record can effectively reduce someone's ability to navigate housing, employment, and also to navigate the family court system. I have counseled dozens of survivors of human trafficking regarding exiting the sex trade, and what I have found across the board is that a criminal record with these charges makes doing so exponentially more difficult. The current process, although is a great start, is cumbersome, and I've spoken with multiple victims of human trafficking who would be eligible for relief under the current statute who aren't able to access it, allowing the This proposed bill amends the current statute to allow them to sign an affidavit to attest to their own victimization.
Thank you.
Thank you.
Thank you very much for your time. Up next, we have Ann Offen, virtually. We've also been joined by Senator Pat Jalen, a member of the committee. Last call for Ann Offen, Offen. Okay. Next we have Gauri Vijayakumar, virtually. Gowri, G-O-W-R-I.
Yeah, I'm here. I'm just trying to figure out, okay, I can't figure out how to turn the right camera, so I just want to move. Is that okay? Can you hear me?
That's fine. We can hear you. Go ahead.
Okay. Good morning, and thank you for the opportunity to speak today. My name is Shelley Wright, and I'm an associate professor of sociology and business and sexuality studies at Brandeis University. I'm here to speak in favor of H-1980 and ask to promote the health and safety of people in the sex trade. This act will improve sex workers' access to healthcare and help them to earn their livelihoods without fear of violence or exploitation. It will enable sex workers to build safety networks and social services that allow them to live with dignity. As a global health researcher, I can attest that there's now a substantial body of research showing that criminalization, including criminalization of clients, the so-called notice model, prevents sex workers from accessing their right to health and safety. I wrote a book about HIV politics in India, where sex work is criminalized. The laws criminalizing sex work in both India and the US are often archaic laws built on 19th century ideas about sexuality and morality. They aren't based on public health research or a nuanced understanding of working people's lives. In my work with Sex Worker Collective, organizing collectively was crucial to slowing the HIV epidemic and improving the health and livelihoods of sex workers, including identifying cases of trafficking. Learned analysis estimated that decriminalization of sex work could avert up to 46% of HIV infections over a decade. In New Zealand, where sex work is decriminalized, sex workers have been better able to report up.
On the other hand, criminalization or conflating consensual sex work with trafficking pushes sex work underground, empowering exploiters and making it hard to access care. Decriminalizing sex work doesn't mean romanticizing it. Sex work is a job like any other job, and all jobs have potential to be exploitative. Decriminalization enables workers to stand up against exploitation without losing their livelihood. My research has shown me that sex workers know best how to protect each other. H1980 allows us to
Thank you very much.
those ideas about what keeps them safe instead of moral panic or outdated sexual norms. Thank you.
Thank you. I also have Chris V. virtual.
Hello. Thank you, Chairwoman Edwards and Senator Friedman, for this hearing and listening to our testimony. I'm here to say I support Senate Bill 1116, created to strengthen justice and support for sex trafficked survivors. Two things first. No woman, girl, or person wakes up in the morning and says, I want to be sexually violated, trafficked, sold, or bought. No. But a trafficker pimp will always be on the hunt for the next victim. Always. Two, always believe her, believe them. Saying I believe you is an important first step in helping victims of sexual violence. Systemic doubt by society, however, ensures underreporting, isolation, continued exploitation, violence, and trauma. Women instinctively know this. I knew this when I didn't report my sexual violence or trauma. So let me say to everyone here and everywhere, I believe you. Section 1, language matters. From prostitutes to prostituted people, I support this language shift because it takes the blame off the victim survivor's shoulders and onto the trafficker, pimps, and John who deserve it, exactly where it belongs. Section 5 and 6, vacature of conviction and expungement. What health supports will victims receive to cope with the re-traumatization while they recount their exploitation or affidavits and legal proceedings? 2, how will the process protect victims from retaliation from traffickers and their associates and ensure victim safety? Section 11, Special Commission. Our organization solely focused on women and girls a part of the Special Commission. As we know, women and girls are disproportionately impacted by trafficking and sexual violence, and it is imperative that women and girl groups are represented on the commission. A UN study reported that sexual exploitation remains a major form of trafficking, involving 36% of the victims. Women and girls.
Thank you very much.
Dominate this category, over 90% of the victims. Thank you very much for listening. I appreciate your work and hearing me.
Thank you. I believe we have State Rep. Keefe and I think State Rep. Farley Bouvier online together. Okay.
Thank you so much, Senator Edwards and Representative Day. This is a very typical committee that you chair, and the work is incredibly important. I appreciate your time today, and am very pleased to be able to join you remotely while my partner is in the room with you. Representative Keefe and I have worked for a few years now on H.1175. We also call this the Sex Trade Survivors Act. The bill, it's important to know, was drafted by survivors of the sex trade and informed by conversations with advocates, law enforcement, and legal experts. And it has a few aims. One is to remove the archaic offenses like common night walking and common street walking. There's also a criminal justice reform component to this, thus removing barriers to housing and employment. Rep. Keefe is going to talk on that more in depth. And the heart of this bill is to create an interagency commission. Now, we love this word commission, don't we? But we need to do the work ahead of time to develop recommendations concerning provisions of services related to those who have been prostituted and exploited. Last session, we filed a bill, and it's not this bill. That's very clear that it's not this bill. And in that we are removing anything about decriminalization for anybody, and we're focusing on the criminal justice reform and the commission. I think it's important to know that there are different views on what to do around this, and conversations have started between people with opposing views, and we're making some progress, and I think you'll be pleased to know that. And with that, Madam Chair, I'd like to turn it over to Representative Keefe.
Thank you, Tricia, and thank you, Chair Edwards and Chair Day and members of the committee. I'm really happy to be here today and move this bill forward. I think it's the third session we've tried to focus on this as an issue, and we've come a long way in terms of coming together and agreeing around what our path should be. According to service providers, women and girls are vulnerable to exploitation in the sex trade cluster for 4 main categories: economic insecurity, housing insecurity, education, and migration. The intent of this bill is to ensure that those who are being exploited in the sex trade, overwhelmingly women and girls, and disproportionately BIPOC LGBTQ individuals, are more easily able to access services and aims to expand access to expungement. I also chair the Criminal Justice Reform Caucus, and one of the biggest emphases of our work has been on reentry and what it takes to reentry. Now, we're talking more about exiting in this situation, but it's so difficult, and the challenges are so real around being able to move in a positive direction. And that's where we feel strongly around the criminal record, that this bill also expands the existing human trafficking vacateur provision to provide that not only prosecutors but other service providers can stand and give some evidence as to whether the person is actually being trafficked. And I think you've already heard from a panel that spoke to that better than I can. Many survivors have told us that while the vacateur provision passed in 2019 was a major, major win, we feel that there's a way that we could step forward and reduce the burdens and make it work more efficiently. Service providers and survivors both have repeatedly told us that criminal record relief and access to professional services designed to support independence contribute to the ability to exit the trade and to start a new life and avoid trafficking and re-victimization. And lastly, I'd just like to speak to the survivors that have put so much work into this, especially folks from Worcester, because it has a huge impact on our city and on my district in particular. I'd like to call out, and you will hear from Safe Exit Initiative, My Life, My Choice, and Read, Inspire, and Act. They have worked so hard to shine a light and to show the pathway that we could create together. So with that, I thank you very much, and any questions we can try and answer.
Seeing no questions. Thank you very much, Representative.
Okay, thank you.
Going on to H.1127, an act exonerating certain individuals accused of witchcraft in colonial Massachusetts. We have 3 testifiers and 1 panel. And just to note, there are some people who signed up today on several of the bills that I've called. What I'm going through is the list to people who signed up, and I will, if you signed up today, we will call you. You will be able to testify on your bill, okay? So I have as an first individual, Antonio Infante.
Good morning, everyone. Esteemed members of the Joint Committee on the Judiciary, I write in support of H.1927, an act exonerating certain individuals accused of witchcraft in colonial Massachusetts. I've grown up in this amazing state since I was 8 years old, and I've embraced my local history in hopes of sharing it with people, while also learning about its dark past regarding the various witch trials in the state. Historical wrongs have been righted regarding the people of Salem, but there is always more to it. The people who were accused before Salem have been forgotten, relegated to the history books, and these were people who had families, and through research I found stories of love and affection. It is a history that has become a comedy, with people now regarding these victims as more than a pebble. They've become a gimmick only acceptable to be discussed in October, and this is not the case. As I have stated previously, they were human beings that became victims of fear and paranoia. Massachusetts has always been one to move against the grain, with the Boston Tea Party in 1773, abolishment of slavery in 1783, and the first state to legalize same-sex marriage in 2004. It is important to acknowledge this past, correct it, and have people learn their stories to keep these tragedies from happening again. We can show the world that witch hunts are not okay and should never be tolerated. I thank you all for considering of this ruling.
Thank you very much for your testimony. Any questions? Seeing none, we'll move on. We have a panel: Daniel Gagnon, Sarah Jack, Marilyn Roach.
Esteemed members of the Joint Committee on Judiciary, my name is Sarah Jack, and I'm the director of End Witch Hunts nonprofit. We collaborate nationally and internationally about literal witch hunts, past and present. I am a direct descendant of Mary Hale, who was tried here in Boston, and also Rebecca Nurse and Mary Esty, who were executed in Salem, but later exonerated. This bill is about innocent people convicted of an impossible crime. They were convicted of being traitors who signed a covenant with the literal devil. So it was impossible. And those 8 people were Margaret Jones, Elizabeth Kendall, Alice Lake, Ann Hibbins, Goody Glover, Hugh Parsons, Eunice Cole, and Elizabeth Morse. This bill specifically is just finishing what Massachusetts has started. It applies the same remedy to these individuals that the Salem victims received. We do have nearly 3,000 signatures of support on a petition, which is a lot. I saw on social media this weekend that Cynthia Erivo from Wicked for Good started a petition to support the refugees in Ghana who are accused of witchcraft. There's 12,000 signatures. So I think 3,000 for Massachusetts is pretty awesome. We appreciate the representatives and senators supporting this. We have historical societies, residents across districts, and no organized opposition. I also want to point out that the art in the House of Representatives chamber depicts Judge Sewell's apology for witch trials. So I would like these individuals to have their name cleared.
Thank you to the committee for this opportunity to speak. I'm Marilyn Roach from Watertown, Massachusetts, and I've been researching and writing about New England witchcraft cases for a good half-century, and new information, such as the need for the purpose we're here today, continues to surface. I ask you to support Bill H. 1927 to exonerate the people executed as alleged witches before the Salem Panic. Although they are not alive and present after over 3 centuries, to feel satisfaction at a reversal of the verdict that killed them, clearing their names is not only right, but would also give us, the living, a firmer ground to speak from when we deplore the actions of other nations, other cultures, and some individuals in our own country, because witch persecutions are still happening, mostly, though not exclusively, targeting women and children. Victims who are scorned, incarcerated, and even killed today, now. Passing Bill H. 1927 would allow a voice to the voiceless, the known and the nameless ones of our shared history whose records are lost, an acknowledgement allowing the dead to make a difference so that their unnecessary death may not have been wholly wasted. Thank you.
Good morning, members of the Judiciary Committee. My name is Dan Gagnon. I'm a historian and researcher of the Salem Village witch hunt. I live in Danvers, Mass. The issue in front of us today is one of righting an historical wrong finally, after almost 350 years, clearing the remaining names of Massachusetts citizens, predominantly women, who the Massachusetts government wrongly convicted of witchcraft, an impossible crime of which they were clearly innocent. This need to clear their names is before us today, hundreds of years later, simply because these individuals were overlooked, while more well-known witchcraft cases were previously cleared. In Danvers, formerly known as Salem Village, our community has confronted historic injustices related to witchcraft accusations over generations. As early as 1703, people from what is now Danvers petitioned the legislature to clear most of the names of people who had been convicted of witchcraft in Massachusetts. And in 1885, our community built a memorial to witch hunt victim Rebecca Nurse, which made Massachusetts the first place in America to dedicate a memorial in honor of someone who was convicted of witchcraft. When in 1885, that first memorial to a witch hunt victim was dedicated, Danvers' state representative at that time, Reverend Charles Rice, told the community, quote, "There is a public interest in every person demanding that public errors of the past should stand in the light and be reproved." Now today, this public interest in justice continues, just as it did for prior generations, and is the reason that this bill was filed. Massachusetts has a proud tradition of seeking justice for those who are wronged. Clearing the names of these innocent people is one final step to close the book on such an awful series of events in Massachusetts history, to redeem these people, and I urge you to support this bill. Thank you for your time.
Thank you. Excellent time management. Any questions? Seeing none, thank you. Next, David Allen Lambert.
Good morning. My name is David Allen Lambert. I am the Chief Genealogist of American Ancestors, formerly the New England Historic Genealogical Society here in Boston, a Fellow of the Mass Historical Society, and Town Historian for Stoughton, Massachusetts, incidentally named for Chief Justice William Stoughton of the trials, who we no longer honor for obvious reasons. For the record, I am not a witch. Before you today, I make this declaration of my innocence freely and without judgment of cross-examination. Hundreds of citizens of the Commonwealth did not have that luxury to claim their innocence from the accused crime of witchcraft in 1692, and 25 perished at the gallows or in jail. One of these innocent was my 77-year-old 10th great-grandmother, Mary Bradbury of Salisbury, accused of the Court of Oyer and Terminer by spectral evidence that she shape-shifted into a blue boar and was in league with the devil. Over 100 townspeople of Salisbury testified in her support of innocence, putting their own lives at risk for association to no avail. She was sentenced to be executed in September of 1692, but somehow she escaped. Yet another relative, Martha Allen Carrier, my 9th great aunt, left this world innocent at the end of a hangman's noose at Gallows Hill, charged with witchcraft. Her sister, Mary Toothaker, her 2 young sons, and a 7.5-year-old daughter, Sarah, sat in jail awaiting trial, only to watch Mary's husband and their father, Roger Toothaker, die in prison. These are a mere handful of the names of hundreds of accused whose names were never cleared and exonerated for their innocence. These long-dead ancestors have no voice to continue their claim of innocence, but many of us here today are their voice and represent millions of living descendants who are your neighbors, your constituents. We now are their voice and hope to be heard one last time. One last relative, my 7th great uncle Samuel Sewell, a judge at the trials, who looks over you in the House chambers from a painting called The Dawn of Tolerance. This painting shows Sewell standing at the Old South Meeting House here in Boston in 1697. Here he stood and made history as the only judge to make a public confession, apologize his roles and death for accused trials. As I ask you to lend your own voice to history today for a final dawn of tolerance, to once and all clear the names of my ancestors and countless others, to bring the closure to the darkest chapter in the history of the Commonwealth, I beg you, for their memory, the innocent victims, undo the Commonwealth did to them and clear their good names after all 333 years. Thank you for your support of H1927.
Thank you. Any questions? Seeing none. And we have Leo Igwe in virtual. Leo.
Distinguished members of the Joint Committee on the Judiciary, thank you for the opportunity to testify here today. My name is Leo Igwe, a citizen of Nigeria and a citizen of the world. I hold a doctoral degree in religious studies from the University of Bayreuth and wrote my thesis on witchcraft accusation in Ghana, West Africa. I have campaigned against witch persecution and ritual attacks since the 90s. And in 2020, I founded the Advocacy for Alleged Witches to End Witch Hunting and Related Injustices in Africa by 2030. It's natural for us to support Bill H. 1927, urging the exoneration of 8 individuals convicted of witchcraft in Boston and all others accused of witchcraft in colonial Massachusetts. This exoneration will serve as a statement of hope and relief to tens of thousands in Nigeria, Ghana, Malawi, India, and Papua New Guinea who still suffer similar accusations and persecution and miscarriage of justice in this century. In my part of the world, witch trials have not ended. Alleged witches, mainly women, children, and elderly persons, are beaten, flogged. They are tortured, stripped naked, set ablaze, and buried alive. Based on my decades of academic experience and activism, I confirm that your favorable consideration of this bill will surely resonate with contemporary victims of superstitious fear and their families. It will boost ongoing efforts to end abuses linked to belief in witchcraft in other parts of the world. Thank you.
Thank you very much. Are there any questions? Thank you. Moving on to S.1175, an act establishing a commission to study reparations in Massachusetts. In person, we have Aziza Robinson Goodnight. Is Aziza here? Okay. I have George Craddock in person. Maybe virtual. No? Okay. I have a panel, Kimberly Jackson Elgaudy and Yvette Carnell, virtually. No. I have Naomi Sheeman, virtually.
Here I am.
Okay.
Can you hear me?
Yes.
Thank you to committee chairs Edwards and Day, co-chairs Eldridge and Fluker-Reed, and members of the Judiciary Committee for the opportunity to share with you my thoughts about Bills H-1753 and S-1181. My name is Naomi Sheeman, and I am an emerita professor of philosophy at the University of Minnesota, living here in Arlington since 2016. I am a member of Boston Workers Circle and of the core team of the Reparations Interfaith Coalition of Massachusetts. Reparations for slavery and its afterlives, which continue to this day, are first and foremost a matter of justice, especially as white people, even those of us whose ancestors arrived in this country after the end of slavery, we benefit in ways large and small from the stolen labor and continuing exploitation of Black people. We owe a debt that needs to be repaid. But I want to speak about another reason that the struggle for reparations matters to me. Over the past few years, I have been inspired by gatherings of national reparationists and by my engagement with the Boston Ujima Project, which is supporting a network of Black-led businesses that are planting the seeds for a solidarity economy, which is itself a reparative endeavor. Those experiences have given me glimpses of the beloved community Martin Luther King Jr. spoke of, a world in which we can relate to each other as neighbors, friends, and kin, appreciating, learning from, and delighting in the differences between us, when those differences no longer delineate lines of unjust power and privilege. I long to live in such a world, and when it comes, white people will owe another debt to our Black neighbors, but that will be a debt to be paid in joy. And though I know that that day will not come in my lifetime, I live for being part of the struggle to achieve it, and I urge you to help us move toward it by passing these bills. Thank you.
Thank you very much. Any questions? Okay. I have Paloma McLaughlin, virtually. Okay. No, okay. Reggie Stewart, virtually. In person, perfect. All right.
Good afternoon, chairs, co-chairs, distinguished committee members. My name is Reggie Stewart. I appear before you today as the state coordinator for the Massachusetts chapter of the ADOS Advocacy Foundation. We represent constituencies in 14 state house districts and 13 state senate districts across the Commonwealth. I want to start by thanking the advocates in the legislature who have already taken a stand in support of reparations: Senator Miranda, Representative Holmes, Representative Fluker-Reed, each of whom has sponsored legislation, and the co-sponsors. Thank you. I'm here today in strong support of H.1175 and its Senate companion S.1181. I want to thank the sponsors for doing the critical work of ensuring bicameral alignment, something that we did not have in the previous session. By filing companion legislation, you've provided the General Court with a unified vehicle, a clear pathway, and a reduced risk of procedural dead ends. The structure of this bill reflects the seriousness of the moment. It establishes a commission with balanced appointments across the executive and legislative branches, meaningful investigatory authority, subpoena power, access to data, the ability to hire staff, and contract research. These are essential tools required for rigorous analysis, credible eligibility frameworks, and actionable recommendations. So I respectfully urge the committee to report this bill out favorably. And let me also say that what we're experiencing today in this country, the weakening of institutions that protect the vulnerable, the hoarding of wealth at the top, the emboldening of racist and authoritarian forces, is not a new phenomenon, but it's rather a modern day of expression and unfinished business from slavery and the legacy that it leaves behind. So as Massachusetts led in 1783 with the Supreme Court decision abolishing slavery, Massachusetts again has the opportunity to lead the way in America and provide us with the moral clarity that we need to move forward as a nation. And if the committee has any questions, I'll take them.
Seeing none, thank you very much.
Thank you.
Harrison Clark, virtually.
Hi, can you hear me?
Yes.
Perfect. Hi, good afternoon, Chair Edwards and Day, rest of the distinguished committee. My name is Harrison Clark, and for the past 3.5 years, I have been working and organizing locally around reparations, locally and nationally around reparations here in the Commonwealth of Massachusetts. And I urge the committee to strongly support House Bill 1753 and Senate Companion 1181. This legislation, because there's a long documented history of involvement in slavery in the Commonwealth, as well as discriminatory laws, practices, and exclusion from opportunity. This includes things like redlining and racial wealth extraction. These policies create intergenerational harm for Black families here in the Commonwealth, and they need to be addressed through actionable means such as this commission. And I urge the committee to support both bills in totality. And I thank you all for your time.
Thank you. Any questions? Okay. Kathleen Anderson. Okay. And we have a panel, a second panel, Jason Boyd, Elizabeth Tiblack, Yvette Modestin, and Jemadari Kamara. You have 5 minutes. Right. Go ahead.
Good afternoon, Chair Edwards, Chair Day, distinguished committee members. My name is Jemadari Kamara. I'm a professor of Africana Studies at the University of Massachusetts, Boston, and the former dean of the College of Public and Community Service. I'm joined here on my panel with my colleagues, Yvette Modestin, Jason Boyd, who's on his way, and Elizabeth Tiblack. We represent the Massachusetts Black Reparations Collective. The collective has come here today to express our strong support for Senate Bill 1181, an act establishing a commission to study reparations in Massachusetts, sponsored by Senator Liz Miranda. We are asking that the Judiciary Committee deliver a favorable report and swift passage of this vital legislation. This essential bill, which mirrors an identical bill that is House 1753, presented by Representative Russell Holmes, proposes the creation of a permanent commission to undertake a comprehensive study of slavery and its enduring negative consequences on the residents of African descent in the Commonwealth. Massachusetts has a complex history in regard to slavery and post-slavery state-sanctioned discriminatory and harmful practices. The legacy of this history, along with subsequent ongoing systemic discrimination, continues to manifest in persistent disparities in wealth, education, housing, and health outcomes. The Commission's work, as outlined in Senate Bill 1181, will involve investigating the history of slavery and post-abolition discrimination within Massachusetts, analyzing the ongoing economic, social, and psychological harms experienced by residents of African descent in the Commonwealth as a result, and developing concrete recommendations for reparative actions. This legislation is a necessary step toward addressing deep structural injustices that continue to harm Black communities today and building a more just Massachusetts for all its residents. Boston, Amherst, Northampton, and several other municipalities in the state have already provided leadership in initiating local efforts to address the legacy of slavery and its stubborn, persistent impacts on the Commonwealth. It's time for the state legislature to address these concerns comprehensively on a statewide level. The proposed legislation will establish a permanent commission to provide a comprehensive, coordinated approach to achieving racial justice. It will provide a platform for all voices to contribute to the complex resolution of this deeply rooted issues. The aligned efforts of Senator Miranda, Representative Holmes, have demonstrated the strong bicameral commitment
Just
to
note
this.
you have 2 minutes, and so if you have the other two wanted to testify.
Very good.
It's all gonna, okay.
Yes. Thank you. It represents the bicameral approach to this particular issue. Our duty as a collective body of constituents, elected officials, in Massachusetts acknowledges and to rectify the historical wrongs of the present day impacts. In conclusion, we strongly urge the committee's support for the comprehensive, inclusive approach taken in both the Senate and the House bills to help Massachusetts thoughtfully move forward toward a more equitable future. The time for our action is right now. Thank you very much to all the committee members and for your thoughtful consideration of this legislation.
Thank you.
If you have any questions, please, I have members of the collective here.
Seeing none, thank you very much.
Thank you.
I understand Aziza Robinson, who we called first, is here. Okay. Hey, Aziza, you'll have 2 minutes.
Okay. I apologize in advance if I go 30 seconds over time. Good morning, chairpersons and distinguished members of this committee. My name is Aziza Robinson Goodnight, and I'm here today as a committed advocate for reparations for American descendants of chattel slavery. And as someone who believes deeply that our Commonwealth has both a moral obligation and historic opportunity before it, I rise in strong support for Bills H4351 and H1753, and also rise with a broader message. Just as organizations like the NRA have normalized the regular passage of legislation to advance their interests year after year, we, reparations advocates, scholars, and impacted communities must also be moving reparations legislation continuously, consistently, and unapologetically. Reparations must not be a one-time gesture. They must become an ongoing legislative practice, because the harms we are addressing were ongoing, multi-generational, and systematic, and intentionally maintained. My primary concern today is to ensure that any reparations initiatives passed in the state is not symbolic and not in vain. It must be grounded in historical specificity, measurable harm, and a clear understanding of who the injured group is. The American descendants of chattel slavery. Our lineage, our history, and our injury must be centered, not diluted, generalized, or collapsed into broader categories of race-based disparity. We are a specific people with a specific claim. To accurately understand the scope of this injury, the work of Dr. Joy DeGruy is indispensable. Her framework of post-traumatic slave syndrome, or PTSS, is not simply an academic theory, it is a diagnostic lens through which we can understand the lived effects of 246 years of chattel slavery, followed by a century of legal apartheid, followed by generations of discriminatory public policy and economic exclusion. I'll go to the end. Bills H4351 and H1753 move us closer to that vision, but they must be designed and implemented with a clear lineage-based definition of the eligible group, strong protections against symbolic and watered-down outcomes. A mandate of PTSS and multi-generational harm is described through mental health initiatives, economic repair, and educational equity.
Thank you.
In closing, I urge, let these bills be more than a gesture. Let them be the structural beginning of a long-term reparations program in Massachusetts, one that acknowledges the harm, centers the people injured by that harm, and builds the conditions for true healing.
Thank you so much. Are there any questions? Quick comment?
Just thank you so much to everyone that's here, including yourself and your team and anyone who's supporting reparative justice. Massachusetts likes to rewrite history, and although we were the first state to abolish slavery, we were the first to make millions off of it and make it legal. And so I think this is incredibly important for the 246 years and the descendants in this Commonwealth to do something and to do it now. Thanks, Aziza.
Thank you.
Thank you very much. We're going to go to Bill S1175, an act prohibiting injurious operations or offering, excuse me, the full title isn't in here. The full title is not, you see that? Oh, great. So we have a panel to come up. Amelia Coco Gilardi and Courtney Gilardi. Is that panel here? Virtually. Are they online?
Can you hear me?
Yes.
Okay, fantastic. Thank you so much for allowing me to testify. My name is Courtney Gilardi. I'm from Pittsfield, Massachusetts. Esteemed legislators, thank you so much for allowing me to testify in support of S1175. By voting to support this bill, you will update current legislation to rectify a significant civil rights issue by ensuring there is a remedy for modern-day discriminatory acts and practices. This bill is a step in the right direction to fix some of the issues in the state law equivalent to ADA Title III. We must update these, and we must do it today. The amendatory language in Senator Mark's S1175 cements into Massachusetts statute that a physical environment or location is not required by adding or business after place and or offers products or services after patronage of. We're changing some words to come into alignment with ADA. Entities that do not operate traditional storefronts or offices but still serve the public by providing goods or services are now clearly covered. It would codify what the courts have already provided for. With your support of S1175, those in protected classes, those that are disabled, can breathe a sigh of relief knowing that their protection is not based on or dependent upon if the injury comes from a traditional storefront or not. With goods and services being offered in a variety of ways these days, protected classes need to know that their protection is not just dependent on a physical place. Times have changed, and so is the way we do business. Many goods and services are sold over the telephone or on the internet, with customers never physically entering the premise of a commercial entity to purchase these goods and service. To exclude the broad category of businesses, the reach of Title III, and limit the application of Title III to physical structures which persons must enter to obtain goods and services would run afoul of the purposes of the ADA and would severely frustrate Congress's intent that individuals with disabilities fully enjoy the goods, services, privileges, and advantages available to other members of the general public without discrimination. Disability doesn't disappear if a good or service is purchased over the phone or on the internet versus in a physical storefront. Please take this opportunity to update protections so that protection extends regardless of if people enter a physical storefront or not. Thank you so much.
Amelia, if you're on.
I think Amelia is in math class, and she's saying that she is just
Well, thank you
leaving her math class so she can step in the hallway to testify. She is a high school student.
What we'll do is we'll just continue on with testimony, and we'll call back. We'll get Amelia in a little bit, okay?
Yeah, if you want to just circle back to her, unless she's here. Okay, circle back to her. Thank you.
Yeah. Charles Ahearn, virtually.
I'm so sorry, it wasn't letting me unmute. Hello, it's Amelia.
Is this Amelia? Okay.
Yes, I'm so sorry, it wasn't letting me unmute. I'm here.
Go ahead. I know you're out of class, so.
Yeah. Good afternoon, my name is Amelia. I'm 17 and I'm a student testifying in support of S1175. I believe that this is so important that I'm taking time out of my class right now to kindly and with gratitude ask for your help. As a student, we're told that our voices matter, the children are the future, and that by speaking up, we can make a difference. I've been testifying on bills for over 5 years, and despite raising awareness, nothing has changed. You have the power to help them to change that today. I have testified on this bill in the last legislative session, and I'm asking for each of you for your unanimous support in supporting S1175 forward this session. The first thing passing this bill does is codifies into the Massachusetts Public Accommodation Act the Massachusetts and First Circuit judicial interpretations of what is and what is not a place of public accommodation under the federal ADA Title III and the state accommodation discrimination statute. 34 years ago, the Americans with Disability Act was signed into law. Unfortunately, all too often, the language used in our legislation fails to be updated to align with these protections.
Today, again, we are asking for you to remedy this and make this change for the better. Disabled people with visible or invisible disabilities should not have to work full-time educating, advocating, and fighting to receive the accommodations and protections that are granted to them but not clearly offered. Massachusetts is a leader in civil and disability rights. Please be a leader today. Your support of S.1175 will go a long way to ensuring your disabled constituents have real living protections that reflect the ADA, the Massachusetts Public Protection Act, and the time. Thank you for listening to your Massachusetts students and constituents, for your action and for your care. Thank you for supporting S.1175.
Thank you. Charles Ahearn, virtually.
Hello, can you hear me, committee?
Yes.
Thank you to all of you for allowing me this chance to speak with you. I am a neuroscientist and neuropsychologist trained at Wake Forest Medical School and at UC San Francisco Medical School, where I later taught. I wanted to let the committee know that I'm very well familiar with the scientific evidence that's been accumulating around this issue of damage from EMF, and I've been following this for over 12 years. And I congratulate you for considering this bill, because at this point the evidence has really become incontrovertible that there's serious damage being done to us, and really alarming as well. When I first heard about this some 12 years ago from a master's of public health, I made a psychological maneuver that I think many of us make that I wanted to note briefly, which is that I thought, well, this really must be psychosomatic. And it's not the case. It's positively not the case. And my retort now is, would that we were so lucky. So these are real biological effects, real biological dangers. I know many people in the course of my professional and personal life who would benefit greatly from the kind of accommodations you are considering. Thank you once again.
Thank you. Dr. Magda Havas? Virtually? Magda? No? Okay. Elizabeth Peterson, virtually? No, okay. Janet FitzGerald is also virtually. You might be muted. She needs to unmute herself. If you can unmute yourself. Janet, we can't hear anything if you are speaking. I think you need to unmute.
And then video, honey.
There we go.
Video?
Yes.
Yeah, so sorry. I'm really sorry. Had little tech issues this morning. All right, thank you. All right, thanks. All right, thank you, senators, for hearing us today. And thank you, Senator Mark, for your compassion and leadership and insights into the problem before us, which can be solved with support for Senate Bill 1175. My name is Janet FitzGerald, and I'm both a speech-language pathologist and a communication strategist. However, I can no longer work as a speech-language pathologist because many or most of the rooms in the schools and hospitals that I'd work in today are too loaded with EMF radiation, and so I get so sick with headaches and nausea and an inability to concentrate in those unhealthful environments. And that's such a shame because speech-language pathologists are in great need today. But as soon as this updating bill passes, I would be able to ask the hospitals and schools I'd work for the accommodations for making the rooms I'm in more EMF safe, just like I and many others like me diagnosed with EMF or EMR syndrome are now doing in our own homes. And the side benefit of that accommodation in those schools would be that most of those kids in those rooms would also be able to concentrate more. And the patients too in the hospitals I'd work in would also feel the difference. There's reams of science to back up our request for this updating accommodations bill. As the world-famous scientist here today, Dr. Magda Havas, can show you. But the FCC stopped sharing that science 28 years ago, amazingly, and has been sued by a U.S. District Court because of that betrayal to all of us. Or I should say all of us regular citizens. So we're all here on our own and turning to you, senators, to help protect us with the accommodations we need to work where we need to work and to live more safely where we need to live.
Thank you.
And that's the civil right, and that civil rights bill before us will give. Thank you very much.
Thank you. Shelley Wright, also virtually.
Thank you, esteemed legislators. I'm a retired teacher with EMS and a director of a national nonprofit organization, Canadian Educators for Safe Technology. We support students and teachers who are now injured by wireless microwave frequency radiation. The director of the Environmental Health Clinic at Women's College Hospital in...
Oh dear. For some reason you froze on our part.
Symptoms, which can be life...
It's on her end? She hasn't connected, okay.
To increase risk for brain tumors, strokes, and cardiac failure. Those who are severely impacted may not recover for days or weeks and may experience permanent injury. My submission cites studies demonstrating biological effects. Microwave frequency radiation is a potential cofactor for serious autoimmune and neurodegenerative diseases, including ALS, multiple sclerosis, and Parkinson's. Children with EMS have no choice. They must limit their participation in society to prevent serious or fatal injury. They no longer have access to hospitals, medical clinics, and public transportation, and other essential services, which were once wired, but now forcefully emit RF radiation, and if no one is actively using those signals. Adults are torn from their families when seeking remote RF-reduced wired places to live. RF-reduced areas, signage, and staff training can lead to inclusive access to medical facilities, the workplace, and transportation. In conclusion, I urge you to vote yes to Bill S.1175 to promote equitable, humane accommodations for people with EMS. Thank you.
Thank you so much for your testimony. Any questions? Okay. I'm going to see if Senator Lovely is on. If not, I'll call back. Senator Lovely was going to testify virtually. No? Okay, we'll just wait for her to let us know. Next bill is S1122, H1588, an act relative to immigration detention and collaboration agreements. Oh, I'm so sorry. What was your name? Yes, you did. I apologies. I had actually Cecilia Doucette for S1175 before we go to the next bill. Apologies.
Thank you very much. I'm Cecilia Doucette, Director for Massachusetts for Safe Technology. Please vote out favorably Senate 1175, an act prohibiting injurious operation or offering services or products that discriminate against or injure protected classes. The march of technology has caused significant changes to how business is conducted, how people obtain and use the necessities of life, and whether they can meaningfully participate in society. It's becoming evident that public facilities, products, and services can operate in ways that discriminate against and even injure people, including disabled individuals who may not want to use that product or service, but are nonetheless exposed. This creates discrimination, whether intentional or not. For example, children and adults on the autism spectrum or those with PTSD cannot go into a grocery store without risk of being injured. Those with multiple chemical sensitivities can't be in spaces with chemical emissions from carpeting, plastics, perfumes, chemically fertilized plants, paint, or cigarette smoke. Those sensitized to man-made radiation get triggered with environments with wireless radiation or dirty electricity. I will leave this radio frequency meter on loan with Grace Giordana for the committee to borrow so you can see these invisible exposures that we're all immersed in today. The ADA already recognizes environmental illnesses, but they provide no legal recourse. Did you know that Walmart now offers sensory-friendly shopping from 8 to 10 a.m. in the morning? Hotels are beginning to offer low EMF or electromagnetic field environments. It's time for Massachusetts to update civil rights law to reflect how business is done today to normalize accommodation for protected classes. Thank you.
Thank you very much for your testimony. Excuse me? Excuse me? Oh, okay, I was just wondering, I saw the top of your head. Okay. I'm like, who's in front? It's a press, okay. Eventually I was like, okay. All right, moving on to S1122, H1588, an act relative to immigration detention and collaboration agreements. And I just want, since I know that there's another hearing that people are competing with, so I'm just going to go ahead and say the bills, 3 bills that are coming up. There's testifiers under each one so that you can kind of gauge that, all right? So this is, I just mentioned S1122, act relative to immigration detention and collaboration. After that, it will be an act relative to the right to wear personal protective medical equipment. And then after that, an act ensuring access to equitable representation in immigration proceedings. Okay, those are the groups of bills coming up. All right, under the first one is an individual, Jaya Savita, here to testify individually. In person. Is Jaya online? Okay. Jessica Tang, virtually. Again, I'm keenly aware that these are similar topics, so I know people are between the two. So if your name is called here and you're over there, I see you, Jess, 1 second. We'll just add you, just let us know so we can call you in under the bill, okay? Okay, go ahead, Jessica.
Thank you. Chair Edwards, Chair Day, and members of the Joint Committee on the Judiciary, on behalf of the American Federation of Teachers, Massachusetts, and the over 25,000 educators, librarians, and employees working in schools and colleges across the state, I'm here to speak in strong support of S1122, an act relative to immigration detention and collaboration agreements, and the bills that will support our immigrants and communities. Massachusetts is home to a vibrant immigrant community and communities that contribute enormously to our schools, workforce, and neighborhoods, but many families continue to live with fear that a routine interaction with local authorities and those in power could lead to harsh and even unlawful consequences that have nothing to do with public safety. S1122 addresses this by limiting voluntary agreements between state or local agencies and federal immigration enforcement. These agreements, which are not legally required, erode trust and undermine due process and destabilize families. State public safety resources should be used on just that, public safety and keeping our communities secure. It should not be spent to require Massachusetts public safety officials to enforce and carry out federal immigration law enforcement. We represent educators, staff, and schools in a number of the state's gateway cities and communities with large immigrant populations: Chelsea, Lawrence, Lowell, Lynn, Boston, Fall River, New Bedford, and more. And we're hearing common themes from each of these communities. Attendance is down, enrollment is down, and fear is pervasive. Educators are going above and beyond to try to reassure students and families that schools and their surroundings are the safe spaces they should be. But the fear is real because parents have been detained on the way to dropping their children off at school. Students with work authorizations and status have been detained and sent out of state. Children fear that when they walk out the door, their family might not be there when they return, and we've also had students also detained because the school incident led to involvement of local police, and when information was shared, the federal agents arrived before the parents were able to. This bill would draw a clear line between local public safety functions and federal civil immigration enforcement, strengthening trust within the community, and provide these children and students more security so that they can come to school feeling safer. For these reasons, I respectfully urge the committee to report S1122 favorably. Thank you for your time, leadership, and commitment to justice and public safety, particularly for our students in the Commonwealth.
Thank you very much. Any questions? Seeing none. Jonathan Goldman. Virtually, maybe? Hmm? Oh.
Thank you, dear distinguished members of the committee. We cannot continue being complicit in fueling an immigration system that is driven by hate and fear, one that tears families apart, destabilizes communities, and treats human beings as disposable. That's why I stand in strong support of the immigrant justice bills H1588, S1122, as well as 1635, 1954, and S1127. My name is Jonathan Goldman, and I'm the Executive Director of the Student Clinic for Immigrant Justice, which trains and mobilizes college students across Massachusetts and Rhode Island to provide pro bono legal support to asylum seekers and organize for immigrant justice. Earlier this year, I received the phone call no one should receive, the one that made my stomach drop. It was from the son of one of my coworkers. My coworker is an immigrant, 7-year-old grandmother, mother, and someone deeply loved in our community. She was returning from a short trip abroad, and her son's voice on the other end of the line confirmed our worst fears. His mom had been detained. Fortunately, our community mobilized, organized, and fought like hell, and we got her released. But the truth is, her story is an exception. Thousands of our immigrants have been detained in cities and towns across the Commonwealth. Moments like this force us to confront a deeper question of who do we, as a city, as a state, as a country, want to be? Do we want to be a place where grandmothers are detained, where children are left on the curb watching their parents dragged away? These three bills offer us a different path. They help build the kind of community we all deserve. The key message remains the same across these: ensuring that police don't assist ICE in making civil immigration arrests, preventing the federal government from turning police into ICE agents via 287G agreements, and funding legal help to fight deportations. We are at a moral crossroads. How do we want to be remembered? What do we want our legacy to be? What is the story people will tell of each representative and senator up in this room and how they rose or failed to rise to this moment? Passing these bills is our way of saying no and saying that we choose compassion over cruelty, community over fear, a better future over a broken status quo. And I urge you to please vote favorably on these bills. Thank you.
Thank you very much. Any questions? Seeing none. Thank you. Up next, I have a panel with Julia Kupferman and Reverend Jamie Hinson-Reiger.
Reverend Jamie's on Zoom.
He's on Zoom. Okay, great. So you have 5 minutes total. Do you want the Reverend to start? Okay.
I'll start. Thank you. Good afternoon, Chair Edwards, Chair Day, distinguished committee. Thank you for the opportunity to be here. I'm the Reverend Jamie Hinson-Reiger. I'm senior minister at First Parish in Bedford. I also serve on the multi-faith leadership team that's been organizing weekly vigils at the Burlington ICE field office for 32 weeks now. I speak for myself today. I'm testifying in support of H1588, S1122, the Dignity Not Deportations Act. In our faithful witness at Burlington, we have heard story after story of families being ripped out of their communities and subject to all manner of abuses in detention, stories that shock the conscience, lack of food, lack of medicine, lack of privacy, the stripping of dignity, windowless rooms and 24-hour lighting, constant fear and uncertainty, all designed to dehumanize. I have stood beside people outside that ICE office when they learn the news that a parent, a son, a brother, a partner is not coming home. I've seen the fear, the devastation, the loss written on their faces, the tears streaming down their faces. Abuse and inhumanity is woven into this terrible deportation machine. We do not want Massachusetts resources to fuel and fund this machine. We do not want our police deputized to become agents of abuse to inflict harm on our neighbors. We ask for no 287G agreements, no jail beds used for ICE detention, and an end to the Plymouth Detention Center. I've heard the argument that the Plymouth Detention Center keeps immigrants closer in Massachusetts. The data shows immigrants have a very short stay in Plymouth, where they are subject to awful abuses before they are sent away out of state anyway. A report by Detention Watch Network shows that more beds is connected with more ICE arrests. We do not need to be collaborating with the deportation machine. Abuse and inhumanity are woven into this system. The values of my faith tradition call us to build communities where all are cared for. At Burlington, we are joined by hundreds of people every week, 750 people just last week, who are dedicated to an America that welcomes immigrants, people who believe that we can all thrive together and we are better when our communities are safe and whole. We love our neighbors, all our neighbors, including our immigrant neighbors, without exception. They belong here. Please join us in rejecting the deportation machine and supporting H1588 S1122. Thank you.
Chair Day, and members of the committee, thank you for the opportunity to testify in support of an act relative to immigration detention and collaboration agreements, H1588 and S1122. My name is Julia Kupferman. I am a Cambridge resident and the organizer for the Religious Action Center of Massachusetts. My organization represents about 14,000 households from the 39 Reformed Jewish congregations in the state. We organized the Reformed Jewish movement to pursue justice here in Massachusetts. As a Jew, the Torah commands me 36 times to welcome the stranger. Protecting and caring for immigrants is core to my faith. In this moment, with the current mass deportation campaign, it is clear that we must do all we can to welcome the stranger. H1588 and S1122 provides you, as Massachusetts lawmakers, the ability to take action in this crucial moment. Right now, local and state law enforcement in Massachusetts can enter into agreements with ICE to provide resources that tear families apart. This practice means that Massachusetts is complicit with the mass deportation campaign that is terrorizing our communities. This bill would end and prevent entering into contracts that deputize local agencies to act as ICE agents, and to prevent and shut down existing detention facilities. We know from the Detention Watch Network's report, if you build it, ICE will fill it, that the closer an immigrant is to an ICE detention facility, the more likely they are to be arrested by ICE. We know that ICE is using Plymouth Detention Center as a way station, keeping immigrants detained there for an average of 3 days before flying them out to larger detention centers in other states. We know that the conditions in Plymouth are well documented to be abusive and inhumane. You, as our leaders, must do everything in your power to disrupt the deportation machine that ICE is running using our state resources. This bill is one step in that direction by refusing to provide state resources to ICE operations. I urge you to report H1588 and S1122 favorably out of committee to ensure that Massachusetts lives up to its values of due process, safety, and dignity for all residents. Thank you for your time and consideration.
Thank you for your time. And are there any questions? Thank you.
Thank you, Senator. I'd like to welcome and recognize Representative Cataldo has joined us as well.
Up next, we have Juliana Morris. Maybe I'm virtually, maybe? Okay. Then we have Nithya Bandrina. Apologies for any mispronunciation. Oh, thank you. And then finally, we have Shalene Title. Nithya was virtually, by any chance, is she on? Okay. Next is H1981, an act relative to the right to wear personal protective medical equipment. First, we have Alex Mantis.
Hi.
Okay. Go ahead.
Thanks for the opportunity to testify today. My name is Alex Mantis, and I'm here on behalf of Fight for the Future, a privacy and anti-censorship org with 60,000 members in the Commonwealth. Today, I'm testifying in opposition to H. 1981. We believe that everyone has the right to cover their face for any number of reasons, and unfortunately, this bill would create more stigma and scrutiny toward masking, not less. And we find Section 3 to be especially dangerous to our civil liberties. Last year, we joined more than 40 rights organizations calling on lawmakers to defend the right to wear a mask for any reason. This in response to dozens of anti-mask bills intended to intimidate protesters protecting themselves from COVID, harassment and doxing, chemical irritants, and more. Since then, anti-mask discrimination has only escalated, especially toward Black, brown, queer, trans, and disabled people who are more likely to mask in public. This bill nobly intends to protect these folks, but it whittles down protections to only very specific medical equipment that enforcing parties deem, quote, necessary, forcing maskers to jump through hoops to prove that they're wearing the right mask for the right reasons. This fails to keep people wearing medical masks safe and denies protections to so many others. For example, folks who may mask to protect from invasive and racially biased facial recognition, or simply for fashion, warmth, or religious reasons. None of them should be treated as suspect. Most concerningly, Section 3 would create an unprecedented expansion of police power to force unmasking. These stop and unmask powers would violate the rights of thousands and subject our disabled, racialized, and immigrant communities to further surveillance and police harassment. Now, as we mask up and gather to reject our neighbors being snatched off the streets and growing fascist encroachment, Section 3 invites further crackdowns on our freedom of expression and equal access to public life. For these reasons, we urge the committee to table this bill and instead support comprehensive protections for mask wearing in Massachusetts, including a broad preemption of local mask bans and anti-discrimination legislation that protects everyone's right to mask at all times without exception. Thank you for your time.
Thank you very much. Amelia Abaf, commoners, virtually.
Hi, thank you. Can you hear me?
Yes. You
Honorable Chairs Edward and Day and members of the Joint Committee, my name is Amelia Abaf, commoners. Thank you for the opportunity to testify today and to do so remotely. I'm grateful that the Commonwealth has taken steps to protect this avenue to participation in public life and hope that you will adhere to the same principle on the topic of H. 1981. I'm testifying in support amended by removing Section 3 and by removing the word necessary from Section 2. I offer the perspective of a citizen whose family still masks in public spaces to protect our own health, to protect our baby who's still too young to be vaccinated, and to protect friends and family at even higher risk of severe complications from infections. My parents live in a county with a mask ban, and I have firsthand experience trying to spend time in a place where I'm constantly concerned that I could be put in a situation to choose between complying with the request of an officer or risking compromising my health and the health of my family. If a similar law were in place in the Commonwealth, it would make it very difficult for my family to travel, to do our jobs, and to live our lives here. On Section 3, it might be hard for you to imagine why removing a mask briefly is a big deal. When most people were returning to in-person but masked activity in 2021, they still lowered a mask to take a sip of water or found a quiet corner to unmask and eat lunch. That's not what it's like for those of us with underlying health concerns. We're the people who are still masking and leave the office and step outside for a sip of water, or skip meals when the only alternative is eating in a public place. For us, unmasking briefly isn't like cheating on a diet where you might slip up, but ultimately a few Oreos didn't derail the effort. It is all or nothing, where a single infection could severely impact our health, triggering new and permanent conditions, potentially disabling us, and have cascading impacts for our well-being, our livelihoods, and our families. Please consider this and remove Section 3 from this bill. On Section 2, I urge you to remove the word necessary. An officer or security guard should not be the arbiter of whether a mask is medically necessary. As written, this language sets those with invisible disabilities or vulnerable households up for conflict with law enforcement and will result in individuals sharing and worse, negotiating about private health information under extreme duress. Thank you.
Thank you very much. Are there any questions? Seeing none, we'll continue to Kim Ammons, virtually. Okay, we have a panel up next, virtual panel with Dr. Laura Germanis and Mr. Sam Halpert.
Thanks so much. I'm going to let Sam Halpert speak first.
Okay.
Thank you. I'd like to thank the chairs of this joint committee as I speak in conditional support of H 1981, subject to the removal of Section 3 and the word necessary from Section 2. I'm a non-practicing lawyer who has been working with volunteer groups over the last few years addressing mask-related legislation around the country and its implications for constitutional rights. In preparing, I've had the benefit of conversations with a colleague in Massachusetts who is versed in criminal procedure but who was unable to attend today. I'm testifying on behalf of the Massachusetts Coalition for Health Equity. We appreciate the intent of this bill. Individuals need the government to recognize and secure their fundamental right to safeguard their health, and this bill furthers that goal. We have grave concerns, however, with Section 3, which asserts that a request from law enforcement for an individual to temporarily unmask for identification purposes is acceptable. This request should not be acceptable. Section 3 concedes a security culture that does not exist and should not exist in Massachusetts. Massachusetts is not a stop and identify state, and the legislature should refrain from codifying a police prerogative to identify residents, especially at a moment when many people in Massachusetts and across the country are desperately concerned about the federal government's sweeping new use of tools for mass public surveillance in pursuit of authoritarian goals. But Section 3 goes beyond acknowledging a police interest in stopping and identifying residents to an interest in stopping and unmasking them. Even if the bill were modified to include a reasonable suspicion standard, as stop and identify laws do, both the U.S. Supreme Court and the Supreme Judicial Court's precedents suggest that a police power to request identity from residents is not acceptable under relevant constitutional privacy protections if the request becomes more intrusive on a person's fundamental rights than already contemplated by a typical Terry stop. In Heibel, the U.S. Supreme Court reasoned that, quote, the Nevada statute does not alter the nature of the stop itself. In Massachusetts, courts commonly observe that, quote, not every encounter between a law enforcement official and a member of the public constitutes an intrusion of constitutional dimensions requiring justification. But a request that a person remove their mask is intrusive in a way that verbal questioning about their identity, or even a request to view but not retain identifying documents, is not. It alters the nature of the stop. It constitutes an intrusion of constitutional dimensions. It intrudes on constitutional rights, including the right to protect one's health, which this bill seeks to secure, but also rights of religious freedom and personal expression. As written, this bill does not simply recognize a police prerogative to ascertain residents' identities. It recognizes a police prerogative to remove residents' masks. Additionally, we would request that the committee strike the word necessary from Section 2. Securing an interest in necessary medical protective equipment will lead to problems with the law's implementation, as police, individuals, and courts dispute what protections are necessary and whose judgment should control that determination. Thank you for your efforts in this area, and we hope you will consider this friendly request.
Thank you.
Thank you so much, and honorable chairs and members of the committee. I am also here to testify in support of H 1981 as amended by removing Section 3 and by removing the word necessary from Section 2. I testify on behalf of the Massachusetts Coalition for Health Equity, of which I am a co-founder, which is an organization of hundreds of healthcare workers, patients, and community members advocating for increased equity in Massachusetts. I am a practicing family physician, an instructor in medicine at Harvard Medical School, and a member of the People's CDC. I speak on my own behalf and on the behalf of the coalition. First and foremost, I want to express a concern, as has already been mentioned by others, that respiratory viruses are best prevented through wearing masks. And even during brief periods of exposure in crowded indoor spaces, people can be infected with viruses such as COVID-19, measles, and other respiratory pathogens. Repeated infections with COVID-19 in particular can increase the risk of serious illnesses, including heart attacks, blood clots, strokes, and diabetes. This is why legislation is so vital to protect the right of individuals to wear a mask and also their own autonomy to determine when and how a mask should be removed. And that is the reason why removing Section 3 and the word necessary from Section 2 is so important. It's not for a police officer or a security guard to decide which mask is necessary. The autonomy to make one's own medical decisions should remain in the hands of the individual who is wearing the mask. Furthermore, for people who are wearing masks but are not visibly sick, the notion that their autonomy to protect themselves could be questioned or that they could be required to disclose their medical information in order to preserve their rights to mask is an infringement of their privacy. I personally wear a mask to protect high-risk members of my household. If I am required to remove my mask, I could become infected with a virus that I could potentially transmit to them before developing symptoms. Thank you so much for considering our testimony, and I do hope that you will consider our request. Thank you.
Thank you very much. Are there any questions? Seeing none, thank you. We have Representative Sina.
Well, good afternoon, everyone. Thank you, Chair Day and Chair Edwards and members of the committee of the judiciary. I'm here today to testify in support of H4115, an act relative to preventing immigration reporting and ensuring the rights to legal counsel. Our immigrants need help right now. They face constant fear from the federal government. Our immigrant community lives in fear. They are afraid of going to work, afraid of going to medical appointments, afraid of going to even grocery stores. It is morally wrong what's happening in our country right now. This legislation does two things. One, it gives immigrant peace of mind by ensuring that local and state law enforcement officials do not report immigration information to federal authorities. And the second part of this bill would assist with legal service in terms of cost for legal representation. It ensures funds is permanent, and it allows the funds to take advantage of grants and nonprofit donations. It should also not be controversial to say that everyone deserves a lawyer, but according to Vera Institute of Justice, 39% of people facing deportation in Massachusetts do not have legal representation. I'm also here in support of H4684, an act ensuring law enforcement identification and public trust, and also H1954, an act ensuring access to equitable representation in immigration proceedings. And I thank you for your time today.
Thank you. Are there any questions? Seeing none, thank you, Representative. Going on to Bill, and again, the next couple bills that we have, S1127, H1954, an act ensuring access to equitable representation in immigration proceedings. Then we have an act prohibiting body size discrimination, and then an act to promote the health and safety of people in the sex trade. Those are the bills that people have signed up for. Then we will have a list. We have a big list of folks who signed up today, okay? For the act assuring access to equitable representation, we have Connor Murray in person.
Good afternoon. Thank you for convening the Judiciary Committee to hear testimony on these important bills. I'm here in support of H1954 and S1127, an act ensuring access to equitable representation in immigration proceedings. Specifically, I want to address the risk to those under wrongful detention. In September, the U.S. Supreme Court granted an injunction allowing Immigration and Customs Enforcement, ICE, to detain individuals based on race and ethnicity. Besides the obviously racist implications of this decision, it raises the potential of accidental or, God forbid, intentional detention of U.S. citizens. Citizens have the absolute right to legal counsel, but under the current law, those in custody for immigration violations are not afforded that right because it's technically a civil infraction. Therefore, it is not unthinkable that a U.S. citizen could be detained or even deported simply because they do not understand the complexities of the legal system or cannot afford an attorney. That's not right. It's kidnapping. An exploitation of this loophole could be catastrophic to those directly affected, as well as the legitimacy of our criminal justice system. The passage of this bill would amend that gap in due process within the Commonwealth and reinforce Massachusetts' status as a national leader in equity and justice. I will be submitting written testimony and welcome your questions if you have any.
Thank you very much. Any questions? Seeing none, due to my mistake, there's a Naomi Bar Yam, who had signed up and is virtual for the previous bill. So I want to call her in before I go on to the next panel. Naomi?
Yes. Can you hear me?
Yes.
Thank you. Thank you. And to Chairs Edwards and Day and members of the committee, my name is Naomi Baryam. I'm speaking as a public health advocate with the World Health Network and the parent of an immunocompromised child. I urge you to report 1981 favorably out of committee and to amend the bill, as others have mentioned, to ensure that it fully protects civil liberties as well as personal health autonomy. H. 1981 affirms a fundamental right to protect ourselves and our families using basic health equipment like masks. For those of us who are or are loved ones and caregivers of medically vulnerable people, wearing a mask in public spaces is not optional, it's essential. And increasingly, people are being questioned, excluded, and even harassed. So this bill matters. However, the bill as currently written includes two sections that could unintentionally harm the very people it aims to protect. Section 3 allows law enforcement or security to require people without any cause to remove their masks for identification. This could conflict with Article 14 of the Massachusetts Constitution, protecting individuals from being compelled to identify themselves without consent. And Section 2 says that wearing protective equipment is allowed only when, quote, necessary. But who decides what's necessary? That vague language risks placing decisions about individuals' health in the hands of police, employers, or security staff, not medical personnel, and not the individual. So we requestfully ask that the committee support H. 1981 with these two key changes: remove Section 3 and remove the word necessary from Section 2. Let's pass a strong right to mask law in Massachusetts, one that truly defends both autonomy and civil rights for all Massachusetts residents. Thank you.
Thank you very much. Continuing on with an act ensuring access to equitable representation, we have a panel with Gina Frank, Dan Hoffer, Pablo Ruiz, and Lindsay Keeney. Ready to go? You coming? All of, just three of you, or?
Lindsay Kenny is here. Senator, just so you know, we had submitted a list of testimony and panels. We're happy to do it in this order, but we had submitted a list to your staff, like in the order of like our principals and stuff like that.
We have several panels listed here, so there might be, we might have broken up your list, or no?
I think it's just resorted a little bit, but that's fine. We can roll it.
They handed it to him outside. I'll get you a list.
Okay, we'll start here and then we'll figure it out. Okay.
Good afternoon, Chair Edwards and Chair Day. My name is Kevin Brown. I'm testifying in place of Pablo Ruiz, our political director. I'm the Executive Vice President of SEIU 32BJ. We represent 21,000 Massachusetts property service workers, janitors, security officers, airport workers, and more. Most of our members happen to be immigrants. That's why I came to testify in support of the principles, and not just H. 1954 and S.1175, but all of the various immigrant defense bills, and including Access to Justice, Immigrant Legal Defense Act, and Dignity Not Deportations. Each of these bills contains components of what the legislature can and must do to ensure that local police don't assist ICE in making civil immigration arrests, to prevent turning police into ICE agents through the 287G program, and to fund legal assistance and against deportation. I'll focus on the legal assistance, which would be achieved by passing the Immigrant Legal Defense Act. Most of our members, fortunately, do have legal representation through our legal fund, which covers 100% of their attorney fees. In the first Trump administration, that fund helped a lot. This time, the situation is even more dire. Hundreds of thousands are being stripped of their legal statuses. Others are being detained despite having work authorization, and ICE's budget has effectively tripled. Yet there is still no right to a government-paid lawyer at these courts. In Massachusetts, a shocking 54% of immigrants with pending cases are navigating their proceedings without a lawyer. Yet we know that detained immigrants with a lawyer are 10 times more likely to win their case than those without. It's only fair that Massachusetts residents have real access to justice. Similar programs exist in California, Colorado, Illinois, Nevada, New Jersey, New York, Oregon, and Washington. It's time for this Commonwealth to step up. Thank you for, hope that you'll support S.1127 and H.1954.
Good morning. Thank you, Chairs Day and Edwards. My name is Dan Hoffer. I'm the Political and Legislative Director for SEIU Local 509. One of our members, Ramesa Ozturk, was snatched from the street on her way to have dinner with loved ones. In the video that was circulated to the media, you can hear her terrified, asking the masked individuals who approached and detained her, "Can I call the police?" One of them replied, "We are the police." Then they put her in the back of an SUV and drove away. What happened to Ramesa was not an isolated incident. It was a result of a system that has allowed ICE to operate far beyond the bounds of public safety and increasingly pressure local police across the country to become a part of that system. We do not need local police to serve as an extension of ICE to terrorize workers, parents, and community members. We have a responsibility to protect our neighbors. Our union believes in the dignity and safety for every worker and community member. What is happening across the country has made it clear that those values are at risk unless elected officials act. Our coalition, as a coalition, we are unified on 3 reforms that would make a difference now and should be included in this legislation. Police should not assist ICE. Police should not turn ICE, police departments should not turn officers into ICE agents, and the state should sustainably fund legal help to fight deportations. We urge you to include these reforms in this and any legislation that is advanced. Thank you.
Hi, chairs, members of the committee. My name is Lindsay Kenny. I'm the legislative director for the Massachusetts AFL-CIO, which represents over 500,000 union members in the Commonwealth and over 800 local unions. The protection of immigrant workers was a priority for delegates to our biennial constitutional convention this year in October, where we passed a resolution outlining our support for the policies proposed here today in this conversation and before you in the legislature. We support policy and legislative efforts to protect our immigrant community through preventing employers from using immigration status as a tool of retaliation against workers who raise complaints about safe working conditions and wage theft or engage in protected concerted activities. The Massachusetts AFL-CIO and our immigration working group support banning new 287G agreements in Massachusetts to prevent local law enforcement from being deputized to act as immigration agents and encourage the use of virtual immigration hearings, reducing burdens for families and minimizing the trauma for those detained. And we support prohibiting informal collaboration between immigration agents and state and local law enforcement. We also asked the legislature to strongly support providing legal representation for immigrants in detention. The labor movement is only as strong as our most vulnerable members, but as we all know, we are strongest when we are together. Thank you.
Thank you very much. Before you go, could you list the states again so we would not that have a similar program of legal defense?
California, Colorado, Illinois, Nevada, New Jersey, New York, Oregon, and Washington.
Thank you very much.
Senator, can I clarify that there was $5 million included in the FY26 budget,
Right.
as I know you know, but just so that everyone is, and that's amazing and such an incredible start, and we need that to continue, and we need it to sort of not be a thing that's subject to the whims of, not subject to the whims, but like we need things that are
Nothing is subject to the whims.
Yeah.
In this building, it's thoroughly vetted and gone back and forth by many of my colleagues.
But as someone who's tried to come back year to year, being like, okay, this needs to be funded this year, also this year, like, is it going to be funded at a higher or lower level? No, we need to ensure that due process, like when we are seeing violation of civil rights, when we are seeing violation of due process, that every single person who needs an attorney, like you all don't have control over ICE and the unspeakable things that they're doing, but you do have control over that.
I would just also like to note that this is consistent with Labor's position on access to counsel, so that this is not new that Labor stood up for attorneys and representations for indigent or poor people and who are losing their homes. That's the access to counsel bill. So this is, I think, part and parcel with your continued stance for vulnerable populations to have due process.
Thank you, Senator.
Thank you very much. Okay, so I do have the panel list, but I'm not just going to call 8 panels in a row. I'm going to in between with individuals who signed up. So We already did Connor Murray. So the next individual, since we just did a panel, would be Siobhan McDonough. Is Siobhan here? Okay. We're going to go back to the panels then. The panel list would have Wendy Wayne. Wendy Wayne, is she here? Yes. Yeah, go ahead. This is.
Good afternoon, Chairwoman Edwards, Chairman Day, and members of the Joint Committee. My name is Wendy Wayne. I'm an immigration policy expert focusing on expanding access to counsel in immigration proceedings and immigration enforcement, and I'm testifying today in support of Senate 1127 and House Bill 1954. This legislation seeks to improve access to fair and equitable legal representation for low-income Massachusetts immigrants by funding attorneys to represent them in removal or deportation proceedings. As you heard from a prior speaker, more than 55% of individuals in immigration court in Massachusetts are currently unrepresented. For those who are detained, the percentage is even higher. Yet research has consistently shown that those who are represented by a lawyer are at least 5 times more likely to win their immigration case if they have counsel. And for those who are detained, they're 10 times more likely to be successful and win relief that they are legally entitled to. Beginning in 2013, states and cities around the country have funded programs similar to what's envisioned in this bill, and you heard about that from a prior speaker. Understanding, and they do so because they understand there's not only a societal benefit, but also an economic benefit in providing legal representation to immigrants and in keeping long-term, hardworking immigrants in their communities. Several studies over the last 10 years have shown the economic benefit to providing legal representation to immigrants in deportation proceedings. Basically, providing representation costs less than the money lost, the revenue lost, when primary wage earners from families are deported because they couldn't defend themselves. This bill will provide state funding for legal service, but also allows for private funding to be raised to bolster overall funding of the program. It ensures that legal representation is provided based on recognized best practices. It includes a structure that has been recognized by experts around the country in the field as providing quality and more equitable representation, and similar to what's been successfully implemented in other states. It also includes the establishment of an advisory board to oversee the program. It's time for Massachusetts to join other states around the country who've invested in immigrants in their communities by ensuring that they have due process in these critical proceedings, and I request that you favorably report this out of committee.
Thank you very much. Any questions? Seeing none? No problem. Liz Sweet? Mira?
Thank you. Good afternoon, Chairwoman Edwards, Chairman Day, and members of the Joint Committee. I do want to just note that we had expected my colleague to speak in advance of my comments, but I am here particularly to talk more in depth and in support of the Immigrant Legal Defense Act, or Senate 1127, H2580. My name is Liz Sweet. I serve as the Executive Director of the Massachusetts Immigrant and Refugee Advocacy Coalition. And as many of you are aware, MIRA is a membership coalition of more than 150 member organizations serving immigrants across the Commonwealth. We also operate a number of direct programs serving immigrants, including providing basic legal services. And through all of these experiences and touch points, we hear such a common drumbeat of the lack of sufficient quality legal services, particularly for our most vulnerable immigrants, those who are in detention and those who are facing removal proceedings. Immigration court proceedings are incredibly complex proceedings, and the stakes are so high. The stakes can potentially include permanent family separation. They can include deportation, often to places where people have grave fears of return. As ICE arrests in our communities continue to increase, that need for representation is only growing and truly eclipsing the existing services. We want to acknowledge, which has already been stated, that we are truly grateful to the State House for having allocated $5 million in support of immigration legal services earlier this year in the state budget. That funding allowed the Office of Refugees and Immigrants to carry out the state contracting process, which did result in, just last week, the MIRA Coalition signing a contract to implement on the new Massachusetts Access to Counsel initiative. We are proud to be standing up a program that will add the capacity in partnership with 14 legal organizations across the Commonwealth, CPCS, and others. We will add 24 new immigration attorneys to accept cases, particularly for those folks in removal proceedings and in detention. We are working to make that program fully operational. Our intake line is now working, and we've onboarded our team as well as working with our partners to ensure that they are staffed, and expect to have full caseloads in the coming weeks. However, we need this to become an ongoing program, and hope that you will favorably report this bill out of committee.
Thank you. Thank you very much. We have a panel: Maroni Winter, Gavi Wolf, Carrie Medina.
Good morning or good afternoon. I'm not sure what time it is right now, but good morning, Chairwoman Edwards and Chairman Day and members of the Joint Committee. My name is Maroni Mentor. I'm a proud immigrant from Gabon. I'm here on behalf of MIRA and Protecting Massachusetts Communities Coalition, which came together in response to this administration's escalating attacks on immigrant communities. Today, we urge you to advance several bills, including what was already mentioned, Immigrant Legal Defense Act, but I also wanted to talk about access to justice, which is H.1175. At the same time, I should mention that a member of our coalition are also testifying in the Public Safety Committee in support of the Safe Communities Act. Together, these bills have critical related provisions. One, ensuring that local police do not assist ICE in civil immigration arrest. Two, banning 287G agreement that deputize local police as ICE agent. And three, fund legal representation so immigrants can defend their cases. The federal government has launched aggressive mass deportation, aiming for 1 million removal a year, and that's about 3,000 people per day. And we all know that ICE cannot meet these targets without police. That's why 287G agreement have skyrocketed nationwide from 135 in January to now 1,200 as of today. Even if one police department in Massachusetts joins, community trust will be collapsed. We have already seen the consequences of fear at home. In Framingham, for example, a single rumor of ICE activity kept 2,500 students out of school. ICE arrests in Massachusetts are up 336%, and nearly 80% of those detained have no criminal history. When people believe police are working with ICE, crimes go unreported and witnesses remain silent. And if immigrant workers stay at home or are deported, our businesses and economy suffer. Massachusetts could now lose an estimated 148,000 workers. These aren't just abstracts. They are abstract numbers. They are impact on families. When a home health aide is deported, patients lose the care that they need. When a child care provider is taken, parents scramble and classrooms close. When a construction worker disappears, house production slows even further. Massachusetts must not allow its police department to become extensions of ICE. We must bend to 287G agreements, and we must ensure that every immigrant has access to legal representation when the future is in the line. Thank you for your time and for your commitment to protecting Massachusetts immigrants.
Good afternoon. My name is Gavi Wolf. I'm here on behalf of the ACLU of Massachusetts and the Protecting Massachusetts Communities Coalition. And in the interest of time, I'm going to focus in on 287G agreements. I just want to make 3 points. First, these agreements have absolutely nothing to do with whether sheriffs rent beds to ICE for immigration detention. That's a whole other kettle of fish. 2, the reason the 287G program is so dangerous is because police do secret double duty as ICE agents. When somebody is stopped for a traffic violation or needs to report a crime, they have no way of knowing if the officer they're talking to is also acting on behalf of ICE. And when people can't trust the police, that is harmful for everybody's public safety. And third, 287G agreements, banning 287G agreements is urgent and timely because there are brand new financial incentives that are going to seduce departments around the state. The Trump administration has pumped billions of dollars into immigration enforcement and will now cover all 287G costs. And they will even pay bounty-style bonuses. So the more people you bag for ICE, the more you get paid. Those incentives pose a clear and present danger to the integrity of Massachusetts law enforcement. Thank you.
Good afternoon, Chairs Edwards and Day, and members of the committee. My name's Carrie Medina. I'm Executive Vice President at 1199 SEIU. 1199 represents over 80,000 healthcare and home care workers, from native-born to those who chose the state as their home. That's the diversity of our members' union. Every day, 1199ers care for us in every setting, no matter a person's background. And 1199ers care for their co-workers, patients, and communities that are being terrorized by ICE. 1199 SEIU and my SEIU family of nearly 150,000 workers are proud to support the Protecting Massachusetts Communities Coalition. The unjust attacks on immigrants should not be funded by Massachusetts taxpayers. The fear that our immigrant community is facing isn't making us safer. It is undermining the trust between immigrants and the law enforcement. On behalf of those who care for Massachusetts, we urge you today to care for residents by not assisting ICE, restricting law enforcement to act as ICE agents, and funding legal support to immigrants facing dedocumentation and deportation. Our members and those we care for are looking for action from you, our elected leaders, in this moment. These priority protections ensure that families know they can trust local law enforcement and have the legal support they need if they face deportation. Thank you so much.
Thank you so much. Thank you. Any questions? Seeing none, thank you. Jen Klein.
Good afternoon, Chairwoman Edwards, Chairman Day, and members of the Joint Committee. My name is Jen Klein. I am the Director of the Immigration Impact Unit at CPCS, the Massachusetts Public Defender's Office. Thank you for the opportunity to testify in support of Senate Bill 1127 and House Bill 1954. Immigration court is a complex legal system where the government is always represented by trained attorneys, but immigrants are not provided counsel to defend against deportation. Despite being detained in prisons and jails, and the system looking and functioning much like the criminal legal system, there is no right to appointed counsel for indigent immigrants in removal proceedings. Over 55% of individuals appearing in immigration court in Massachusetts are unrepresented. As ICE enforcement increases, that number is at risk of increasing. For people who've spent decades making Massachusetts their home, or those more recently arrived seeking protection and refuge from persecution in their home countries, their only hope might be a lawyer standing next to them. At a time when our immigrant neighbors and communities are under attack, passage of this bill will create an extraordinary opportunity to expand meaningful representation to immigrants across Massachusetts. This funding will begin to ensure that every person receives the dignity, due process, and humanity they deserve when faced with the power and strength of the federal government. This funding will keep families together, protect our local economy, and protect due process and the rule of law. We're grateful to the legislature for including similar funding in the fiscal '26 budget. With those funds, MIRA and CPCS are building a team of attorneys who will provide representation to those in removal proceedings, both detained and non-detained. We're embracing the tenets of public defense and envision a program where representation is zealous and client-centered. To set the highest level of representation, we're creating and implementing standards of practice for immigration representation similar to those instituted for all other attorneys appointed by CPCS. Our attorneys will stand as a bulwark between the individual and an immense and often dehumanizing immigration system. We would ask you to continue to support this work by funding this bill and making sure that this work can continue, representation continue, and people will get the help that they deserve.
Thank you very much. Any questions? Seeing none, thank you. We have a panel of Robin Nice, Laurie Millman, and Helena Da Silva Hughes. 2 are virtual and 1 is in person. So we'll have are Laurie Millman and Helena Da Silva online?
Yes.
Okay. So in total, you have 5 minutes.
Thank you. Thank you. Thank you so much for having us here today to speak on this important topic. My name is Robin Nice. I'm an immigration attorney at a small firm where we have represented thousands of immigrants, primarily asylum seekers, for more than 13 years. I've seen firsthand many times that having an immigration attorney makes a world of difference. It can literally be the difference between life and death for many people. I often consult with potential clients who don't think they have a strong asylum claim, but they do. They might be a survivor of domestic violence, they might be a member of the LGBTQ community, but they might emphasize the wrong things when they initially tell their story. They need an immigration attorney to help them understand the legal landscape so that they can possibly navigate it. These individuals would fall through the cracks and get deported to places where their lives are in danger without help of an immigration attorney to translate the legalese and guide them. I've been taking on more pro bono cases at my firm in recent months, as ICE has indiscriminately detained more and more people and send them to immigration court proceedings. But our nonprofits are already bogged down. Our private firm can't absorb all the private firms can't absorb the need that is left. And these pro bono clients include the most vulnerable, young children with debilitating medical conditions, a high school junior who was held in abysmal conditions for 6 days. One day he wasn't allowed to contact his parents, so they had no idea where he was, a blind man, a man in a wheelchair, and DV survivors. We need a permanent solution to this permanent, or at least permanent for now, and systemic problem, and the ILDA will do that. It's hard to understand or justify that we don't appoint lawyers for individuals who are, again, facing deportation, which can be tantamount to a death sentence, but we do appoint lawyers for those who might face probation or a few days in jail, not to minimize that whatsoever. But these are folks being sent into courtroom in an unfair battle. They're being sent against deportation judges, as Trump is now advertising it, and they deserve a fair shot, and that's all that this funding will do. It'll give them a fair, equal opportunity to pursue what they're legally entitled to pursue. Thank you.
Laurie Millman?
Yes. Good afternoon, Chair Edwards, Chair Day, and distinguished members of the committee. My name is Laurie Millman, Director of Center for New Americans, a nonprofit education and resource center welcoming immigrants in Western Mass. I support the priorities of the Protecting Mass Communities Coalition and am testifying in support of S.1175, H1954. Center for New Americans is honored to participate in the Massachusetts Access to Counsel initiative. We commend the legislature for allocating the funds to make it possible for immigrants who must appear in court to receive legal representation. We know from published data that immigrants with legal representation have a better chance of actually receiving the due process, which is their constitutional right. We believe the act ensuring access to equitable representation would make due process a reality for more people on a more consistent, longer-term basis, especially in a region like Western Mass, where we are one among very few immigration legal service providers. Many of our Haitian students, young families who entered the country legally in hopes of receiving safe haven, are now in removal proceedings. They followed the rules, they applied for employment authorization, got jobs, enrolled children in school. They could not have anticipated that national policies would would change so dramatically. Don't we owe Daphne and Charlene, Andre and Rolando, nurse aides, construction workers, manufacturing staff the chance to tell their stories with the support of an attorney so that an immigration judge might actually recognize the challenges that they fled and the ways they hope to contribute to the community? Our legal team is so excited to finally be able to offer our neighbors the opportunity for a fair hearing in court. We thank you in advance for considering passage of the Act to ensure access to equitable representation so that we can continue to do the important work of providing representation. Thank you.
Helena Da Silva Hughes?
Yes.
Go ahead.
Yes, good afternoon, chairpersons and members of the committee. Thank you for the opportunity to speak to you today. My name is Helena Da Silva Hughes, and I am the president of the Immigrants Assistance Center in New Bedford. We serve thousands of immigrant families across southeastern Mass, and I am here to express strong support to the Immigrant Legal Defense Act. Bristol County is truly a legal desert. There's a severe shortage of pro bonos and low-cost immigration attorneys in our region. Most immigration legal services are concentrated in Boston, leaving families in New Bedford, Fall River, and Taunton, and the surrounding towns with almost no access to representation. Because of the lack of access, many of our clients become victims of immigration scams. They turn to notaries or attorneys who have no experience on immigration, who promise to help them, but provide false information, take their money, and sometimes cause irreversible damages to their cases. We see these consequences every day. Even today, before I testified, I spoke to a family that had spent thousands of dollars on an attorney who took their money and did nothing. So these families are losing their savings, missing deadlines, and being put at risk of deportation simply because they cannot afford a legitimate attorney. We know that legal representation works. Immigrants are 5 times more likely to win their cases when they have an attorney. Without legal representation.
Thank you, sorry. We can, if you will submit the rest of your testimony in writing, then the committee will have it. Thank you.
Sure.
Just want to represent, go ahead.
Nope, just recognize and welcome Vice Chair Fluker Reed has joined us as well.
Thank you. Up next, we have another panel with Gladys Vega, who's virtual, Gerald Gabu, virtual, and Patricia Sobalvaro, who is in person. Hi. Are the other two online? Do we have the other two?
I'm here.
Oh, excellent. And then I think Gladys will join. Okay, go ahead. You have 5 minutes total. So we're going to do in person, and then we'll go to you.
Good afternoon, Chairwoman Edwards, Chairman Day, and members of this committee. I am Patricia Sobalbarro, the Executive Director of a grassroots immigrant-led organization, and I'm also a member of the Protecting Massachusetts Communities Coalition, here to provide support for the Immigrant Legal Defense Act. Agencia Alpha serves more than 1,200 individuals through our legal, citizenship, and organizing programs. This past summer, in less than 6 weeks, 34 of our constituents were detained and arrested by ICE on their way to work. Unfortunately, 15 of those hardworking but low-income individuals have been deported back to Guatemala or Honduras because they did not have access to an immigration attorney. For someone who earns $15 an hour and to be told that they have to pay $300 for 30 minutes with a private attorney, it's inconceivable. Now imagine when they are told that to represent them, they have to pay $10,000, $15,000, $20,000. And the reality is that our constituents are left with 2 choices: to face immigration proceedings without counsel, or to accept their fate of an imminent deportation separated from their families. But passing the Immigrant Legal Defense Act will give low-income immigrants who can't afford a private attorney a fighting chance in immigration court. Thank you for your time.
Thank you. I think Gerald, go ahead.
Yes. Good morning, everyone. And my name is Dr. Gabo with IFSI, Immigrant Family Services Institute. So I am here because our organization is at the forefront of serving and welcoming immigrants, with dignity and respect. And we know for the past few months, we have not seen any of that in the way that ICE has been treating our community. So I'm here to testify on all of the 3 bills that we have in front of us, not only the Access to Justice, the Immigrant Legal Defense Act, and dignity, not deportation. And because we know each one of those bills has a way to really protect our community. And here at IFC, we have seen firsthand, the fear that our community face when ICE is in our community. When we hear that our police forces are working in collaboration with ICE, this really diminishes the trust that our community needs so they can safely go to their medical appointment, call if there is any issue, call the police, building that partnership that we all need so our communities can flourish. So all of those 3 bills, they have a significant impact on our community. And I really want to emphasize that we need our police to do their jobs to protect our communities and not working for or on behalf of ICE. And again, we urge the legislature to take action to protect our communities by passing those 3 urgent reforms that are needed right now. Thank you so much.
Thank you. I'm not sure if Gladys Vega's joined us. I don't think she's on. Okay. Thank you very much. Have any questions? Seeing none, thank you. Our next panel is Laura Rotolo, Julia Schlossman, and David Albright.
Good afternoon. David Albright was unable to join us, so it's just us. Good afternoon, Chair Edwards, Chair Day, members of the committee. My name is Laura Rotolo, and I am here today on behalf of the ACLU of Massachusetts and the Protecting Massachusetts Communities Coalition. ICE has gone too far. Immigration arrests in Massachusetts are up more than 300% since January, and enforcement is becoming more indiscriminate and more violent. So the question is, what can this legislature do? And we are urging 3 concrete steps, which you've already heard several times today. But look, you're already showing up for immigrants. You've put legal aid funding in the budget, and you're having ongoing communications with your community, so thank you for that. But we're fighting an uneven fight against a massively funded federal deportation machine. Our 3 priorities, one more time, are number 1, don't assist ICE, don't turn our police into ICE agents, and number 3, fund legal help to fight deportations. You have several bills before you today. In addition to the Immigrant Legal Defense Act, you also have H.1635, Access to Justice, and Dignity Not Deportations, S.1127, and H.1588, which all include components of these priorities. So let me briefly focus on priority number 1, informal collaboration with deportations. This is where the harm happens quietly. Informal collaboration could look like police pulling over a vehicle while an ICE van waits behind them, allowing ICE to use official buildings or parking lots as staging areas, tipping off ICE about release times and court appearances, providing information that is not available to the public. This kind of collaboration harms communities and diminishes trust in public institutions, and we do not need to be a part of it. We do not need to participate in this. 10 states, in fact, already limit these kinds of informal collaborations, and Massachusetts must do the same. I'll pass it to my colleague to speak about the dangers of formal collaboration with ICE.
Chair Edwards, Chair Day, members of the committee, my name is Julia Schlossman, and I'm Senior Staff Attorney at the Jewish Alliance for Law and Social Action, which is part of the Protecting Massachusetts Communities Coalition. I'll be speaking about banning 287G agreements, which are contracts between state or local agencies and ICE, whereby state or local employees are deputized as ICE agents. First, however, I would like to acknowledge several bills before this committee, namely Dignity Not Deportations, Access to Justice, and the Immigrant Legal Defense Acts. Each of these contains important provisions. Banning 287G deputization agreements is possible, constitutional, and crucial, and 7 states already do this. Under the most popular type of agreement, local law enforcement or other types of governmental agencies are empowered to arrest immigrants while still wearing their local uniforms. Let me be clear. 287G agreements are distinct from detention agreements, such as the one in Plymouth County. barring Massachusetts agencies from participating in the 287G program has no bearing on whether immigrants will be sent out of state once detained. The administration has consistently stated that the 287G program is central to its plans for mass deportations. Nationwide, the number of 287G agreements has risen nearly ninefold, from 135 on January 20th to nearly 1,200 today. Thanks to funding from the Big Beautiful Bill, DHS recently announced that it would cover salaries, benefits, and overtime for 287G officers, along with bonuses for apprehending immigrants. We cannot give in to the administration's dark vision, where every police officer, sheriff's deputy, or government employee is at all times doubling as an ICE agent. We must strive toward a Commonwealth where all residents, regardless of immigration status, feel safe coming forward, and where our law enforcement are focused on keeping all of us safe, not on deporting our fellow community members. Thank you very much.
Thank you. Are there any questions? Seeing none, thank you. Next we have a panel, Hannah Avila and Monique Nguyen. Okay, I'll just give you 2 minutes.
Good afternoon, Chair Edwards, Chair Day. I'd also like to thank the Joint Committee and recognize Senator Miranda and Representative Fluker-Reed as well. Thank you for holding this important hearing today. My name is Hannah Avila, and I'm here today on behalf of the Boston Mayor's Office for Immigrant Advancement to support two acts: an act ensuring access to equitable representation in immigration proceedings, or the Immigration Legal Defense Act, and an act relative to immigration detention and collaborating agreements, or dignity not deportation. The City of Boston has over 700,000 residents, of which 27% are foreign-born. Our immigrant neighbors play a significant role in contributing to our city and region's economic growth and are essential to the diversity, vibrancy, and culture of Boston. ICE arrests have sharply risen in every state since the beginning of Trump's second term. As of September 15th, Plymouth County Correctional Facility, the only ICE detention jail in Massachusetts, holds an average daily population of 449 immigrants and has been criticized for unsanitary conditions and treatment of detainees. The ICE field office in Burlington, an administrative facility intended to detain people for only a few hours, has held immigrants in inhumane conditions for days on end. Unlike defendants in the criminal legal system, detained and non-detained immigrants facing deportation proceedings are not guaranteed the right to a court-appointed attorney. Without counsel, immigrants lack the legal tools for a fair judicial process. Of the more than 13,000 immigrants granted asylum in immigration courts in Massachusetts since 2000, less than 5% won their cases without legal representation. The Immigration Legal Defense Act establishes a statewide system for free immigration legal representation to low-income immigrants in defense of removal proceedings, prioritizing detained immigrants. The Dignity Not Deportations Act requires that Massachusetts law enforcement does not sign new or extend or renew existing 287G agreements. We believe that the state should invest in immigration legal services and ensure that local law enforcement are not assisting the Trump administration in their mass deportation agenda. Thank you for your consideration, and I respectfully request that you report this legislation out favorably.
Thank you very much. Questions? Thank you. Jane Peachy, virtual. Representative Sullivan, Almeida.
Madam Chair, can you hear me? I apologize.
Yes.
Sorry about that. And I do apologize. I tried to get on when she was still sitting there, the previous testimony. I've heard several times through this hearing that Plymouth County House of Corrections has been accused of have inhumane conditions and abusive conditions. And I'm just wondering, and I guess this could be a blanket statement or a question to all those who have previously testified to that question or that statement is, have any one of those individuals for this facility had any conversations with the jail itself, with the sheriff or his administration? Because I've heard from several different people, including our Black and Latino caucus has toured this facility several times and has spoken about how well the conditions are kept. So my question is to the previous testimonies, as well as the woman that just testified, if they've ever had or taken the opportunity to tour that facility.
Thank you, Representative. Thank you. Was Jane Peachy available online? No, right? She's available? Okay. Okay. If she gets back on, we'll try and pull her in. Murat Erkan, also online.
How you doing there?
Okay. Go ahead.
Okay. Just one moment, please. Thank you so much. I'm here to speak on behalf of the Mass Association of Criminal Defense Lawyers. For nearly 30 years as a prosecutor, now as a defense lawyer, I've learned the difference between justice and injustice often comes down to one thing: whether someone has an advocate standing next to them. In our criminal courts, Massachusetts does guarantee counsel because we understand that liberty cannot be protected without representation. Yet in immigration court, where families are permanently torn apart, we leave people to fend for themselves. This is a moral failure we must correct. Let me give you 3 reasons why S.1127 is essential. First, Massachusetts does not ask people to fight life-altering battles alone. Immigration law is notoriously complex. Without a trained advocate, what chance does the detained mother from Lynn or Chelsea have when the federal government deploys its mighty deportation engine against her? We cannot and must not let her face it alone. Second, the bill protects families and strengthens communities. A deportation is not an isolated one-person event. It is a shockwave that rocks children, workplaces, and entire neighborhoods. Representation prevents wrongful removals and keeps families intact, something every one of us should want for our neighbors. Third, this bill reflects the best of who we are. Massachusetts has always led the nation when it comes to justice, from establishing a model public defense system to recognizing marriage equality. With this bill, we can lead again in line with our finest traditions. History teaches that our deepest injustices begin quietly, with vulnerable people isolated and denied representation, forced to face the weight of the government alone. And it grows in the spaces where people have no advocate, no voice, and no one is willing to stand up and say, this is not who we are. Someday our children will ask us what we did when families are being separated and when our neighbors face deportation alone. Let us anticipate that question with confidence that we are on the right side of history. Thank you.
Okay. Thank you very much. I heard Jane Peachy is able.
Yes,
okay, go ahead,
thank you,
Jane.
and sorry about that. I'm testifying today as the president of the Massachusetts Association of Criminal Defense Lawyers, or MACDL, and I'm testifying today in support of H 1954 S.1127. I'm proud to be a public defender as well in Massachusetts, where we have what's been called a model public defense system. Other states look to us for providing quality representation for all our citizens, guaranteeing them good due process and fairness in our courts. But for many of our clients, especially in the current political climate, criminal charges where they get protections, including appointed counsel, are not the thing they are most worried about. It is the threat of ICE agents arresting and detaining them, whether legally justified or not. It's deportation more than charges, a conviction, or even jail time is what can change the trajectory of their whole life and the lives of their families. As the Supreme Court said in the landmark case of Padilla versus Kentucky, deportation is an integral part, indeed sometimes the most important part, of the penalty that can be imposed on non-citizen defendants who plead guilty to specified crimes. For these reasons, our Commonwealth should also provide legal representation for our community members facing immigration consequences. As criminal defense lawyers, we are constitutionally obligated to provide advice to our clients about the immigration consequences of the criminal case. That is now more difficult than ever. Nothing is guaranteed. DHS is coming up with new interpretations of long-standing legal principles. Immigration lawyers, including a team of volunteer MACDL attorneys, are filing habeas petitions in federal court to try to uphold the rule of law. It is more complicated and dire than ever to navigate proceedings in immigration court. I wouldn't even represent myself in immigration court these days because the legal landscape is so rapidly changing. Our Massachusetts friends and neighbors need lawyers in order to have a fair chance in immigration court, and in order for the decision maker to have all the relevant information and the correct legal arguments at their disposal before they make such a life-altering decision. In short, it is needed to make it a fair fight. It is for these reasons that MACDL supports the Immigrant Legal Defense Act.
Thank you. Thank you very much. Questions? Seeing none. I'm going to call in actually Senator Lovely. There we go. Senator, we're ready when you are.
Thank you, Madam Chair. And Mr. Chairman, my apologies, I'm testifying from my car, but I am pulled over, so I'm not a hazard to the road or to myself. I am here to testify quickly on, and I know you have a very long docket, thank you for taking me out of order. House number 1927, an act exonerating certain individuals accused of witchcraft in colonial Massachusetts. As a senator from Salem, I feel compelled to speak on behalf of this bill today. And I know you have already heard from probably several people who have testified on behalf of this bill. It would exonerate these 8 individuals that were denied their basic justice, 5 of whom were executed back between 1648 and 1693. So this bill would exonerate these 8 victims who were wrongfully convicted of witchcraft in Massachusetts. Happy to answer any questions, and thank you for the opportunity to quickly testify.
Thank you very much, Senator. Any questions? Seeing none, thank you.
Thank you.
Representative Markey?
Thank you very much for taking me out of order, Madam Chair. Women, Mr. Chairman. Typically, I don't speak at these because I try to figure out a few things and who the people are to talk to. I'm here on 4736, which is a bill to protect the public from street takeovers by recreational vehicles, motor vehicles, and also to deal with disturbing the peace and disorderly conduct while masked. This bill would enhance the penalties or potential penalty a person faces when there are additional elements that the government would have to prove at a trial, more than the operating to endanger. The operating to endanger is operating a motor vehicle on a public way in a negligent manner or reckless manner under Chapter 90, Section 24. This would add a subsection to that, which would be operating negligently or recklessly with a group of 2 or more people, and that you're hindering the traffic. The potential penalty could be an increased fine for up to $2,000, but keep the same penalty for incarceration of 2.5 years. But the thing that I think is compelling here is that it gives the ability, like under Chapter 90, Section 26, where they can seize a snowmobile for doing this out in Western Mass, that you can actually seize a recreational vehicle or a motor vehicle that participates in one of these street takeovers. You say, oh, well, we're enhancing penalties, we don't like to do that, you know, it's not incarceration or those things. Hopefully this is a deterrence. The idea is all we're really looking to do here is to take away the motor vehicles or the recreational vehicles from these individuals who participate in them. We think that those are the prized possession of individuals, that they would not want to do this anymore as a result of that. Further, this also protects the police in this respect. If an individual is participating in this, but not in a car, but out on the side of the street screaming and yelling and causing disorderly conduct, and or that they're disturbing the peace while masked, because a lot of these individuals are masked when they're doing this, there's an increased penalty. Right now, disturbing the peace as punishable under the statute for a first offense is a $150 fine. That's it. So what we're looking to do is increase, while mask, again, an enhanced element that the government would have to prove to make this into a one-year minimum, one-year sentence, not a minimum mandatory, but still a misdemeanor, but it has the potential for some type of jail as a result of this. You say, oh, well, it's just nothing, it's a bunch of kids in a motor vehicle. It's been well documented that in the last 5 months, there have been 4 shootings, including 1 murder. One in Dedham on June 25th, one in Lowell on July 23rd, one in Brockton on August 17th, and one on September 15th in Brockton. The police are having a very difficult time controlling these individuals because of social media. These are not just simple motor vehicle Chapter 90 violations. The collateral consequences of this are significant, and it's prime for these individuals to set up a shooting or a murder at these locations because of the nature of the communication that's hidden from the police and the lack of police response. So I'm hoping that this is something, it is a late file, but I do think it is something that is very significant. It's happening in every area of the Commonwealth, particularly on the October 5th incident in Boston. It started in the south end of Boston, but it ended up in Randolph, then to Middleborough, and then into Somerset. So it's going all over the place, and we have the Mass State Police working diligently trying to keep up with it, but the response, because of the volume of people, makes it nearly impossible. So I'm hoping that this bill would deter individuals from participating, and I hope that you would vote favorably for this to pass. I'm happy to answer any questions. No?
Any questions? Seeing none. Thank you very much.
Thank you. Appreciate it.
Back to 1127, Stasha Shejual. We got a Stasha Shejual in person. Okay. We're 2 bills left. We have now S1249H1919, an act prohibiting body size discrimination. Up first, we have Jacqueline Liu.
Thank you, Chairwoman Edwards, Chairman Day, and the rest of the Joint Committee for your time and consideration. My name is Jackie Liu. I am a third-year medical student at Harvard Medical School, a resident of the city of Boston, and I'm speaking on behalf of Medical Students for Size Inclusivity as their co-lead of advocacy. We are a national organization of medical trainees championing weight-inclusive medicine. Last week, I was in an outpatient pediatrics clinic where the doctor I was working with actively fat-shamed my 19-year-old patient. My patient was struggling with debilitating migraines and issues tolerating her contraception, for which she desperately needed treatment. But instead of addressing those issues, the doctor decided to focus on her weight. Why have you gained 40 pounds since the last time we saw you? This isn't good. What will you do to be healthier? You know you really should lose some weight. After the visit, she turned to me and asked, was I mean? To which I said, yes. And while she didn't act the way I wanted her to, she at least came to understand that what she did was wrong. I see this calling out as an example of what this bill purports, a wholehearted declaration that size discrimination is not tolerated in the state of Massachusetts. By instituting a ban on size discrimination in schools, the workforce, and in public spaces, we show that we as a state will not allow for people to be treated differently based on their bodies. And in turn, we can begin to change the public's and our healthcare system's opinion that larger bodies are worth less than others. My hope as a future weight-inclusive physician is that my patients, regardless of their weight, will have equitable access to the social systems we all partake in, that they will have medical equipment that fits them, access to equal employment opportunities, and the ability to further their education without fear of prejudice. In turn, I know that this will allow all of my patients to achieve happier and healthier lives. This bill takes us one step closer to that reality. As a result, we as MSSI urge the committee to deliver a favorable report for House Bill 1919 and Senate Bill 1249 and be moved out of committee urgently. Thank you.
Thank you. Next is Jennifer Kellogg.
Hi, my name is Jennifer Kellogg, and I live in Boston. I have been legally blind since birth. Before disability was added as a protected class, I was denied insurance, I was denied accommodations in school, and I was denied employment opportunities. The civil rights movement has fought for protections in the law, and protections should be extended to height and weight. Fat people are represented in all classes protected by Massachusetts state law. For example, providing legal protection for race, gender, and disability, but not size, leads to discrimination despite being in a protected group. According to the mass.gov website, Black and Hispanic people are 40% more likely to be fat than white people. And according to the CDC website, 40% of disabled people are fat. I want to be very clear. Being fat is not a disability and should never be considered a disability. Let's use a fair housing example. A landlord cannot deny housing based on race, color, religion, sex, familial status, disability, and national origin. However, a landlord desperate to deny an application to a Black woman can skirt the law by denying her application based on her size. For example, the landlord might claim that the stairs down to the laundry room in the basement are too narrow. If this woman was disabled, then the landlord must comply with fair housing laws and the applicant could ask for a reasonable accommodation. Whether this accommodation is made or not is a story for another day. And if it's this difficult for a person with a disability to live in a world where their rights are protected, think about how difficult it is for a fat person to live in a world where they don't even have a legal basis for fighting for their rights to be housed, educated, or employed. The state is not actually protecting the rights of people they claim to protect unless you add height and weight to a protected class. Please pass this legislation. Thank you for your time.
Thank you. Any questions? Seeing none. Maggie Bowlby.
Good afternoon, committee members. Thank you for your time today, and thank you to Senator Roush and Representative Nguyen for championing this bill. My name is Maggie Bowlby. I'm a resident of Lowell, Mass, and I've been a Massachusetts resident since 2010 when I attended Boston College. I was a special education teacher here in Mass for 8 years, and I currently work at the Association for Autism and Neurodiversity in Watertown, and I'm a founding board member of Bigger Bodies Boston, who you'll hear from shortly. I love Massachusetts because so many of my rights are protected, and this whole state feels like my neighborhood. As a large fat person, the message I receive in public spaces is clear. You don't fit. I spent many years trying to shrink my body, and now I have only an eating disorder to show for it. I experience constant uncertainty. Will I be able to buckle the seatbelt? Will that chair hold me? Can I squeeze into this bathroom stall? Will the doctor have a gown for me? What if I get stuck in the MRI machine? I wonder, how will I have to embarrass myself to receive accommodation, and even if I do, will I get it? I'm a Broadway and Boston season ticket holder. I used to squeeze into theater seats for 2.5 hours with the arm of the seat digging into my thighs and leaving bruises, and my knees pressed up against the seat in front of me. My stomach would tie up in knots as I approached a seat in a new theater. What if this time I don't fit and there's no other options and I have to leave? Now, many theaters, there are alternate options, but these accommodations are not guaranteed and they're not protected, and that's where you come in. I am able to use my privilege to be here today, and many others cannot. I was able to get childcare and take time off work. I ask you to consider the many fat people unable to be here today who are routinely excluded from public spaces, employment, and housing that fits their needs. And I ask you to return a quick and favorable decision on this bill. Thanks for your time. Let's put our weight behind this issue.
Pun intended, right? Okay.
Pun intended.
Pun intended.
Thank
Good
you.
job. Sorry. Stevens, please correct me.
Can you hear me?
Yes.
Yes, Nyanu Stevens.
Go ahead.
Good afternoon, Madam Chair, Mr. Chair, and esteemed members of the committee. Thank you for hearing me today. I am Nyani Stevens, Director of the National Conference for Community and Justice, or NCCJ, located in Holyoke. And today I am here to speak on behalf of my organization as an advocate for human and civil rights in the state of Massachusetts. NCCJ is in strong support of H 1919 and S 1249. While weight and height discrimination are rampant and sizeism has an impact on all of us, it is undoubtedly fat people who bear the brunt of this form of oppression. Fat people in the United States are one of the most visible groups of people, making up 74% of the population, yet are one of the most invisible when it comes to rights and representation. Weight is generally not a protected class, and over the last several decades has become a highly stigmatized identity. We see the impact of this lack of protection in every metric measuring wellness and success. Fat people face discrimination in employment, education, healthcare, housing, and all public spaces. This is an issue of human and civil rights that you, the Massachusetts legislature, have the power to remedy, at least here in Massachusetts. There is no federal protection from weight discrimination. When the federal government fails to act, it is up to the states to create laws that protect each resident, each visitor, and each person employed in the state equally. Massachusetts has a chance to belong to a group of states who believe in the humanity of all of their constituents. People will oppose this bill on the basis that fat people need to be discriminated against and bullied for their own protection, because otherwise they will never become thin. We know this to be untrue. Fat people know they are fat, and thinness does not equal health. Stigma and discrimination do not make it more likely that people will become thin. It makes it more likely that they will struggle with mental health issues, engage in unhealthy behaviors to become thin, and avoid seeking health care. Fatness is not a health crisis or a moral failing, but discrimination and stigma are. Please stand up for human and civil rights by advancing this bill. Thank you.
Thank you very much. Rachel Otis, virtually.
Hey, are you able to hear me?
Yes.
Thank you. So I just wanted to start today by, of course, thanking you all so much for your time. I am testifying in support of our bill to ban discrimination against citizens of size or based on their body size. In preparing today's testimony, it was actually shocking for even myself to remember and realize how many parts of life have been impacted by size discrimination. Starting from 3rd grade, when I was being bullied about it and my parents decided it was safest for me to switch schools from public to private because nothing was being done by the staff, to the countless times throughout my youth that I ultimately left a sport or activity that I truly loved simply because the uniforms didn't fit my body. Starting with dance and gymnastics, where I was discouraged from participating, then basketball, volleyball, softball. I still persisted in making tennis work all the way to being number 3 on my varsity team, playing through the discomfort of an ill-fitting uniform. Also at this time, being immersed in Children's Hospital and being put through an aggressive weight loss program. These experiences, in part, led me to become the mental health therapist I am today, supporting clients of larger sizes deal with the daily discrimination of their lives. As I was going through the brutal 4-year grad school program to obtain my master's, I faced some physical obstacles. Picture this, those teeny tiny chairs with the desks attached. Now imagine existing in most classrooms for all of those years of study, and my default being having to sit on the floor. So right now during this whole meeting, I'd be sitting on the floor. And I'm sitting on the floor obtaining my master's while my classmates around me are seated in these desks and chairs. Halfway through the program, we began working with clients. And again, I realized I have no access to seating. So I just want to end by saying, as a therapist, I was lugging chairs from room to room to accommodate myself and my clients of size. Only through my disability was I able, through the Americans with Disabilities Act, to obtain seating. So if I didn't have that, I guess I still wouldn't have a chair. I was sitting on the couch, my clients were sitting in the chair. And thank you for your time today. Listening.
Thank you very much for your testimony. Questions? Seeing none. Reagan Chastain?
Yes,
Virtual?
thank you so much.
Yeah.
Sorry, having a tiny trouble with my camera. There it goes. All right, thank you so much for the opportunity to testify in strong support of these bills. And I apologize, I'm dealing with some laryngitis, so please bear with me on that. I'm Reagan Chastain, and as a size discrimination researcher and expert, and someone who has lived her entire life in a fat body, I can assure you that body size discrimination impacts higher weight people and people of short stature in every aspect of their lives. Research finds that body size discrimination drives inequalities in housing, education, transportation, public accommodation, and employment. This discrimination also combines with other discrimination, particularly racism, to increase existing inequalities. The research around body size discrimination and health tells a distressing story for victims and for public health in general. Decades of research finds that experiencing body size discrimination is linked to higher incidence of type 2 diabetes and high blood pressure, substance use disorders, suicide and self-harm, poorer control of chronic health issues, and a 60% increase in mortality risk, all of which impact both personal and public health. Moreover, when body size discrimination is illegal, people are told and shown with complete clarity that they are not equal, that they are not welcome, that they are not valued. Eventually, many internalize those messages and withdraw from self-care, healthcare, and society to the detriment of their physical and mental health and to public health and society in general. Body size discrimination is wrong, harmful, costly, and preventable, and you can choose to help end it. Massachusetts can lead in this area of human rights as it has in others. H 1919 and S 1249 improve public engagement and public health by creating a more accommodating world, a more just world, a world where people of all heights and weights can participate fully and thrive. Please take the next step in creating that world by favorably reporting these bills out of committee. Thank you.
Thank you very much for your time. Questions? Okay. Reverend Dr. Anastasia Kidd.
Thank you for your time. I am Anastasia Kidd, and I'm ordained clergy in the United Church of Christ, and I teach at Boston University. I stand here with the support of a dozen of local clergy, including my husband, the Reverend Chad Kidd, who's with me today. Each week, clergy stand in pulpits statewide, and we affirm the dignity of all people in the eyes of God. But that dignity is not fully enjoyed by all residents, and every day people are denied jobs, health care, housing, and public life because of the raw, unchangeable genetic code that made them tall or short or fat when it becomes an excuse for others to deny them access or services. I know this because I preach and I teach in a fat body. I stand behind pulpits and lecterns with the same commitments and competencies as my thinner colleagues. But when we leave work, our lives diverge. My thinner colleagues have never been turned away from a restaurant or a salon because of their size. They've never been shoved out of a tea stairwell at rush hour and told that they take up too much space. I have. And that's hardly the worst of what so many others experience when denied housing or employment simply because of their size. I graduated from seminary on May 17, 2004, the same day equal marriage became law here. I remember feeling joy that I was able to minister in a state that chose to lead this nation by protecting the God-given dignity of all people to live and to love freely. You once again have the opportunity to lead. Passing these bills, S 1249 and H 1919, would make Massachusetts the first truly size-inclusive state in this nation, one that refuses to let shame or stigma rule over its people, and where every body is protected in equal measure. May God bless your discernment.
Thank you. Questions? Stephanie Baldassari.
Hello,
Hello, thank you for the opportunity to testify today. My name is Steph, I'm from Gardner, Mass, and I'm here to voice my strong support for the bill to prohibit body size discrimination. Weight-based discrimination is often invisible in policy discussions, but its impact on real people is constant and deeply harmful. I've personally experienced how quickly assumptions are made about one's character, abilities, or lifestyle simply due to their body size. These biases follow people into workplaces, classrooms, public spaces, and even healthcare. Unlike some other forms of discrimination, body size stigma is still widely treated as unacceptable, even though it affects mental health, employment opportunities, and overall well-being in very real ways. A friend of the family years ago couldn't even get a job as a cartoonist because his weight was stigmatized. And my first blatant experience with weight discrimination was in healthcare. When I walked into a doctor's appointment, I was met with assumptions, judgments, about character, lifestyle, before we even discussed the real medical issue. I was treated like a waste of an appointment slot. It made me feel dismissed, unsafe, and devalued. This causes people like me to avoid medical attention and delay critical treatment. This attitude amongst clinicians undermines quality care, lowers trust, and contributes to poorer health outcomes in fat people, which are often just attributed to our weight. Massachusetts has long been a leader in protecting people's rights and dignities. I urge you all to support this legislation. Thank you for your time and consideration.
Thank you. Tigris Osborne.
Thank you, chairs and committee members. I'm Tigris Osborne, Executive Director of the National Association to Advance Fat Acceptance. I'm here to testify on behalf of our Massachusetts members and for all fat people. For 56 years, NAFA has advocated for anyone who experiences injustice because they are fat. Anti-fatness creates systemic barriers in education, employment, housing, healthcare, and public accommodation. Size discrimination exponentially expands injustice against fat people who are already discriminated against for other identities, especially Black and brown people, queer people, and disabled people. Research by Dove shows that size discrimination harms at least 34 million Americans each year and costs millions. NAFA co-founded the Campaign for Size Freedom because fair treatment for people of all sizes should be a legal right everywhere. But when fat people face discrimination, we are told that the solution is to change ourselves. We are especially told this today when misperceptions about drugs like Ozempic have led people to believe that all fat will eventually go away. But fat people deserve access, opportunity, and fair treatment now, as we are, not in a fantasy future where our bodies may or may not be different. The solution to injustice is not changing its victims, it is changing the injustice. Years ago, as a student in Northampton, I attended a workshop on larger-bodied women, led by Carrie Hemingway, who taught me that fat didn't have to be a bad word, and that fat people could demand equality. Carrie didn't live to see her decades of advocacy in Massachusetts result in legal changes. But I'll say her name every time I come before this body until this bill is finally passed. I hope this is the last time I need to do so. And when I come back to Northampton in May for my 30th year anniversary at Smith College, I hope to come back to a Massachusetts where body size does not determine whether my fellow alumni and I have the same rights. Please vote favorably on this bill and let 2026 be the year the act is finally voted into law. Thank you.
Thank you. I just had a quick question. Since you're part of the coalition and organization,
yes.
Has there been any study on the impact of the children? I know that when it comes to racial discrimination and other forms of discrimination, the microaggressions, oftentimes the parents that they experience can be absorbed or, I I guess, internalized by the children.
Yeah.
I'm wondering, and we don't have to give the statistics now, but if there could be some studies on the impact of internalized self-hate or internalized resentment or whatever the internalization of seeing your mother or father who may be in a bigger body be treated as though they don't belong. I don't know if there is a study.
Well,
I'm just curious.
There's some research, and certainly there's anecdotal evidence of kids being judged based on their parents' body size and based on their own body size.
I knew the own body size part, but someone had testified about that. But I was really curious about the link between the impact on children, if there's some studies or something.
Yeah, I mean, there's research that talks about how children are bullied, both, I believe that it includes when they're bullied based on their, not just their own bodies, but also like association, like people see their parents and make fun of them, that kind of thing. There certainly is evidence of parents, children being separated from their parents because perceptions that their parents are bad parents, regardless of how they're actually parenting, just because of their parents' body size. So that's a huge impact area. We sometimes see in family court situations where one parent is holding the other person's body size against them, again, without evidence of other bad parenting. So there are lots of ripple effects for parents of what they're seeing in their own families. I mean, for kids of what they're seeing in their own families. And then certainly just, the direct impact on kids themselves. We know that fat kids are one of the most bullied groups of kids. Some research says the absolute most bullied group. Some research says the second most bullied group. Either way, we know that in jurisdictions where they've explicitly added height and weight to bullying statutes, that has had an impact on decreasing bullying. Mm-hmm. So there are absolutely lots of ways that this impacts young people.
Thank you very much.
Thank you.
Any other questions? Okay. Jessica Rosenblum?
Hello. Yes. Hi, thank you. Hello, committee members, and thank you for your time. My name is Jessica Rosenblum. I'm a third-year medical student and MPH student at Tufts and National Co-Director of Medical Students for Size Inclusivity. A few weeks ago in my pediatrics rotation, I witnessed a mother shout at her 9-year-old that she is lazy and better stop eating, and I watched the little girl curl inward and tug at her shirt, trying to make herself smaller. Already, she understands that to be fat is to be less than. I am often told by the medical community that I don't belong, that the identities of fat and medical student are mutually exclusive. When I was invited to order my very first white coat, it should have been a joyous milestone. However, dread crept in and my premonition was confirmed. They did not offer plus sizes. I had to call the company and give my measurements so they could tell me my size and place my order, separate from my classmates. The act of excluding larger sizes from the drop-down menu, even though the company manufactured those sizes, told me that I didn't belong, that I was an outsider, an unexpected and unwelcome intruder. A fat medical student was not something that was considered, planned for, or desired. Every time I sit down in the lecture hall, eager to learn, I am greeted by the sharp metal piercing my side, the attached desk digging into my abdomen, leaving a bruise. On my surgery rotation, I was placed with a bariatric surgeon and could tell he disliked me for my body. After all, I was the enemy whom his whole career was built upon eliminating. One day he showed me a slideshow of before and after bodies. Of the after photos, he said, "Don't they look like $1 million?" No mention was made of their health. He just wanted to show me that thinner was better. I did not speak for the rest of that rotation and my grades suffered. As I think about the employment process after medical school, I become apprehensive. Although I am a stellar candidate by all other measures, there is the problem of the flesh on my body. I worry that employers will say, "Who wants a fat doctor? If she was smart and hardworking, she would have lost the weight by now." I am confident these biases and ultimately employment discrimination are waiting for me, because in a society that values thinness as a proxy for worth and provides no legal protection for fat bodies, what is stopping them? That is why, as a former fat kid, current fat medical student, and future fat doctor, I urge you all to vote yes on these bills S.1249 and H.1919. Thank you for your time.
Thank you very much. Samantha Powers?
Good day, committee members. Thank you all for hearing our testimonies today. I also want to thank Senator Roush, Representative Nguyen, and their co-petitioners for pushing forward this important legislation, an act to prohibit body size discrimination. My name is Samantha Powers. I'm a graduate of Tufts University, a licensed general contractor here in the Bay State, and a resident of Woburn. I'm also the founder and president of Bigger Bodies Boston, a community building and social justice nonprofit dedicated to creating fat community and fighting anti-fat bias. When BBB hosts community events, we're often privy to people's personal horror stories. We've spoken to a fat swim instructor with loyal students who was let go without cause, but now suspects that her body was the reason for her dismissal. We've talked to mass health patients looking for doctors who might offer any advice beyond lose weight. And we've heard from a single mom who was looking for life insurance as mandated by divorce court, but found that multiple companies rejected her based on her weight. We weren't able to help these people, but you could. This bill would give short, tall, fat, and thin people the legal protection that they deserve. Ultimately, the question before this committee is whether or not citizens of size deserve protection under the law, and I wonder why that's even really a question. Lastly, because of my significant privilege, I was able to take time off, and so I ask you think about the people that cannot be here today to represent themselves. Please consider not just our testimonies, but the stories that you and I can never know. I urge this committee to favorably report out H. 1919 S.1249. Let's be the revolutionary state I know we can be. Thank you.
Thank you very much. Questions? Okay. Sarah Fury de Lima.
Hello. Thank you to the Committee on the Judiciary for allowing me to speak today. My name is Sarah Fury de Lima, and I live in a bigger body. Once a week, I have a meeting on the 7th floor. I watch people press the elevator button, wait for the light to turn yellow, step inside, and shift around to make room for people. But I skip all of that and take the stairs, every time from the first floor. Maybe it's a way to just get my steps in, or maybe it's to prove a point I know some people would be surprised about someone living in a larger body, that someone would or could walk up 7 flights. Some might also be surprised that my labs are great, that I go to the gym 4 times a week, that I don't fit the stereotype of a fat person. That's the problem with prejudice. It's judgment, and in my story, it's based on a single characteristic. I'm asking you to vote yes on S.1249 and H. 1919 because this bill would finally make it clear that people like me shouldn't be treated differently just because of our size. Adding height and weight as protected classes would finally say out loud that our size doesn't define our worth. Our size doesn't make us less deserving of good medical care, fair hiring, a safe home, an education, or a loan with the same terms as anyone else. Our size doesn't make us less reliable, professional, capable, or hardworking. Making size discrimination illegal changes the way that people view us and react to people of all sizes. It lessens the macro and microaggressions to those living in larger bodies. I and more than half of adults in Massachusetts live in bigger bodies. I hope Massachusetts will take this opportunity to be one of the first states to pass a bill like this and protect us all from discrimination. Thank you.
Thank you. And just in terms of to the advocates, another question I have is, you know, when we're discussing disability rights or folks with disabilities, we can point to that 1 in every 5 people may become and will be and could have a disability in their life. I think that's also something worth discussing about having a bigger body. I could be pregnant one day, all of the different ways in which my body could change. And it's important to note that it's not a stagnant from birth to so on and so forth. You may be in a bigger body or you may be in a smaller body, but because of that, it would be good to hear if that would also be part of the analysis. That's all. No, we don't, no. Sorry, just want to bring that up. I brought up some kids and I brought up some other things about also testimony that would be helpful. Okay, so I am now going to move on to the next bill. Again, there are people who signed up for the day. We will call them, but we're going to go on to the final, not the final bill, but the bill that signed up. Okay, thank you. H1980, an act to promote health and safety of people in the sex trade. We have Andrew Sebald, virtually.
Hi, can you hear me okay?
Yes.
Hi, sorry about that. I'm just preparing this. Okay, my name is Andrew Sebald. I live in Somerville. I'm a graduate social work student as well as a member of the Boston chapter of the Democratic Socialists of America, or DSA. I've been organizing in the greater Boston area since I moved here 4 years ago. I'm here in my own personal capacity to support organizations like Boston Sex Workers and Allies Collective, who have done tremendous work to bring this bill before us today. I want to take a brief moment to speak on the current state of Massachusetts' working class. According to the State Department of Economic Research, unemployment in Massachusetts has reached its peak since the COVID-19 pandemic at 4.8%. The cost of living is of the highest in the U.S. Per the Missouri Economic and Research Information Center, Massachusetts sits at the second highest cost of living in the country. Massachusetts also boasts one of the highest costs for childcare. The point is that Massachusetts is one of the most difficult places now to live and work day in and day out. And it is only getting worse with the Trump administration's assault on civil rights, from the kidnapping of our immigrant neighbors to threats toward the LGBTQ+ community at large. In conditions like these, it is often that our neighbors turn to sex work as a means to continue paying the rent and putting food on the table every day. A large portion of people who work in the sex trade come from marginalized communities, especially transgender people of color. Criminalizing sex work only makes these populations more vulnerable to harassment and incarceration, and also hinders access to institutions they need, like healthcare. As a social work student, I have worked with families who have already been unjustly harmed by the cruelty of the Trump administration. For too long, our communities have deserved more than what they have been given, and this applies to the sex workers in our community. This goes back to why I'm here with this testimony today. I believe sex workers deserve protection from both police brutality and violent clients. I believe sex workers deserve equitable access to health care. I believe sex workers deserve more in general. I urge you to pass H1980 to protect their health, safety, and their rights. Thank you.
Thank you very much for your testimony. Any questions? Chastity Bowick, virtual. Nope. Okay. Danielle Lee, virtual. Yep. Okay.
Hello. Thank you so much, Chairwoman, and thank you to the committee as well. My name is Danielle Lee, also known as Danny Lee. I have been a community organizer and a sex worker of over 8 years, and I'm here to offer testimony in support of Bill H1980, an act to promote the health and safety of people in the sex trade. I implore everyone who is watching and listening to this testimony to hold space for the concept of bodily autonomy. Consenting adults should not be cited, arrested, or shamed for their sexual choices, including when they make the choice to exchange money for it. As we are mindful of the ongoing economic failures in our country, such as an unstable job market, record high inflation, and record high housing costs, as well as a 54% increase in homelessness in the state of Massachusetts between the years 2023 to 2024, we must ask ourselves why there is still so much stigma surrounding the consensual exchange of sexual services for money. As we are mindful of how many reported incidents there are of law enforcement sexually harassing and assaulting sex workers, we must question the idea that convicting a person for prostitution is somehow protecting them from sexual exploitation. Furthermore, as we are mindful of the humiliation ritual that comes with being a prosecuted sex worker, complete with a public, permanent record, we must ask ourselves how sex workers are ever supposed to find jobs outside of the sex industry. As a Black, disabled, gender-expansive person living without the privilege of access to generational wealth, sex work saved me from homelessness and starvation numerous times. Disgracing and penalizing consenting adults for their choice to utilize their own body to pay their way through survival is wrong, full stop. And with that said, I strongly express my support for the decriminalization of consensual adult sex work. I believe that the expungement of prostitution charges from public record is a bare minimum first step toward restorative justice for sex workers. Thank you for being present and attentive to my testimony.
Any questions? Thank you very much.
Thank you.
Erica McDonald LaPlante, or LaPlante, in person? Okay.
Hello, everyone. My name is Dr. Erica LaPlante, and I'm a resident of North Attleboro, Massachusetts, and the director of the Human Rights Research Hub at the Gladstein Family Human Rights Institute at the University of Connecticut. I would like to express my strong support of H.1 980, which would decriminalize consensual commercial sexual activity. My area of research and expertise is at the intersection of sex workers' rights and anti-trafficking policy. I've spent the last 10 years of my academic career focused on understanding the impacts of different regulatory laws and legal frameworks on the rights of those engaged in consensual commercial sex and those who have experienced trafficking. I've also volunteered for National Sex Workers Outreach Project organizations focused on supporting incarcerated and formerly incarcerated sex workers. The majority of my research is focused here in the United States and in the context of New South Wales, Australia, one of the few places that has decriminalized approach to sex work internationally. New South Wales has functioned under the decriminalization model since their state-level legal reform in 1999. My findings and analysis contribute to a significant body of research internationally that shows that just decriminalizing sex work helps counter human trafficking, improves public health, and promotes community safety, and allows for workers increased access to critical services like primary health care, mental health care, access to housing, legal services and representation, and access to bank accounts and financial loans in institutions without the harm of criminalization, all while also fostering an environment that allows victims of trafficking to seek safety without the risk of arrest. There is significant support for sex work decriminalization as a crucial component of trafficking prevention, as demonstrated by both national and international human rights and anti-trafficking organizations. You have the opportunity here in Massachusetts today not only to do more for our communities and for those who have been minoritized and excluded from protections and services they should be legally entitled to, but also to be a leader in modeling a human rights-based, community-led, and public health-informed approaches to sex work policy. Thank you for consideration and support of this bill.
Thank you. Questions? Thank you very much. Jay Rodolitz?
That's me. I'm here. 1 second. I'm online.
Okay.
Had to go home. All right. Can you hear me okay?
Yep, we can hear you.
All right. Thank you so much for your time today. I'm Jay Rodolitz. I'm a PhD student at Northeastern University, and I'm here in strong support of H1980. I'm also submitting as written testimony my recent paper, As Someone Who's Disabled, I Am So Thankful to Sex Work, on alternative approaches to access among disabled sex workers. In that paper, we studied how disabled sex workers make use of sex work to create accessible working conditions and living conditions for themselves. I want to highlight a few of our findings here. Our participants described many ways that sex work was accessible to them, where civilian work wasn't. As one says, finding a job that you can do 3 or 4 hours a week and then deal with your other medical miasma the rest of the time is really hard. However, sex workers are forced to engage with inaccessible civilian workplaces if they want access to housing or healthcare, as another sex worker describes. Quote, I also have a straight job, which is very physically demanding, but it pays none of my bills. I do it for respectability. It's a cover. I've come into quite a bit of issues with renting apartments, with verifying my income, and with being a self-pay insurance person. And in order to get access to housing, they've had to work another job, not for money. Just because you can't report being a sex worker if you want housing. Sex workers deserve to be able to report their work just like any other workers. They shouldn't have to jump through hoops to survive. Decriminalizing sex work also enables workers to organize together and engage in safer working practices. Many of our participants and my colleagues here today work with their peers to create safer, more accessible working conditions, for example, by sharing housing. Under the current laws, this opens them up to more risk from law enforcement. Our current model actively disincentivizes safer sex work. I urge this body to pass H 1980 and support sex workers in their efforts to create safer working conditions for themselves. Thank you for your time.
Thank you very much. Questions? Seeing none. Madison Crees.
Hi there, my name is Madison Crease, and I'm a member of the Boston Sex Workers and Allies Collective, but my day job is as a clinical director and licensed social worker who has built her career working alongside street-based sex workers on Mass and Cass here in Boston. A year ago, I was contracted by the Massachusetts Department of Public Health as a trainer on the intersection of sex work and substance use. The mandatory training covered topics like the continuum of consent, the term sex work, and sex work history from a labor rights perspective, and how to build accessible and judgment-free milieu spaces. Anyone who was leadership within programs that received T contract funding had to attend. Some of you are in the room with us now. Hello, Safe Exit Initiative. It was mandatory because the Commonwealth recognizes that sex workers are a part of our communities and they deserve safety, dignity, and services designed for them rather than against them. I also serve as an elected member of the Massachusetts Office of HIV and AIDS Behavioral Health Advisory Board, a position I hold specifically because of my expertise supporting sex workers. My career exists because the state already knows what this bill is saying out loud. Sex work is labor, and people who do it deserve the same safety, dignity, and rights as any other worker. Criminalization doesn't protect my clients. It pushes them into isolation, forces them into more dangerous situations, and makes it harder for them to access healthcare, substance use treatment, housing, and trauma support. It perpetuates the cycle of abuse. When police involvement in catching a charge is a constant threat, they don't call 911, they don't report violence, and they avoid the very services that the state funds me to provide. My job would be easier and my clients would be safer under decriminalization. H 1980 is not a radical idea. It's a public health-driven and evidence-based approach. Massachusetts has already invested their dollar in recognizing and supporting sex workers as community members deserving of care. Decriminalization simply aligns our laws with the reality of our practice in Massachusetts. I urge you to pass H 1980 and take a meaningful step towards health, safety, and human rights for people in the sex trade. It's a simple formality. Thank you.
Thank you very much. We have a panel. I have Maya Onikoroshi and a couple other people.
Hi, my name is Maya Onikoroshi, and I'm testifying today in support of H 1980. I'm speaking to you as co-chair of the Boston Sex Workers and Allies Collective. We are a volunteer-run group who, for the past 2, coming up on 3 years, have operated a monthly support group for consensual adult sex workers, such as myself in the greater Boston area. And what I really want to share with you today is how much I love my career as a professional dominatrix. I've worked in the adult industry over the last 7 years, and if I had 2 minutes just to talk to you about what I love about my career today, I would, but I don't. So I'm going to wrap up before passing the mic to my colleague just by pointing out the peer-reviewed research literature produced by public health and human rights groups such as the American Civil Liberties Union, UNAIDS, the United Nations Working Group to Prevent Discrimination Against Women and Girls, and they agree that decriminalizing consensual adult sex work improves public health outcomes, combats HIV/AIDS, and reduces violence. So thank you for your time, and thanks for hearing our comments. And when my colleague finishes, we'll be happy to take any questions.
Hello, thank you so much for hearing my testimony. I'm a Boston-based artist and curator. I'm also an autistic transsexual woman and a professional sex worker. Sex work's been my primary source of income for several years. As a disabled person who's not eligible for disability benefits but too disabled to work full-time, I turned to sex work as a way to support myself within my capacity. Before doing sex work, I regularly experienced medical problems as well as physical and emotional burnout. Sex work has enabled me to survive in a culture that doesn't accommodate me despite my desire to participate in it like everyone else. While it's true that I didn't initially come to this work by choice, it is certainly my choice now. I've had many jobs in my life, high-risk jobs that, I was subject to violence for $11 an hour. So while sex work is not something I initially came to by choice, it is by far the least degrading work I've done. Spending 40 hours or more per week for working than less than a living wage for people who exploit my labor is far less desirable than sex work. Decriminalization would actually enable me to have some modicum of enjoyment for my work. I would be able to properly vet clients. I would not be afraid every time I saw a new client. I would be able to have complete control of the clients I see and the services I offer. Instead, I'm forced to see clients in good faith. I have seen dangerous clients who feel empowered by my inability to safely report assault or abuse. They also feel empowered to not allow me to vet them because they are afraid of, their criminalization. I have been robbed. I have been raped. And myself and my colleagues deserve to support themselves safely and free of exploitation and free of stigma. There are a lot of socially acceptable jobs people do that contain lots of risks, but because there's no stigma, it's considered, normal and even, virtuous to subject yourselves to risk when it's a job society's deeming acceptable. This is a job like any other job. It's a job I choose to do, and I shouldn't be judged for the risks that I take doing it. No one judges a firefighter for running into a burning building. Not that I'm comparing it, but lots of jobs have risks. Thank you so much.
Thank you. Any questions? Thank you very much. The next is a panel, Mary Carol Walden and the BSWAC members.
Thank you. My colleague, Mickey Jones, was here earlier and had to leave and is online now. And I'd spoken to someone outside who said that she would be able to join virtually. I don't know if that message has reached you all.
Mickey Johnson?
Mickey Jones.
Jones. Is Mickey Jones on?
It may be Johnson. I might have that wrong.
No.
Okay.
Oh, well, we'll give you 2 minutes for now, and then if...
Yes, I'm here.
Okay, then, so
Okay,
you got your
great.
5.
Thank you, Chair Edwards and Chair Day, for listening to people whose voices are too often suppressed, distorted, and appropriated. My name is Mary Carol, and I am here today as a sex worker with more than 20 years of diverse experience in the industry and as a longtime advocate for sex workers' rights and well-being. I am currently the co-chair of the Boston Sex Workers and Allies Collective. We provide peer support for sex workers, advocate for policies that address the needs of sex workers and survivors of exploitation, and we work with local and regional advocates and harm reduction organizations, including in recent conversation with Safe Exit Initiative and My Life, My Choice, whose members are here today. We recognize the harm that criminalization brings to our communities while envisioning the benefits for us all when we address the roots of vulnerability in our society. But that's a wordy way to say that I, a sex worker from a low-income family of loving people, a would-be scholar of sex work, a sex worker with clients who defy fear-mongering stereotypes about them, a middle-aged white lady who loves making dinner for her passionate peers, I implore you to favorably advance H. 1980. BSWAC is part of an ongoing organized movement that began in the US in 1973. Coyote, Call Off Your Old Tired Ethics, originally recognized that criminalization itself is a foundational source of harm for sex workers. Decriminalization is not the only policy we seek to protect laborers and vulnerable people, but it is a call to end state violence against sex workers and the beginning of meaningful policy shifts that can only take effect when sex work is fully decriminalized. These policy shifts will mean that sex workers can enjoy being home without fear of eviction, that we can access the healthcare and social services we need for our families without risking custody, that we have access to the rights and protections of the law that other workers have, and that we can address the real sources of harm in our lives without risking arrest, surveillance, or increased violence. Please favorably advance H1980 so that we can meaningfully address vulnerability, labor, and sex. Full decriminalization of sex work is the first step. Thank you so much, and I'll turn it over to Mickey.
Hello, members of the community. Thank you for the opportunity to speak. My name is Mickey Jones. I am an activist with Consulting with Chastity and Consulting Talent Group. I have also worked with SOS, Survivors of Sex Work. And I just want to briefly give my testimony on why I urge you to pass H. 1980 and amend the harmful provisions in H. 1683. For years, I have worked directly with the transgender and cisgender sex workers, helping them secure resources to housing, healthcare, jobs, education, and everyday essentials. Hearing these stories and fear for their arrest and barriers created by criminal records that drives my work and why I'm so passionate about this bill. Criminalizes doesn't protect them. It makes them less safe and blocks them from stability. H. 1980 is straightforward evidence based off a publicly safety bill. It decriminalizes consensual adult sex work, strengthens anti-trafficking laws, and provides expungement so that people could move forward with housing, employment, and security. Research and global health leaders agree. The criminalization reduces violence, reduces trafficking, and also improves public health. H. 1683, however, includes language that wrongfully defines all sex workers as prostitutes persons, erasing survivors experiencing and conflicting with federal protections like T and U visas. This harms the very people it aims to help. We all share the common goal in exploitation, support survivors, and keep our communities safe. The path to this is not criminalizing consenting adults. It is passing H. 1980 and fixing the harmful language in H. 1683. No one should be punished for the rest of their life trying to survive. We all want to end exploitation and support survivors. That means decriminalizing. Passing H. 1980 and fixing the damage in 1683. I urge you to advance H. 1980 and amend H. 1683. Thank you so much for your time. I really appreciate it.
Thank you very much. Thank you. The next panel is Melissa Brodu and Becca Cleary.
Good. Yeah, go first.
Oh. Hey, good afternoon. My name's Rebecca Cleary. I'm the staff attorney at Decriminalize Sex Work. I'm a policy expert on trafficking laws and laws relating to adult consensual sex work. I just want to provide some context for things that our colleagues have said and also the existence of this particular decriminalization bill and its history here. Historically, I think that the policy questions surrounding trafficking in adult consensual sex work haven't been examined properly and instead have been seen as a conflict between two groups. And there are proponents here of H.1683, and we are in allyship with the people who are proponents of that bill. We do disagree on certain points, and we'll discuss that. But that does not mean that this is an issue that's not worth examining, and that does not mean that we're not working together and share the same values of making sure that vulnerable people in Massachusetts have access to services that will keep them safe, that will keep everyone safe, that criminal record relief needs to be accessible, and it doesn't need to be re-traumatizing, which is one of the things that is addressed in H.1683. Both of these bills do repeal common night walking, which is archaic, a frankly archaic law. And, we also want to urge that there is further study of ways that we can support marginalized people who are engaged in the crime of sex for fee, whether that be as adult consensual sex workers or whether under coercion. Because at the end of the day, both of those groups of people are being criminalized under this law. The reason why decriminalization is important is that when you decriminalize adult consensual sex work, we can eliminate laws that inadvertently harm sex workers and survivors of trafficking. People who are experiencing trafficking get caught up in crimes, and sex workers and trafficking victims alike can be caught up in crimes that are intended to punish people who are not sex workers. So when people work together, they can be harmed under laws like the support from or sharing earnings from prostitute law, which is amended in this bill to ensure that people who are working together for safety reasons can't be prosecuted under a law that was ostensibly written to instead harm people who are benefiting off of sex workers and or trafficking survivors and coercing them. And these two groups are in agreement. There are things that we disagree on, and those are questions that you are all here to work through with us on. But at the end of the day, decriminalization is the policy that will further things like support services being accessible to people, ending over-criminalization of people that should not be criminalized, not overusing law enforcement resources on consenting adults, especially right now during this era of immigration enforcement. Criminalization carries harms like they always have and new harms. I've seen multiple cases in the state of people being investigated as trafficking victims who are now in ICE custody. So these are all things we need to address. I'll pass it on to my colleague.
Thank you. My name is Melissa Bruto. I'm the legal director of Decriminalize Sex Work. I've been an attorney and an advocate for sex workers and survivors for many years, nearly 20 years. I'm also in full support of House Bill 1980, which would fully decriminalize consensual adult sex work. But as you've heard from many of my colleagues, and will undoubtedly hear from many more, I will put that issue to the side, right, in the interest of time. And I want to just talk a little bit about Bill 1683. I echo my colleague in saying that we are working collaboratively to forge a path forward. We all want vacatur and expungement for sex workers and survivors of trafficking. The issue that I take and I wanted to briefly address in the last 45 seconds is the language of prostituted person, right? So Bill 1683 would create a new legal category of a prostituted person. Now, every single state, as well as the federal government, has a trafficking law that delineates what is a victim of human trafficking. We need to have this delineation, right? Both the lawyers and legislators, it is incredibly important that we be specific and we be fact-based when we create legal categories, right? there are specific factors, right? I pioneered vacating law in New York. There's specific factors I had to show for my clients to receive vacatur and to obtain the status of being a victim of trafficking. From an ideological perspective, I promise I'm almost done, the conflation is really problematic, right? Everyone has a different lived experience. And we heard from somebody earlier that said, believe her, believe them, right? And you're gonna hear, you've heard from, and you're gonna hear from more colleagues that say, I'm a consensual sex worker. Believe me, I'm not being trafficked, right? And I urge you to do that. I urge you not to buy into the language of conflation, because sex work and human trafficking are not only two distinct legal phenomenon, they're also two different personal phenomenon for people's lived experiences. Thank you so much.
Thank you very much. Questions?
Any questions?
Just real quick, what other states have decriminalized?
So there are no other states in the U.S.
Okay.
That have decriminalized as of now. Nevada is the only state that doesn't have an overarching criminal code penalizing all of consensual adult sex work. They allow prostitution in small legalized brothels.
Okay. Okay, thank you.
Thank you.
I have Quid in person.
Okay, and we've been here a long time, so I'm just going to riff and keep to my 3 main points and then submit my written after. And you took the words right out my mouth, right? We're hearing in the room today, believe her, believe those accused of witchcraft are innocent, and believe sex workers. So it's very important that I am believed when I say that I did grow up and want to be an erotic laborer. I have been a sex worker my entire adult life. When I was 19 and needed to make rent very fast, so I turned to legal options like a strip club, like an entertainer, like professional sexy party starter, and soon became financially independent and was able to find confidence in my strength and my community. And I've been able to take my experience as a sex worker into my community. And while I am very proud to work alongside or volunteer alongside sex worker and survivor-led organizations, I am here today on my own accord. And I am in full support of the full decriminalization of sex work. And I really want to accentuate that those who orbit a sex worker's life need to also be decriminalized, right? I need to be able to support my family and not fear that my family will face criminalization because of where I'm getting money that has nothing to do with them. And what is the point of decriminalizing if I can't support my family and myself? As well, the expunging of prostitution-related charges. As someone who is pretty close to the ground in adult industry networks, I would argue that expungement and full decriminalization can allow folks to leave the industry if they would like to, more than any other form of governing would, because they would not have these, scary or shameful, alarming charges following them around. And of course, people who are making money that they have to file will be able to file freely and pay taxes and feel comfortable giving those resources back into their communities. And finally, the only person that I want to report, the only bad experience I've ever had in my years of experience, lives in Massachusetts. So I will not feel comfortable reporting until I have full decriminalization. Thank you.
Thank you very much. Travis Wayne. Virtually?
Yes, can you hear me?
Yes.
Right, thank you. So my name is Travis Wayne. I'm speaking in favor of this bill as a worker in Somerville. I didn't get here by choice, so it was through displacement. I've been displaced 4 times in my life personally, and with every displacement, my family and income has been decimated. This is an experience that most people on this body who have a vote have never experienced. But it isn't a novel experience. Many sex workers, including partners and friends and people I love, became sex workers to survive, to stay housed, to stay safe, to maintain access to medication, to not be displaced. And for this, they're literally considered criminals. This is why sex work must be decriminalized, and also why every legislator here who has not faced these conditions, who have not been displaced, will face that judgment. And no matter how many closed doors are decided behind, we'll know. Decriminalize sex work now. Thanks.
Thank you very much. Then we have a panel, Volney Gordon and Henry Bix.
Hello, and thank you for this opportunity to testify. I'm Volney Gordon, co-director of Ishtar Collective, here to support H1980, decriminalizing sex work, which acts as a perpetual punishment and weight on those arrested, fined, and unfairly labeled. We, Ishtar Collective, are a Vermont-based initiative led by sex workers and created as a way to support sex workers who are denied pandemic relief and face constant social, housing, and financial discrimination. Some of our services include quality food access and distribution, relocation and emergency shelter support, access to informed healthcare and mental health services, as well as educational and cultural community-facing events. Like I said, we are sex worker-led and are a testament to what we can accomplish when supported and encouraged to learn, share, and grow. Our work is largely funded and supported by the Vermont Department of Health and the Vermont Community Violence Prevention Initiative, which acknowledges the connection between the criminalization of sex work and the inability to rise above one's circumstances once in the system. Community safety and increasing the quality of life are our primary concerns and always have been. And from my experience, arrest and criminalization only further punishes folks and prevents further barriers to accessing housing, work, banking, and a host of other basic needs, which puts them in an even more vulnerable place than when they started. We work with the People's Health and Wellness Clinic, VT Cares, and many other healthcare providers across our state to ensure that our communities are receiving quality, tailored healthcare, and our providers are receiving the training that they need to better serve our communities. This work only goes so far if the folks face further stigma because of their jobs. We see the effects of criminalization of sex work every day at our food distro and at our offices, with clients unable to legally access housing, or with folks who are still dealing with the fallout of a charge from years ago that lingers and affects their ability to access public assistance in some places, which puts them in a position of permanent instability. We're fortunate enough to have a Department of Health and a state community Department of Health and state community programs that believe in our work and allow us to provide the services we offer. We see the difference it makes when folks are offered humanity and support and the opportunity to learn new skills and hone the ones they have. None of this is possible if we continue to criminalize sex work and sex workers and punish the most vulnerable of our communities. I implore you to consider decriminalization and funding more community support services. Thank you.
Hi, my name is Henry June Binks. I am the co-founder and co-director of the Ishtar Collective. I'm happy to be here with my colleague in the Ishtar Collective and the many folks with lived experiences who do leadership and organizing regionally in the United States who are here to talk about this issue. I'm here obviously to support the advancement of H1980, which would in effect decriminalize adult commercial sexual activity. I am a sex worker, a second-generation survival sex worker, professional poor person. And we've been working for the past 5 years to improve the lives of marginalized working-class people like sex workers, trafficking survivors, and other shadowed stakeholders in the working class through policy and non-carceral direct services. And like many organizations in your state of Massachusetts, we've also been fighting to decriminalize consensual adult sex work in the state of Vermont. You'll find a similar fight in Rhode Island, in Maine, in Massachusetts, stripper bills of rights. In California, in Denver, there was a labor class advancement for dancers led by dancers. What I'm speaking to is the power of community care that adult consensual sex workers actually have, no matter what line of experience they come from. What we have is a response to a deepening working class crisis where people are being targeted on a broader spectrum, and sex workers leading food drives, holiday meal drives, opening up pop-up clinics for safe STI testing, doing policy training, doing face-to-face work, police liaisoning. Those people are in this room today asking for basic human rights. They work, they pay taxes. They are filed under 1099 private contractors, and yet none of these benefits do we see. None. Not legal protection, not fair self-representation under the eye of the law, not fair custody encounters when our children and our families are put into the sway of the conversation and our work is weaponized against us. The only way to discern exploitation from consent is to put survivors and consensual adult sex workers in the same room for self-representation. We're building that collaborative relationship with some folks you'll hear from now. It might not be all the way, but we are very excited to work together with them, and we hope that you work with us.
Thank you.
Thank you.
Thank you. Any questions? We have a question.
Sorry.
Would you like to stick around?
Leave yet. Brother, don't leave yet. Thank you.
Got a question.
So I've been interested in this work on decrimming sex work and drugs due to the fact that I represented, when I was in the House before I got to the Senate, Roxbury and Dorchester, and there was some organizing from workers in that community to not only educate me, but to educate the community about the differences between consensual and non-consensual, and folks were getting arrested and going to jail. The question I have, it's been a little sticky up here around essentially bridging two groups and two different philosophies. And I just asked one question around, what do you think is really holding us back here in the Commonwealth? I know there's a lot of Puritan values here, so that might be it, I don't know. But what's holding us back in kind of bringing those two groups together, but also getting to a point where we might be able to bring this to the finish line?
I think number one, the fact that this is kind of hyperfixated on as a sexualized issue when it's a labor issue and a safety issue is what hangs everybody up on this. I think that if we speak about sex work under the scope of safety, humanity, and labor conditions, working conditions, those are things that most working class folks can identify, right? With, get around. Like in most conversations that I'm having with people, I try to meet them with where they're at. You know what I mean? You got anything to say on that?
No, I would just agree with you. I feel like they are very general working class issues. I think when folks remove themselves from whatever moral issues they may have with sex work as a labor field, it's pretty simple. I think I'm always comparing it to McDonald's, working at McDonald's and the exploitation that goes on in those conditions. Not everybody chooses to or wants to be a chef. Nobody that works at McDonald's, a lot of people do it because it's accessible work and it pays the bills. And I feel like that is the case for some people who in sex work, and in some cases, some folks love doing it.
Yeah,
and I think that's fine too. I think both are acceptable, and I think just seeing us as part of the community is the first step to getting.
Thank you.
Thank you very much. Thank you. Okay, so now we're going to the folks who were here and we missed, and we're going through them. We have another at least 20 to 30 people. So we're going to be very strict on the time. Once 2 minutes hits, we're moving on. So is Mandira Pant here? Is she online?
Can you hear me?
Yes.
Can you see me? All right. Thank you. Thank you for the opportunity. Dear Chair Edwards, Chair Day, and distinguished members of the committee. I'm a senior technical leader in the semiconductor industry, and my career is a testament to the power of effective guardrails. In a field that is historically male-dominated, my success was not guaranteed. It was secured by clear systemic policies, written procedures, accountability metrics, and a mandated focus on merit that actively prevented discrimination from dictating outcomes. These guardrails didn't hinder our industry. They made it stronger, more innovative, and more competitive by ensuring we didn't overlook a single talent. I'm here today because our state's venture capital ecosystem desperately needs the same kind of, let's call it, intelligent design. I urge you to issue a favorable report on H1922 and S1119, the Fair Investment Act. The data speaks to a catastrophic system failure. Women and minorities start over 50% of new businesses, but receive a minuscule 0.6% of venture capital. We're not just talking about fairness, we're talking about a massive economic opportunity being squandered. This bill provides the precise structural fix we need. It establishes Chapter 151G to create fair investment practices, requiring professional investors to implement written policies and conduct regular self-evaluations to ensure equitable funding. This is not a punitive measure, it is a performance-enhancing one. It brings the transparency and accountability that we rely on in every other sophisticated sector to the critical task of funding our state's future. We have the proven blueprint on how guardrails unlock potential. My career is living proof. Let's apply that blueprint to our economy, and please do give this bill a favorable report.
Thank you very much. Nithya Bandranath, also virtually.
Good afternoon.
Good afternoon.
Good afternoon, Chairs Edwards and Day, and honorable members of the Joint Committee on Judiciary. My name is Nithya Badrinath, and I'm here to testify in support of the needs of the most vulnerable immigrants in the Commonwealth, survivors of domestic violence, sexual assault, and human trafficking, and their children. I'm the Policy Director at Jane Doe, Inc., the State Coalition Against Sexual Assault and Domestic Violence. Our 65 community-based member programs provide direct services to sexual and domestic violence survivors throughout Massachusetts. Our state must pass the Dignity Not Deportations Act, or H-1588 and S-1222. Federal immigration enforcement has been terrorizing our communities, using facilities in our state to strengthen the deportation and detention machine. Anti-immigrant rhetoric has moved, even in the Commonwealth, towards a level of dehumanization that should chill us all. Survivors and their families are under attack, and the reality is that these survivors face violence in their homes and then violence when trying to get help. We have heard from our JDI member programs that advocates have been losing contact with immigrant clients who have presumably been detained or kidnapped by ICE. Programs have also been reporting that fewer immigrant clients have been accessing their services, foregoing in-person visits that can be so life-affirming for survivors and sometimes dropping out of contact altogether. Harm doers are threatening to report a person's undocumented status if they try to speak up about being sexually assaulted on the job or abused by a partner. The messages we hear in our communities separate survivors from resources that can help while cultivating a climate of dangerous silence. Massachusetts cannot and should not participate in the federal government's attacks on our communities. By eliminating detention space available to ICE in the state and local facilities, this bill will limit Massachusetts' role in mass deportations. The Dignity Not Deportations Act will restore fundamental safety protections for all residents. Immigrant survivors of sexual and domestic violence deserve access to health and safety without any fear of accessing life-giving services, deportation, or detention. On behalf of JDI and our member programs, I urge you to report H-1588 S-1222 favorably and support the priorities of the Protecting Massachusetts Communities Coalition. Thank you so much for your consideration.
Thank you. Grace Ross.
Thank you, members of the committee, chairs. Been a busy day. I am speaking in support of H4115 and also Chairman Day's bill. I think that's 1635, House 4684 and Senate 1122. But mostly I'm before you because, and I will leave the committee with copies, but we already as a state have stood strong when people were being taken out of our state illegally and for unconstitutional purposes. We have a strong history as an abolitionist state, and because of that, we often think of states' rights being southern states fighting desegregation, but the northern states stood up first for the black members of our communities to not let them be taken to slave states. And actually, 3 years into the existence of our Constitution, the first Chief Judge of the Massachusetts Supreme Judicial Court said that our Constitution does not allow the loss of liberty on the basis of African blood or color, complexion, or feature, what we would call race. And that was codified in the our Bill of Rights, Article 1 now says that liberty cannot be denied or abridged on the basis of sex, color, race, creed, or nation of origin. And that means we have more protections for the members of our communities than the federal Constitution gives us. And when the people of Massachusetts stood up in the abolitionist movement, we actually got a law, the Wisconsin version of which made it all the way up to the US Supreme Court. That habeas law is still on our books, and it says that we have a right to demand any federal agent who takes somebody in state court, we can go and ask for a habeas petition. It does not allow us to get the person brought, but it does allow us to demand the warrant, and we are being lied to that we can't demand them.
Thank you.
So I will leave the law from 1855. You can see what has already got constitutionality in our state.
Thank you.
Let's make this happen. Thank you.
Asia Jackson.
Good afternoon, Chair Edwards, Day, and members of the Joint Committee. My name is Asia Jackson, a proud American freeman on both mother and father's side, a lineage that survived everything Massachusetts has thrown at us. My ancestors were enslaved, my grandparents were locked out of home ownership, my parents were denied economic mobility, and the aftermath is me. Underfunded housing, underfunded resource schools, over-policed communities, both my grandfathers, black men in this country that never loved them, put on a uniform and fought for this nation. So when does this nation finally fight for us? So when? Now. Massachusetts profited from slavery in billion-dollar ways, turning stolen black labor into generational wealth through ships, banks, rum, cotton mills, and insurance policies on enslaved bodies. Industries powered by my ancestors who never saw a dime of the billions they created. The harm is measurable. Black families hold only $8 net worth, compared to $247,000 for white families. That's not coincidence, that's policy, and policy must be repaired. My family paid cash for a home because banks wouldn't lend to black families. Redlining crushed its values. My relatives were forced to sell, and this lineage matters. American freemen endured the direct harms of slavery, Jim Crow, redlining, and state-sanctioned exclusions in Massachusetts. S.1181, H.1753, H.1696, and H.4351 are not symbolic, they are the spark. Commissions that will name the harm, count the costs, and create real solutions with real deadlines led by American freemen. Massachusetts was one of the first to profit from enslavement. Let it be the first to repair it. Thank you.
Thank you very much. Palma McLaughlin. Is Palma here?
Hi, I apologize for the camera problem. My name is Palma McLaughlin, and I'm actually testifying in opposition to Senate 111 and 1753. In 2006, the federal courts dismissed a reparation suit against companies including Fleet and Aetna, citing a lack of clear linkage between these successor companies and their slavery-involved antecedents. Without the courts, it's left to the legislature. But if the courts couldn't find sufficient clear linkage, it is difficult to see how to find a clear linkage to the 97% of our population who arrived after the end of slavery. In short, the final goal of this bill is a bill of attainder, which is unconstitutional. The diversion of resources from the 97% of them, some of them who truly need those resources, making the 97% pay. And that is without consideration of intervening countervailing historical events. Beginning with when the Commonwealth actually came into existence. In his papers, John Adams noted there were so many successful individual freedom suits that lawyers for slave owners stopped showing up. It is inconceivable that Adams did not have this in mind when he drafted the 1780 Constitution that led to the Elizabeth Freeman and Quock Walker suits. The first reparations ever paid in this country were in the Commonwealth. It was signed by Governor John Hancock in 1781. So now we actually start talking about double dipping. Hancock later held the Equality Ball to celebrate the end of slavery in the Commonwealth. I did mention the 1855 Personal Liberty Act, which is similar to the Safe Communities bills that should pay. There is also the fact that the Salem native former Speaker of the Massachusetts House, Joseph Story, attempted to end slave trade completely, including working with Lord Stovall, the English jurist. Finally, in May of 1857, this body actually produced the report that tells you pretty much everything you need to know when it created a law that required the Commonwealth
Thank you very much.
to.
If you would
All
just
right, I will
submit the rest
submit.
of your testimony in writing, and the entire committee will receive it. Thank you.
Thank you.
Steve Ico, or I have a Steph, ICO. Couldn't read the handwriting so well. Signed up. It's just on an act ensuring access to equitable representation in immigrant proceedings. Okay. Todd O'Berger from Immigration Working Group of Lexington, an act ensuring access to equitable. Okay. Jose Urias, Mass TPS Committee. Also, okay. Lisa Capra, the Episcopal City Mission, an act relative to immigration detention. Mary Beth Sack-Cremoni from CASA, an act relative to immigration detention and collaboration. Excellent.
Thank you, everyone, for being here this long and seemingly without a lot of bathroom breaks. I'm Mary Beth Sack-Cremoni, and I'm here on behalf of my immigrant neighbors and the CASA Metro Worker Center to support the bills related to immigration. I've spent 33 years career as a public school educator, protecting and supporting kids and families as a school counselor. I'm keenly aware of the trauma endured by immigrants as well as people of color. Never did I think in my retirement I would be protecting children and families from masked men coming to abduct them, detain and deport them. Due to all of this, my retirement days now look like this. Driving kids of color, not just immigrants, but anyone with dark skin due to racial profiling. Driving them to school because their family members are too fearful to get them to school on their own. Driving children, young adults, and senior citizens who are immigrants who've been here legally for many years, taking them to doctor's appointments, grocery stores, pharmacies, and church for fear of being abducted and detained. Standing out in front of ICE facilities and bearing witness for people whose families are being torn apart due to illegal ICE raids, and then watching them get driven away illegally in a van with a cage in the back as if they were animals. Delivering food and stocking food pantries for families whose fathers and mothers or siblings have been detained and they have no idea how they will get by because they don't know where they are. Helping a family who literally had to escape from their country of origin to find safety in the Metro West area, thanks to a faith community. The mom of this family was raped and trafficked in her country, but through incredible strength and resilience somehow survived and came here with her 2 children to what they thought was the safety of the United States. Mm-hmm. They then were told by our president that their home country is on the list of countries that are no longer welcome here. This family now lives in a homeless shelter rather than being surrounded by their local faith community because they are required to wait for legal proceedings as asylum seekers. Imagine being 6 years old, 7 years old, watching your mom survive the horrific trauma endured in their home country, then being able to escape to the quote-unquote safety of the melting pot of the United States, but then being told, sorry, you can't stay, you're no longer welcome here, and you actually are illegal now. It's extremely clear to me that our immigrant children and families and even any person of color need our help in so many ways. These laws can only help our immigrant neighbors and all help of color feel safer and more welcome here. Please protect all our immigrant and our brown-skinned neighbors as best you can. Thank you.
Thank you very much. Jocelyn Fimbres, Celine Vences, and Stephanie Grady. It's a panel, so 5 minutes.
Thank you, Chair Edwards, Chair Day, and members of the Joint Committee on the Judiciary. My name is Jocelyn Fimbres, and I am a doctoral candidate at the Boston University School of Public Health, accompanied by Dr. Stephanie Grady, a postdoctoral associate, and Selena Vences Brown, a doctoral student. The field of public health has accepted that non-physical stressors, like the stress of a traumatic event, can lead to severely negative health implication. And as we have seen since January 2025, there have been unprecedented increases in workplace and community raids with enforcement activities targeting and harassing undocumented and documented immigrants. These raids and subsequent holdings in detention centers are increasing the risk for the health of our neighbors. Therefore, we are testifying today in strong support of Bill H-1588. In January 2025, ICE began operating in previously protected locations, including places of worship, schools, and healthcare facilities. The fear of ICE operations in healthcare facilities has led to skipped appointments, including vaccinations, urgent health needs such as gunshot wounds, and unchecked progression of chronic diseases. Children's health is especially vulnerable. A pediatrician told New York Times that no-show pediatric appointments had increased 30%. Similarly, a clinic in Chicago reported that 30% of their patients canceled or did not show up for their appointments after ICE raids began in January. One epidemiology study found that infants born to non-U.S. born mothers had significantly lower birth weights after a series of raids began, with low birth weight being an indicator of poor overall health in infants. Other studies have found immigration enforcement and arrest are harmful to students' school retention, remaining on their grade track and test scores, and they're likely to experience depression, anxiety, and behavioral problems. We can also look to educational disruptions from COVID to see how harmful widespread reductions in school attendance has been for the entire population of students.
Since January 2025, there's been an unprecedented increase in workplace and community raids, with enforcement activities targeting and harassing undocumented and documented immigrants. During this time, raids have led to over 200,000 arrests and 61,000 holdings of immigrants, many of whom do not have a criminal record or are United States citizens. Currently, over 90% of detainees are held in privately operated facilities, which present challenges in implementing federal health and safety standards. This vast increase in detainees in detention centers is of incredible concern, as it coincides with extreme lack of reporting on healthcare utilization and health outcomes within these centers. Detention presents a staggering threat to health. Detainees have reported experiencing exposure to poor sanitation, extreme temperatures, and poor ventilation. These aspects and other present environmental challenges which highly increase risk of adverse health outcomes. Given close quarters, increased likelihood of immune suppression in high-stress situations and constraints on personal hygiene practices or supplies, carceral facilities also represent a high-risk environment for the spread of infectious diseases. Not only can diseases, especially respiratory pathogens, spread quickly through detained populations, but carceral facilities, as well as established as institutional amplifiers, which may amplify the spread of infectious outbreaks in the communities surrounding facilities through exposed workers entering outer communities. This year, 20 deaths have occurred in ICE custody. As number of detention centers rise and oversight is minimized, the conditions in these centers will continue to worsen.
In addition to a host of significant social and cultural contributions immigrants have made across Massachusetts, immigrants are also a vital to our economic state and well-being. Immigration detention centers are a threat to that vitality and economic well-being. Immigration detention centers and deportations result in economic instability and harm for families and communities. A 2015 report published by the UCLA's Institute for Research on Labor and Employment estimated detaining 562 immigrants in California for more than 6 months cost approximately $12 million and resulted in significant financial instability for the families of detained individuals.
During detention, 64% of families detained individuals had a difficulty paying rent. 42% were unable to pay for necessities such as medical needs or medical care, and 37% were unable to pay for food. Just 3 key takeaways in support of H 1588. Terminating and not signing new agreements will build trust in communities. It will also reallocate state funds to more pressing public health and safety issues and keeps sources locally. And it protects families from further being criminalized. Thank you.
Thank you. Thank you for your testimony. Okay, up next we have H 1963, an act of strengthening justice and support for sex trade survivors, Audra Duty and Delia Vega. Delia Vega. This will be one panel.
Saving the best for last night.
I know. Hi.
Good afternoon. My name is Audra Duty. I am the co-executive director of Safe Exit Initiative in Worcester, but more importantly, I stand before you as a survivor of human trafficking and prostitution. Today, I'm here in support of Senate Bill 1116, which seeks to provide critical criminal record relief for individuals affected by trafficking, regardless of whether they are involved in the sex trade or have exited it. For many survivors, a criminal record is more than just legal obstacles. It is a barrier to rebuilding our life. My own personal history includes convictions stemming from exploitation, and these records have significantly hindered my opportunities for stable employment, safe housing, and a chance to regain custody of my son. Senate Bill 116 recognizes that everyone deserves the chance to move forward, free from the stigma of the past they may not have chosen. Whether someone is still navigating the complexities of the sex trade or has bravely exited the life, the need for relief from the repercussions of their past is universal. This legislation seeks to repeal archaic offenses such as common night walking and street walking, laws that punished exploited individuals rather than offering them protections. Many survivors I work with carry these convictions, which subject them to discrimination and further trauma. Repealing these charges and instituting expungement is long overdue. Additionally, this bill enhances and broadens the vacatur process, allowing more survivors to clear convictions tied to their exploitation. This bill also establishes an interagency special commission. Currently, access to trauma-informed services, housing, legal assistance, and exit strategies are difficult to access with many barriers for services. A coordinated statewide approach, which is what we've been doing with the Governor's Human Trafficking Task Force, will enable survivors to receive consistent and supportive care. I want to acknowledge that we have been here before with a different variation of this bill. We listened carefully to the concerns of the opposition and law enforcement, and as a result, we made significant changes to be more inclusive. We have engaged in meaningful conversations with the Boston Sex Workers and Allies Collective to strengthen the bill's provisions. I encourage open dialogue where all voices can come together to address these complex issues. I believe we can find a common ground that upholds public safety while fully addressing the needs of survivors. By supporting this bill, you are not only empowering survivors like myself, but also fostering an inclusive approach that believes in the potential for change in all individuals. Together, we can work towards a future where everyone has the chance to rebuild their life, free from the burdens of their past. Thank you for your time and consideration, and I look forward to working together to advocate for the rights and healing of all survivors in Massachusetts.
Hi, everyone. Thank you. My name is Delia Vega. I am a, this just shifted. So I'm the Policy and Community Relations Manager with My Life, My Choice. And so those of you who don't know what My Life, My Choice is an organization we work with. I know Senator Edwards, you know, you're familiar with My Life, My Choice, but for those that are not, first of all, I want to also thank you all. But for those who are not familiar with that, with who we are people who work with young people who have been sexually exploited or at risk for sexual exploitation. And not only do we provide direct service, we also provide, wraparound services like case management. We direct them to therapy if they need it, and so on and so forth. We also provide training for folks who work directly with young people as well to identify CSEC, which is the commercial exploitation of children. And so I'm here to share with you why this bill matters. For some of us by the way, I'm also a survivor of exploitation, and so I'm here to share with you why this bill matters. For some of us, being in the life is a strategy for survival, a way to meet basic needs when there are no other options. For others, it is deeply exploitive. a coercive environment that we are forced into. And then there are those of us who have since left the trade and are working to rebuild our lives. Too often, the law does not distinguish between these experiences. Charges like common street walking and common night walking lump all of us under criminal labels without recognizing the complexity of our stories. This bill changes that by removing those offenses, mandated expungement, and broadening access to vacatur. It offers a path forward, not just for those who have exited, but also for those who remain in the trade today and deserve a more supportive future. And why the commission is so critical. I strongly support the creation of the Interagency Commission that includes people with lived experience, whether currently in the life or have left it. We know what the real gaps are in services, what exit programs must look like, and how prevention must be informed by the very people who walk this path. So today I ask you, respectfully, to please vote favorably out of committee. Thank you so much for your time.
Thank you so much. Well, you'll send over your written testimony in full. Thank you.
Thanks.
Same bill, Yvette Monge and Alex Powell, RIA and Safe Exit Initiative.
Hi, good afternoon. I'm chairperson and members of the committee. My name is Yvette Monge, and I am a survivor and outreach manager for RIA. I work directly with individuals impacted by the sex trade across Massachusetts. Every day I meet women trying to rebuild their lives, yet they are held back by criminal records from their time in the sex trade. These records follow them everywhere: housing, jobs, education, and keep them trapped in a past they never choose. I know this personally. When I left the sex trade, every background check forced me to relieve trauma I was trying to heal from. No one should have to carry that burden. H1683 is a survivor-centered solution. It repeats outdated offenses like common night walking and street walking, strengthens and expands vacatur, and ensures automatic expungement so that those live with and living experience can truly move forward. It also creates a statewide commission to provide consistent trauma-informed support. This bill shifts accountability off those who lived and live in experience and onto the systems and exploiters responsible for the harm. On behalf of those I serve, and as someone who lived, I urge you to pass this bill. Those with lived and living experience, regardless of their experiences, deserve justice, support, and a real chance to rebuild their lives. Thank you.
Good afternoon, and thank you, Chair Edwards, Chair Day, and members of the Judiciary Committee. My name is Alex Powell. I use easier pronouns. I'm a person with lived experience in the sex trade. I'm also non-binary, gender fluid, a person with disabilities and long-term recovery, and I'm here to testify in favor of H1683, S1175. This bill accomplishes three things: removes common night walking and street walking, expands on the 2018 vacatur bill to reduce barriers to access and automatically expunge vacated records resulting from lived and living experience in the sex trade, and it also establishes a coalition to assess and expand services across the state. So despite the same name as our last bill session, this is not the same bill. It is not a partial decriminalization bill. That being said, those with lived and living experience should not be penalized for their victimization and or survival. Vacatur is a difficult process to access, and our legal systems are re-traumatizing for many of the folks that we support. Core records from the sex trade also contribute to homelessness, unemployment, further stigma and alienation, and vulnerability to violence. Marginalized individuals, including those involved in the sex trade, and particularly BIPOC, trans, disabled, immigrant, and homeless persons in the sex trade, are unjustly targeted by our court and carceral systems. Increasing access to vacatur and expungement is an important step in restoration for these harms. This is also a critical safety matter for anyone currently or previously involved in the sex trade or attempting to exit. For similar reasons, I also support Bill 1893. There is a strong need to expand services for anyone who is actively exchanging or has previously exchanged sex, regardless of their situation and self-identification, whether they identify as a trafficking victim, a sex worker, a survivor, or don't ascribe to any labels. We need safe housing and sustainable wages. We need more treatment beds. We need alternative education and treatment options that are culturally specific. We need a 24-hour statewide hotline and imminent options for respite and safety, not a 2-year wait list. We need to decolonize systems, increase access to resources, and build more inclusive community. We need to approach legal proceedings from a restorative justice lens. We need more services across the state and in areas where services are currently overwhelmed, and services to fill the gaps in Lowell, Lawrence, Franklin, Whitensville, Fall River, New Bedford, and the Berkshires, just to name a few. We need more emergency resources past the exiting and trafficking prevention education. Individuals are dying in the sex trade at aberrant rates, and we need to do more. Please support H1683 and H1893 favorably. Thank you.
Thank you very much for your time. Laura Duncan on 1980, an act to promote health and safety people in the sex trade. Laura Duncan. Okay.
Well, I'm here.
Okay.
Can you hear me okay?
Yes.
Okay, thank you. My name is Dr. Laura Duncan. I'm a medical doctor and researcher. I live and work in Massachusetts. So I'm here to show my individual support for H1980. For over a decade, I've been involved in healthcare for those working in the sex trades. This includes multiple years working at St. James Infirmary. This is the nation's only occupational health clinic for sex workers. So I'm speaking with the honor of having heard the stories of many, many people who work in the sex trades. I've also studied the medical and public health data. It's clear to me that a profound threat to the health and safety of those in the sex trades is criminalization. Criminalization and the lack of expungement of past records causes harm in a myriad of ways. It promotes stigma and social isolation. It drives this work underground and leaves those involved with less safety and autonomy. It also prevents people from reporting crimes against them and closes down avenues for them trying to leave coercive circumstances. Lastly, I'd like to share a visual that maybe not many people have witnessed, and being in the medical field is something that I've seen, unfortunately, more than once. What happens after such an arrest? Recently, a patient arrested on what was called, quote, prostitution-related charges came to my hospital needing inpatient medical care. Due to the requirements of her custody, she was chained to a hospital bed 24 hours a day. 2 male officers were consistently at her bedside, only feet from her body, and she required permission for the smallest tasks, sitting up in a chair, going to the bathroom. No request by myself or hospital staff to change these requirements of her custody went through. None of this experience provided healing, support, or rehabilitation for her. They only created punishment and trauma. So I believe we're all here because we care about the dignity and bodily autonomy and freedom from coercion for all Massachusetts residents. In witnessing the result of sex work-related arrests in my work as a physician, it's never more clear that blanket criminalization and a lack of criminal expungement is antithetical to this goal. I urge you to support H1980. Thank you very much for your time.
Thank you so much. Jessica Van Meer, Boston Sex Workers Alliance. This is an act to promote and the health and safety of people in the sex trade. Go ahead. You want to unmute yourself? She might have technical. We're just going to continue. We will come back to you. Michaela Burnberry, an act establishing a commission to study reparations in Massachusetts.
Hello, chairs and Judiciary Committee. Thank you for giving me the opportunity to speak. I first wanted to quickly clear up a misconception that there was double dipping in reparations. John Hancock did not offer reparations in a modern sense. He offered a pension to one man who had been enslaved, and that's what that is. So, again, thank you. I am here for bills H1753 and S1181, which seek to form a commission for the study of reparations for slavery in Massachusetts. My name is Mikala Bembury. I am an American descendant of slavery from Framingham, Massachusetts. I've been doing my family genealogy, and I always knew that, that my ancestors came up in the Great Migration. Sometime between 1890 and 1950 is when people trickled into Massachusetts. And I even found one of my ancestors, the owners, who was raised in Sherburne, Massachusetts. But it wasn't until last year, after testifying on these bills last year, that I completed more genealogy and covered my fifth great-grandfather, Fortune Howard. He was owned by Isaac Royal in Medford. Isaac Royal was a loyalist and ran back to England in 1775, 3 days before the Battle of Lexington. It is at that point, I think, that Fortune escaped to Boston and began a whole new life. Unfortunately, Fortune died before, in 1880, before the legal end of slavery in Massachusetts, but he started a lineage that continues on in Massachusetts to this very day. Although slavery in Massachusetts was abolished in 1783.
Well, thank you. I'm sorry that
That's okay.
the time, but we
Thank
will,
you for the opportunity.
And this testimony seems incredible, so please email it to, you can take pictures of it and send it to the
Absolutely.
committee. It sounds like an
I'll
incredible
type it up.
lineage. I'd love to learn
Thank
more. Arrington Chambliss, on an act establishing a commission to study reparations in Massachusetts.
Thanks so much. Good afternoon, Chair Edwards, Chair Day, and distinguished committee. My name is Arrington Chambliss, and I'm an Episcopal priest and the Executive Director of Episcopal City Mission, a leader within the Reparations Interfaith Coalition, and a supporter of the Mass Black Reparations Collective. I'm here today to speak in support of S.1181, H.1753, an act establishing a commission to study reparations in Massachusetts, and also would like to voice my support for the bills known as Dignity Not Deportations, S.1122, H.1588, and the Immigrant Legal Defense Fund, S.1127 and H.1954. As a Christian and a follower of Jesus, I'm here out of deep moral and faith conviction that the healing of the soul of this Commonwealth and our nation requires truth-telling, apology, repair for the significant role in the transatlantic slave trade and ongoing impact of slavery and systemic discrimination to African Americans, Afro-Caribbean folks, and indigenous people who are our siblings and neighbors. And I'm not here alone. Episcopal City Mission is a statewide organization with thousands of engaged Episcopalians and delegate members from the suburbs, from rural areas, from urban areas across the state. Possibly more of those folks, well, not possibly, definitely more of those folks are white Christian Americans. And we have been complicit in our organizations. My organization is 181 years old, and we are doing reparations organizationally. And so our church is finally fully facing this legacy, because we know that it's going to strengthen our relationships and strengthen our commitment to our faith. For our 237th annual convention, we made a historic vote to approve the creation of an Episcopal diocesan reparations. Yeah. Okay.
I know.
Well, I will submit it online if that's
Please,
okay.
please
Okay.
do.
Well, thank you for letting me speak, and next time I'll practice so I get within 2 minutes.
Thank you very
all for
much.
being here.
Thank you. Catherine Quinlan, an act establishing commission to study reparations.
Okay. Good afternoon. Good for you for all staying for so long. Thank you so much for listening to everybody today. Okay, so my name's Catherine Quinlan. I live in Concord now, but I come from Montreal originally. I lived in an all-white world until I drove a school bus in busing in 1976 through 1986, and it kind of changed my life. I know that I had a bunch of changes in my life, and I bolted out. So anyway, let me get to the point of this reparations thing. It can become easy to erase a culture Most notably today, it happens when many people are engaged in other events, causes, pressures, even opportunities. With so many changes in modern world mobility of people, next generations can bring complexity and confused images of prior and enduring heroic people who scrambled through adversity, too easily dismissed by people not directly involved. I come from Montreal, Quebec, Canada, and I remember when French Canadians noted that their culture risked being erased and their language was declining. In the English-led working environment, English language and customs were preserved, used in many Anglo sources because the transactions between Quebec, where the population was 90% French, and the rest of Canada, which is more English, and then also with the United States and with the original and remaining ties to Britain, everything happened in English. The busy English took the French culture and history for granted, carried on their own goals, and French Canadians felt disappointed and angry that the English seemed to have so little interest in learning about their unique history, culture, and people. Their protests were amplified, however, because they had leverage. Since most French Canadians lived in Quebec, a sizable, distinct province in its own right, the French could tell the rest of Canada that they would leave and start their own country, yet the English had so little interest and respect in learning more about French Canadian history.
Yep.
It's like, oh my God, like another paragraph or whatever. I don't know. Only. So the basic point is, Black Americans didn't have that leverage.
Okay.
Okay, and it's worth studying because erasure is a big deal.
Yes. Thank you very much. You can email that to us.
Thank you.
Thank you. Margaret Carey. Margaret, online maybe? No? Okay. Chelsea Hall. Chelsea Hall, an act promoting body size discrimination. Not here. Okay. And then just going back to Jessica, we had technical difficulties. Jessica Van Meer.
Hello, can you hear me?
Yes.
Wonderful. Hello, my name is Jessica Van Meer, and I'm a PhD candidate in public policy at the Harvard Kennedy School of Government. I've been doing research on sex work and sex trafficking for 12 years, including interviewing over 250 sex workers and sex trafficking survivors across 5 countries. I'm also the policy chair of the Boston Sex Workers and Allies Collective. I'm here to testify in support of H.1980, which would decriminalize independent adult sex work while strengthening our anti-trafficking laws and leaving laws against profiting off a sex worker on the books. Again, to be clear, this bill does not decriminalize brothels. It only decriminalizes self-employed sex work. Although evidence shows that criminalization of sex businesses also harms sex workers, we understand the state may not be ready for this. We are proposing solely to repeal the crime of sex for fee as a modest and practical first step towards sex workers' safety. After New Zealand decriminalized sex work in 2003, a report which surveyed 772 sex workers found they felt safer, more able to choose their clients, and were more likely to report a bad incident to the police. A meta-analysis of 134 studies in over 30 countries by researchers at the London School of Hygiene and Tropical Medicine found that all forms of sex work criminalization, including criminalization of their clients, are associated with greater risks of violence and greater risk of STIs. Decriminalization will also make reporting and preventing sex trafficking easier. Sex workers and their clients are those who are most likely to witness cases of sex trafficking, but when buying or selling sex is criminalized, they cannot report trafficking without fear of being arrested themselves. Here in Massachusetts, we're aware of a predator in our community who has targeted dozens of sex workers in our state. None of the victims have felt safe reporting him to law enforcement because they fear being arrested themselves. I'm also here to testify in partial opposition and partial support to S.1176. I strongly support the bill's intent to expand criminal vacatur and eliminate the crime of common night walking, and appreciate the bill's proponents' recent efforts to solicit our feedback. However, I strongly oppose the bill's introduction of the stigmatizing term prostituted person, and also oppose the bill's expansion of asset forfeiture to sex workers' clients, which would economically devastate families and communities. Thank you.
Thank you very much. Is there anyone here who has not testified, wanted to testify, did sign up? Yeah. Okay. Let's go.
Chair Edwards, Chair Day, and members of the committee, thank you for the opportunity to testify today. My name is Anna Ardeline, and I am here in strong support of H 1919 and S 1249, which would ban discrimination based on body size. Like many others, I came to Massachusetts for its world-class higher education. During my Master of Public Policy program at Brandeis University, I focused on weight discrimination policy, and I even wrote my thesis on this exact bill. During my research on existing weight discrimination laws, I noticed two main concerns from those in opposition that I would like to address today. So first, some believe that banning height and weight discrimination would require a complete rebuilding of all of our society. However, as we saw with the passage of the ADA, that is simply not the case. This law would not require every space to be retrofitted to fit larger people, but it would empower individuals to seek reasonable accommodations when necessary. The second main concern is about the cost of implementation. What alleviates this concern in Massachusetts specifically is that the Massachusetts Commission Against Discrimination is organized by area of discrimination, such as housing or employment, not type of protected class, such as race or gender. This means that MCAD would not have to hire an expert on this type of discrimination specifically. They can use their existing system and just add to the list of protected classes. There's no need to reinvent the wheel there. So I'd like to finish on a more personal note. While I was conducting this research as a student, I faced this issue on my campus. I needed to request accommodation because of my size. While they were definitely sympathetic, they said they couldn't help without a documented disability. My experience didn't qualify, even though the campus environment was effectively disabling to me and my body, and my experience was very different from that of my thinner peers. Now, as a Massachusetts resident, I am excited to see how my new home does what it has always done, be a shining example of progress and equity to the rest of the country. Thank you so much for your time, and I would be more than happy to share the rest of my research with you if that would be helpful.
It will be. Thank you very much. Thank you. Questions? All right. Thank you all very much for your testimony. I will officially close out this hearing.